Morning, everyone. Good morning, everyone. Thank you so much for being here. I'm Katie Glenn Bass. I am the research director at the Knight First Amendment Institute. We're really excited about this program and we're excited to have you all with us. I just have a few housekeeping notes before we begin our formal program. The first is if you need the Wi-Fi, it's Riverside Guest, and the password is password, all in lowercase. Bathrooms, there's one on this level to the left as you walk out there, and then there are more bathrooms one level down in the elevators. I also just want to explain something about the way we do audience questions here. We have two options for you. You'll see behind you on the screen a QR code that you can scan to enter a question via a Google form, and then the moderator will get it at an iPad. You can ask those questions at any point during the conversation, and the moderator can try to work them in as the panelists are discussing. And then later in the discussion, the moderator will invite people to come up to a standing mic in the room if you'd prefer to ask your question that way towards the end of the discussion. And with that, I'm going to welcome the Executive Director of the Knight Institute, Jamil Jaffer, to the stage to give some opening remarks. Thank you.
Hi, everybody. Thank you for being here. I'm Jamil Jaffer. I'm the director of the Knight Institute. Welcome to the Knight Institute's symposium, Regardless of Frontiers. And to those of you who were at the photo exhibit last night, welcome back. So the Knight Institute focuses on issues at the intersection of free speech and new technology. The concern of this particular symposium is on the role that international borders play in regulating, distorting, or suppressing the free exchange of information and ideas. Of course, borders have always been sites of censorship and surveillance. Detentions and interrogations and searches at the border are nothing new. But as a result of advancing technologies that are both fortifying and blurring national frontiers, the relationship between borders and the exchange of information has changed. 50 years ago, censorship at the border typically entailed a customs official destroying a shipment of Cuban books or denying a visa to a Belgian Marxist. Versions of those things still happen, but censorship now comes in many other forms as well. US border agents search the laptops and cell phones of journalists, human rights advocates, and others returning from abroad. Visa applicants are required to register their social media handles with the State Department if they want to visit the United States, handing the US government an easy avenue for surveillance of their expressive and associational activities. The Treasury Department bars Americans from speaking and associating with foreigners whom the US government has sanctioned. Congress bars Americans from accessing Chinese social media platforms. And immigrants in the United States sometimes suffer official retaliation for their expressive activities, both online and off. In the United States, and in many other democracies as well, foreign speech from abroad, is increasingly viewed as a threat. And yet, even as the international border is used as an occasion for new forms of surveillance and suppression, the border's value as a shield seems to have eroded dramatically. It was once possible for dissidents persecuted by authoritarian regimes to take refuge in liberal democracies. Today, we see those rights-abusing regimes brazenly reaching across national frontiers to intimidate and even eliminate perceived political enemies, including those living in open societies. An industry of spyware manufacturers provides tools that facilitate these transnational attacks. In many ways, the law is struggling to keep up with these digital age threats and challenges. International human rights law protects the exchange of ideas regardless of frontiers, and the First Amendment has been understood to provide that protection too. But there are many unresolved questions about the meaning and scope of that protection, particularly in relation to new technologies that guard and test national borders. It's these questions that we'll be engaging with over the course of the day. Before I turn this over to Professor Mukherjee, I want to thank just a few people. First, it's an immense privilege for us to have this group of advocates and researchers and scholars with us today. So thank you to all the symposium participants, and particularly to those who contributed papers. This project gave some of us at the Knight Institute the chance to work with Dugan Meyer, Coulter Thomas, and Saira Hussain from the Electronic Frontier Foundation. We're grateful to have had that opportunity and to have been able to feature their beautiful, provocative, and unsettling images, which, as you can see, are around you. I also want to thank the Knight Institute staff who did so much to put this event together, particularly Lorraine Kenny, Katie Glenn Bass, Candace White, Adriano Lamarande, Kitty Ahmed, Teddy White, and Roni Galaz. Thank you as well to the Knight Institute's supporters, some of whom are listed at the back of the program, and a few of whom have joined us today. And finally, thank you all for joining us. It's wonderful to be here with you at Riverside Church, which, as we say in the program, has been for almost a century a venue for the most important conversations about human rights, social justice, and the United States' relationship to the rest of the world. Thanks again. Alora, over to you.
Thank you so much, Jamil, and thank you all for coming. It's such a privilege and an honor to be here this morning with you all. So we're going to begin the day by considering the First Amendment rights of non-citizens within the borders of the United States. The questions of whether and how the Constitution should be understood to protect the expressive and associational rights of non-citizens inside the United States are bound up with questions about sovereignty, collective self-determination, and the purpose of the First Amendment. What First Amendment rights should non-citizens be understood to have, and what rights do they actually enjoy? What legal frameworks do we need to ensure that the expressive and associational rights of non-citizens in the United States are respected? I'll start by introducing our truly amazing panelists and by asking them a few opening questions. And then I would love for all the folks in the room and folks who are participating online to chime in with questions of your own using either the QR code or for folks in the room by coming up to the mics. So our first panelist is Alina Das. She's a professor of clinical law at NYU, where she co-teaches and co-directs the Immigrant Rights Clinic. She and her clinic students represent immigrants and community organizations in litigation and advocacy to advance immigrants' rights locally as well as nationally. In addition to her teaching, Alina engages in scholarship on deportation and detention issues, particularly at the intersection of immigration and criminal law. Our next panelist is Ahilan Arulanatham. He's a professor from practice and the co-director of the Center for Immigration Law and Policy at UCLA. He has successfully litigated cases involving immigrants' rights, including Franco Gonzalez versus Holder, the first case to establish a federal right to counsel for any group of immigrants, Ramos versus Nielsen, a challenge to the Trump administration's plan to send holders of temporary protected status who had lived in the United States for decades, and Fazaga versus FBI, a challenge to the FBI's surveillance of Muslim communities in Southern California on the basis of their religion. Ahilan has argued before the U.S. Supreme Court 3 times and has testified before the U.S. Congress 3 times. Prior to joining UCLA, Ahilan was senior counsel at the ACLU in Los Angeles for nearly 20 years. Ahilan has received numerous awards for his groundbreaking work, including being named a MacArthur Foundation Fellow. In other words, he's a recipient of the Genius Grant. Next, we have Genevieve Lakier. She is a professor of law at the University of Chicago School of Law, where she teaches and writes about freedom of speech and the American Constitution. Her work examines the changing meaning of freedom of speech in the United States, the role that legislatures play in safeguarding free speech values, and the fight over freedom of speech on social media platforms. Christian Farias rounds out our panel by bringing a perspective from journalism. He's a senior editor at Inquest, which is published by the Harvard Law School's Institute to End Mass Incarceration. He has written about law and justice issues for the New York Times, the New York Magazine, the Atlantic, the New Yorker, the Nation, and other outlets. He has served as a legal editor with Radiolab's More Perfect, a podcast about the Supreme Court, and as a legal affairs reporter for the Huffington Post. He has also completed 2 writing residencies, including one here at the Knight Institute. So let me start out, Alina, by asking you a question. You've done so much extensive advocacy on behalf of non-citizens who've engaged in expressive activities, activities that most of us just assume should be protected by the First Amendment. But a number of your clients have suffered very serious retaliation for engaging in these activities. Can you please start us off by describing one of your clients' experiences, and then we would love to hear how current First Amendment doctrine applies to those situations.
Sure. Well, thank you so much, Laura, for that. And thank you to the Knight Institute for bringing us all together. It's really an honor to be here with so many wonderful scholars, advocates, and experts, and particularly on this panel, co-collaborators, co-conspirators in this work. So the focus of my paper and what I contributed to this convening is primarily about the federal government's aggressive legal positions in trying to undermine the First Amendment rights of immigrant activists. And I hope to talk more about the experiences of my clients and why those positions that the government has been taking are wrong as a matter of law. But first, I'd like to focus on just underscoring what's really at stake when we talk about these issues. As many of you know, the immigration detention and deportation laws in this country have not fundamentally changed since 1996, when they were made incredibly more harsh by Congress. So I think it's probably safe to say that the only reason that we have had any victories in the immigrant rights movement over the past 30 years, and here I'm talking about things like deferred action for childhood arrivals, designation of countries for temporary protected status, the passage of sanctuary legislation and welcoming policies, and even the occasional victory in court on a broad immigrant rights issue. The only reason we have had those victories is because immigrants have been willing to speak out, to expose and condemn immigration policies for what they are, even though they are vulnerable to deportation themselves. And they have done so by being leaders in our communities, organizing the rallies and protests, being the plaintiffs in litigation, speaking to the press, being journalists themselves, and taking on all of these roles, despite the fact it puts them in the crosshairs of federal immigration enforcement. And so that's why the question that I posed in the paper that I submitted for this convening is really not academic, and it's quite ominous. You know, do federal immigration officials have the power to arrest, detain, and deport people for their criticism of US immigration policy? And I think the answer, from my perspective, should be a clear no. Obviously, the First Amendment prohibits government retaliation of protected speech. When you're criticizing immigration policy, as many of my clients have done, you're engaging in political speech on matters of pressing public concern. The US government should not be able to silence its critics by imprisoning and exiling them. But as I describe in my paper and as I've experienced in my work, the government has raised a number of very challenging arguments with significant success on their side to prevent immigrants from raising these very claims. And many experts would have said that the battle was already lost in 1999 when the US Supreme Court held in Reno versus AADC that immigrants as a general matter do not have a right to bring a selective enforcement claim to challenge their deportation. So thankfully for me, I was not an expert in selective enforcement when I first encountered the issue. It was January of 2018 when immigration officials under the Trump administration arrested 2 men in New York City, and they transferred them 1,000 miles away to a federal immigration prison in Miami, Florida, with plans for their immediate deportation. The agency responsible, U.S. Immigration and Customs Enforcement, claimed it was just doing business as usual. It was targeting 2 non-citizens with old deportation orders who are priorities for deportation. But these 2 men, Gene Montreville and Ravi Ragbir, were actually leaders of the New Sanctuary Coalition here in New York City. And this is a coalition of faith-based organizations, faith leaders, volunteers, congregants dedicated to advancing immigrant rights. Both men had received deportation orders many years ago, but they had subsequently been authorized to remain in the US, to live and work here under formal orders of supervision. And both men used that time to help other families who were going through what they had gone through and navigating the immigration system. They became prominent activists and organizers in the immigrant rights movement, initially through an amazing organization called Families for Freedom, which is when I first met them, and later as leaders of the New Sanctuary Coalition. So from our perspective, what was claimed to be business as usual looked very different. I had been representing Ravi for about a decade when this happened, and unfortunately had a front row seat to many of the things that were unfolding in real time. We were actually in a meeting at Judson Memorial Church, downtown Manhattan, where New Sanctuary Coalition's offices were located. We were meeting with Ravi to discuss his upcoming supervision appointment with ICE, and that's where we learned that Gene had been arrested at his home in Queens just before his supervision appointment was scheduled to occur. And at that same time, we began receiving reports that there were suspicious cars outside of the church as we were meeting. I will spare you the story of how I was 8 months pregnant at the time, and we thought it would be a good idea for me to go knock on the doors of each of the unmarked cars to ask them if they were my Uber. But essentially, it was becoming clear at the time that these federal immigration officers, who had for a long time been expressing to our faces, to the faces of faith leaders and New Sanctuary volunteers, how much resentment they had over the sanctuary movement and the public attention that Ravi and Gene were receiving, it became clear that they were actually hatching a plan to try to silence Ravi and Gene once and for all, and to send a broader message to our community that if you speak out against ICE, you or your loved ones will be deported. So we were very grateful during that difficult time to have the support of so many partners to help craft a First Amendment strategy, including Arnold and Porter, which eventually led the litigation in Ravi's case, and so many organizations that partnered with us as amici, including the Knight Institute. Thank you to Ramya, who worked on the amicus briefing and supported our public education strategy. I know we'll be hearing from her later today. We were able to get an amazing Second Circuit decision, which essentially found that Ravi's case fit in with an exception in Reno versus AADC for outrageous discrimination, which is what they found a plausible claim that you were being retaliated for your criticism of immigration policy was a form of outrageous discrimination, and that the suspension clause required judicial review despite very bad jurisdiction stripping provisions in immigration law. Now, this decision was short-lived in the sense that the government sought cert, and it was remanded for an intervening suspension clause issue, although not on the merits like the government had asked, so that was good. But on remand, we ended up settling the case, and Ravi was able to receive 3 years of deferred action, and we are continuing to fight for his right to stay here in the US. Thank you. And thanks. The case itself still had the effect of serving as a roadmap for others. Gene had been the one who was arrested first, and he was unfortunately deported to Haiti very quickly after this happened. But fortunately, after the Second Circuit issued its decision, we reached out to him in Haiti, decided to file a First Amendment lawsuit to try and bring him back. And that too was ultimately successful as part of a settlement, and he is here in the United States. Thank you. But unfortunately, Ravi and Gene are not alone in their experiences. With our partners, the NYU Immigrant Rights Clinic began a mapping project, and I encourage you all to visit immigrantRightsVoices.org, which is where we mapped all of the instances of retaliation under the Trump administration of immigrant activists, and mapped over 1,000 instances across the country. So that's immigrantRightsVoices.org. I ended up representing several individuals, as many people here have, who faced this kind of retaliation over the years. And because of immigrant organizing, once again, many of these individuals were able to achieve a measure of success through settlements in their cases, through other ways of resolving the issues that they were facing. But because of the way these things were resolved, the law itself remains in flux. And I know that these positions that the government took, which are essentially that no court can review these cases, and even if they could, immigrants who are subject to otherwise valid immigration enforcement shouldn't be able to raise First Amendment claims at all. Those claims are still the ones that they continue to raise, the Justice Department, under the Biden administration. And I know this because I represent someone who was retaliated against, detained, almost deported by the same field office that targeted Revi and Jean under the Biden administration. And they brought in a special individual from the Department of Justice just for the purpose of arguing that there was no judicial review of her claims. And like others, we were able to resolve the case favorably by other means, and so it remains to be seen what will happen with the law. So there are responses to these legal arguments, which is what I outline in the paper. And essentially, I hope that we'll be able to talk about them in more detail. The hope is that we can somehow normalize First Amendment law and immigration rights in a way, but it is a hard task given how immigration exceptionalism applies across all sorts of constitutional domains. And I'm interested in hearing from those who are core First Amendment scholars whether the First Amendment really continues to do its job of protecting people who are oppressed rather than the powerful, given some of the shifts we've seen over time. But I think the larger concern is really why our government is so willing, under any administration, to put the interests of immigration enforcement over the interests of defending the Constitution. Courts have been willing partners to this, but I hope, and I think as lawyers, many of us believe that that course can be corrected over time, and that the victory that Revi achieved in the Second Circuit, as fleeting as that decision was, can be an example of what's to come. So thank you.
Thank you so much, Alina. It is so inspiring to hear about Ravi, to hear about Jean, to hear that they're back in the United States with their loved ones, and to hear about the awe-inspiring warrior you are for folks, non-citizens who have had their First Amendment rights violated. So, Ahilan, let's turn now to you. Alina raised so many troubling questions. Why isn't the First Amendment doctrine more protective of the expressive and associational rights of non-citizens within the United States? What legal frameworks do we need to ensure that the rights of non-citizens in the United States are actually respected and that the pattern that Alina has described isn't perpetuated?
So, thanks for the question. I guess first I should also thank the Knight Institute for organizing this really important discussion and also the things from last night. And your work, Alina, really underscores, well, thank you for it. It's incredibly important work and also does underscore the need to have conversations like this. I mean, I think underneath your question, Ilora, I feel like are sort of two distinct questions. And I want to kind of play abstract law professor for a minute here, because I think it's helpful to think about that framework that way. You know, one question is if anyone, a citizen or a non-citizen, wants to assert First Amendment rights as against federal immigration enforcement, which is what the cases you were talking about is about, right? Like what legal frameworks do we need for that? What is the existing law about that? A second, to me, very, very different question is, if we leave aside the federal immigration enforcement context, what are the rights of non-citizens in general when it comes to free speech? And are those different from citizens, the rights of citizens, and should they be? I actually think it's useful to start with that second question just for a minute to escape from immigration exceptionalism and all that in order to think about this. If we're allowed to sort of think, what's the general legal framework? You know, sort of abstract first principles, what should we think about this? And to me, the answer is quite obvious, actually, if you abstract out of that the rights of non-citizens and citizens with respect to speech not only should be the same, but actually are the same in practice in most situations outside of federal immigration enforcement. You know, just imagine students at a university are protesting a university, just hypothetically, you know, are protesting universities' investment policies with respect to a country somewhere. And you have citizen and non-citizen students who are protesting. would it make sense that the school might have two sets of rules? Like the citizen students have to be 50 yards away from the president's office, but the non-citizens have to be 100 yards away? Or if you want a less sort of hot example or whatever, imagine a situation where people are protesting at a school board, or just speaking at a school board meeting to complain about any, class sizes for their kids, or any sort of mundane context in which First Amendment rights happen all the time. The idea that in that kind of context, that the length of time rules for a citizen to speak might be different for a non-citizen to speak, to me seem pretty, that it seems absurd to me that you would imagine kind of different rules in that context, because the state's interest in creating its time, place, and manner rule, or even other kinds of rules, the speaker's interest in speaking, and the general kind of public interest or societal interest in structuring the First Amendment rules in that context to ensure what we want the First Amendment, the work that we want the First Amendment to do, they're all the same, regardless of whether the person is a citizen or non-citizen. And so, for me, I think that is the kind of general framework that I would bring to all of this. And I think that intuition holds. You can test it in a variety of contexts. I think that intuition will hold even if the state actor at issue is the federal government. Put that protest on a military base, or put the school board on federal land, or the protest on federal land. It doesn't make a difference. It doesn't really matter. And I think it also holds, even though it's true that non-citizens, for the most part, can't vote and can't vote in federal elections, ever, because the fact that you can't participate by voting doesn't make it sort of less important that you have the ability to speak to people who can, right? Like it's sort of quite orthogonal to me to the question. So I think, yeah, that's sort of my answer to your question as a general matter from a legal framework perspective. I think the First Amendment's protections as to speech should be treated like the Sixth Amendment's protections, which apply in all criminal cases and are meant to be the same regardless of immigration status. I think it should be the same as the suspension clause. Important caveats we have to talk about, but the suspension clause and the federal habeas statute, which is meant to implement it, apply to all prisoners. And at least when it comes to a sort of canonical claim challenging your detention, those are the same and are to be treated the same regardless of the immigration status of the prisoner. And I think the First Amendment should be like that. Now the contrary view in the doctrine anyway, and in the kind of academic discussion about this, seems to arise from the fact that the First Amendment uses the word "the people" in a portion of it, and so the idea there is the people refers to a political community, and the people protected by the political community that are defined in that language might be more limited than the set of all people, like natural persons who are just living and walking around in the territory of the United States. Now, I don't want to get into this in a lot of detail. A lot of people have written about this. Pradeepan Gulasekaram is one professor who's written really interesting stuff about this. I think that view is clearly wrong. For one thing, the text says, "Congress shall make no law abridging the freedom of speech or of the press or of the right of the people peaceably to assemble." So the people is not about the speech clause, it's about the assembly clause. And just a sort of very basic grammatical, if you want to read the people back into that, it's just a very unnatural reading of the words. Presumably then you would read it back into the press, which is even weirder, like citizen press and non-citizen press. It was just totally bizarre. It doesn't make much sense. And I also think it's true that it's odd to me that we would pick this one spot to read the First Amendment in this distinctly textually limited way when Congress doesn't actually mean Congress. It applies to all branches of government. Speech doesn't just mean speech. It applies to expressive conduct that's not speech, and applied to listening, which is coming in the papers later. And law doesn't apply to laws, but also to regulations and to just enforcement action that isn't law. So it's like the First Amendment is so far outside its narrow text, by its terms. It's just why in this one context would we instead limit it back to a phrase that's not even in the portion of the amendment which is about speech. So I think there are really serious problems just at a very basic level with the doctrinal move of trying to limit speech rights based on the text of the amendment. So if you're with me with all there, then really the question now I would say comes back to Alina's question, which is okay, given that in general It doesn't make any sense doctrinally or in terms of the text or the sort of normal things that we consider in constitutional analysis to limit speech rights to for non-citizens in a way that does not apply to citizens. Is there some reason why we should nonetheless allow those things in the context of immigration enforcement? And that's sort of the classic immigration exceptionalism move. Like you're talking about, maybe all the rights, due process rights, everything is sort of limited when it comes to asserting rights against immigration enforcement. And I don't want to kind of get into it in a lot of detail. This also a lot of people have written about, including Adam Cox, who's here, who just wrote a very long paper about this, talking about the problems of immigration exceptionalism. A lot of people have talked about this in different contexts. I would just say like 3 things, quick things. It's my view that those are wrong, and that there isn't an immigration exceptionalist sort of justification for treating the First Amendment differently when it comes to immigration enforcement. I think that you can believe that and nonetheless believe that the government has the power to exclude and deport and detain people. It may or may not have those powers. It's a much more complicated sort of question. But even if it does, all it means to reject immigration exceptionalism in this context is just to say that those powers, when exercised, are constrained by the First Amendment. Just like when the government does a million other things, like exercise its Commerce Clause power, or exercise its spending power, or every other, that there's a side constraint operating on those exercises, which is the First Amendment. And that is to say that the government can still deport people, but it can't do it for reasons that would be impermissible as applied to other kinds of sanctions. So, if you can't criminally prosecute somebody for speech, then you shouldn't be able to deport them for speech either. Of course, you can criminally prosecute for some speech if it complies with the Brandenburg test, and then you could deport on that basis too. But if you can't do the one, then you can't do the other. So I don't think it's it doesn't get you to like open borders just because you believe that there's no immigration exceptionalism. The other thing I would say. Two other things I would say, unlike in some other areas, the Supreme Court has not said that non-citizens have fewer First Amendment rights. It's the orthodoxy, I think, even in the context of immigration enforcement, it is the orthodoxy for sure. That's what most people think. And I think most people think that the Supreme Court has said that as well. But actually, I think if you look at the cases, only a few cases, but if you look at the cases closely, most of them are either cases that would have come out the same way even if the person was not an immigrant because of the time that they were decided. I'm thinking of like Turner v. Williams, which is from like early 1900s, or these cases from the Cold War communist era, like Carlson v. Landon and Heresiades. These are cases where decided at a time when the First Amendment doctrine generally was really different from what it is now. And then ADC, and this sort of gets to the third point I was saying, ADC is primarily a case about, not primarily, I would argue it's entirely a case about selective enforcement. And what makes your work so amazing is that the people Alina was representing were all people who had final deportation orders. And she was arguing that even though they had a final deportation order, still the government could not target them for deportation. And whether or not such an argument would work today with our current Supreme Court, it's a very, very different thing to say that if you take people who are lawfully present but are non-citizens, like my temporary protected status holder clients, for example, who went all around the country vigorously organizing and protesting and demonstrating and hunger striking to protect TPS status, that those people can be targeted for their speech, where they're not actually deportable. They're holders of lawful status, and to argue that nonetheless the government will strip that status because of their speech is a very, very different thing. And the Supreme Court has never said that's okay. And I think to do that would be a bridge farther. They may do it, but to do it would be a bridge farther. So I think for all those reasons, I would say the framework that we're talking about is actually more expansive, properly understood under even existing law than people sort of often assume it is.
Thank you so much, Ahilan. There are so many important insights that we all should take from that discussion, including about how the First Amendment must be a bulwark against immigration exceptionalism in this area. And you ended your talk in part by mentioning the orthodoxy around the First Amendment interpretation in this area. So Genevieve, that's the perfect spot for you to come in. Tell us about this orthodoxy. What why do we have this limited understanding of the First Amendment rights afforded to immigrants? What does that tell us about the strength and nature of the First Amendment more broadly? We're accustomed to thinking of free speech protection as so broad and so powerful in areas that do not include immigrants, but is that really what it is?
All right, well, thank you, and thank you for having me, and it's great to be on this panel. I'm so happy this convening is occurring. And Anilan, I'm so happy that you just set me up perfectly, because I have to say I agree, and I guess I disagree a little bit with your presentation, because I think as a matter of theory, as a matter of doctrinal theory, so the conception of the First Amendment, of free speech in the cases, it seems I completely agree with you that there is a very strong argument to be made that non-citizens who are in the United States, or I think we could even speak more broadly, non-citizens who are addressing a US audience, that speech should be entitled to full First Amendment protection under the sort of the orthodox view of what and how broadly the First Amendment extends. Because from the 1930s, 1940s, the court has made very clear that the First Amendment protects all speech that addresses publicly and truthfully speech on matters of public concern that is relevant to the interests of the listening public. And it protects the speech not only for the speaker's benefit, not only because we think that speaker is a rights holder, but because of the audience. The members of the democratic polity have a right to have access to the widest, in a later case, the court talks about the most robust and inclusive public discussion available. They have the right to a wide range of viewpoints and ideas. And presumably, that means, if we're not going to be ridiculously parochial, means maybe that foreigners, non-US citizens, whether living here or not living here, but particularly living here, might have something to add to democratic public discussion. And so from a theoretical perspective, from like 1940 on, the argument that, as you say, non-citizen speakers and non-citizen speech should be on a par with citizen speech, it's obvious, right? Like it's the logical conclusion. And yet I think if you look at the history of the First Amendment law, what you see is a constant battle with a suspicion about foreign speakers in the United States and a worry about the way in which foreign ideas are subverting and undermining the American experiment or democratic principles. I mean, I think it is no coincidence that many of the defendants in the early Espionage Act cases, out of which emerges the early First Amendment, are so, for example, in the Frower case that Holmes decides in 1919, it's a German language publication. In the very infamous Schenck v. United States, there are Russian immigrants. And, as we know, much of the anxiety and opposition to the anti-war sentiments from World War I that mobilized the development of the modern First Amendment was xenophobia, was a concern about radical immigrants from Eastern Europe bringing in their proletariat ideas and revolutionary aims. And the court rejects this ultimately by declaring that the First Amendment extends broadly. The First Amendment allows speakers to engage in un-American speech so long as it is on matters of public concern and is addressing and contributing to this vibrant public discourse. And then we get the second Red Scare, and we get the Dennis case. And again, a huge part of Dennis involves the prosecution of the leaders of the Communist Party USA, so these are American citizens, but so much of the concern in the opinions and the arguments is about the subversion by the Soviet Union, this subterranean infiltration of the American experiment by this foreign global power, and the need to protect against that. And it is in the response to that that we see the Supreme Court allow the conviction of members of a political party basically for spreading political philosophy. And then the court rejects that, right? Dennis becomes this stain on the history of the First Amendment, and in response to Dennis, the court begins to embrace a much more rigid, expansive, some have said imperial First Amendment. Beginning in the late 1960s, 1970s, we begin to see a much more expansive and aggressive, and no balancing, no conditions, free speech, we really mean it. And yet still, I guess the part where I disagree with you is that I think as a matter of actual descriptive practice, it's not obvious to me that it is only in the immigration context that non-citizens have fewer speech rights as a practical matter. We also know when it comes to election-related speech and campaign finance, the distinction between citizen and non-citizen is a significant one. And although the Supreme Court has never ruled on it, then Judge Kavanaugh, when he was sitting in the DC Circuit, wrote an important and influential opinion in Blumen v. FEC, in which he quite forthrightly articulates a view that non-US citizens non-resident, non-permanent residents, right? He's not. It is very interesting to me the ways in which these categories shift. So maybe it's about citizenship, maybe it's about permanent status, but there's some category of resident aliens who, on Kavanaugh's view, do not have the same right to participate in democratic election-related or political discourse, or certainly not to fund it under existing doctrine, which is a significant reduction in free speech rights, particularly in a time when, and on a court when, being able to contribute money to political campaigns is understood as a very significant means of expressing and participating in the political process. So for me, it creates this paradox or this conundrum or this really important question that I'm glad we're all gathering in a way to discuss today, which is if, in theory, the argument that non-citizens should have full First Amendment rights is crystal clear and very old, almost 100 years old, the court has settled on the doctrine that it's really about is it speech on matters of public concern, is it addressing a public audience, that's all you need to know. And then the reality of significant differences in the quality and nature of rights. Anilan is completely right that non-US citizen speakers have a lot of First Amendment rights, but maybe not where it counts, or maybe not in the context where it really matters. And so how do we understand this? How do we understand, on the one hand, this expansive theory and this limited application? And I guess I'm just gonna make the paradox a little bit sharper, because if we think that there are certain characteristics of the modern, which I grew up from the 1970s on, the modern doctrinal framework when we're thinking about the First Amendment, the court has emphasized in recent years two principles of how the modern First Amendment works that are supposed to guard against government discrimination and tyranny and all the bad stuff that are central to the modern First Amendment. One is no speaker-based distinctions. Certainly not when there are pretexts for viewpoint-based distinctions. In maybe the peak of the modern libertarian or laissez-faire First Amendment, the peak case, Citizens United, one of the most hated cases, but also an extremely expansive, very First Amendment-y case. The court strongly rejects the idea that we should think that speaker-based distinctions are okay in any context in where they might be a proxy for viewpoint discrimination, which is certainly in these contexts that Alina is talking about. And second, the court has made this idea that what the First Amendment prohibits above all else, perhaps, is viewpoint discrimination by the government, sort of a central mantra in how we think about the First Amendment. What the First Amendment does not allow the government to do, above all other things, is discriminate against people based on their viewpoint. And yet, again, that is exactly what Alina is describing the government saying that it has the right to do. And so there is a way in which the current dichotomy, the actual practice of the reality of how the First Amendment works in the immigration context, maybe also in the campaign finance context, maybe in other contexts when it comes to non-US citizens, is in direct tension with what the court has articulated as the central and very strong principles of the modern First Amendment. And so how do we understand this? And I think there are three explanations, and I think they're important, but I'm not sure. I think it's genuinely interesting the ways in which the modern First Amendment is in some ways so expansive and then in some ways so narrow and so limited. First Amendment scholars today like to complain about how broad and how overly expansive, how too deregulatory the First Amendment is, but I'm sure that's not your experience. In many ways, it's very, very narrow. Okay, so I think there's three reasons why. So one is the conception of democracy that underlies it. The idea that Kavanaugh articulated in his opinion in Blumen, but I think that underpins and explains why even in Citizens United, even like a few paragraphs after saying that speaker-based distinctions are never allowed in the First Amendment, and certainly not when they're proxy for viewpoint discrimination, the court says, but bans on foreign-owned corporations being able to participate in elections. Well, that's fine, without really any explanation. How these two can go together is this view that the reason we're protecting so much speech and we're tying the government's hands when it comes to regulating speech, including corporate speech, is because of an idea that this is speech by and for the democratic polis. And I think this is not so much a textless claim about who, the people, but an idea that democracy only works if it is the members of the political community who are calling the shots. And so we are really only protecting speech, potentially, to the extent that it is contributing to the conversation by and between and among members of the democratic community, and that foreign speakers can contribute, but they can also subvert the autonomy of the democratic people, their ability to participate in self-governance in this core way. I think that's influencing a lot of it. Now, I think it's incoherent in a certain extent, which is why it's always nuanced and unsure of itself. I think, again, the Blumen opinion is so interesting because Kavanaugh does not say non-US citizens or non-permanent residents do not have any First Amendment rights or any right to speak, but they don't have a right to contribute money to elections, because that is where the opinion draws the line between giving useful ideas and opinions and exerting too much power over the democratic polity. And so it's always unsure. There are limits. The view is not that non-citizens don't have any free speech rights, but that the democratic political community, the native-born, the citizens, whoever we may think it to be in our conception of democracy, must have control over the terms and conditions under which they are governed. Now, I think that's incoherent, though, because what it produces is the kind of situation that Alina was talking about, where we have a largely unaccountable federal bureaucracy making decisions on the basis of viewpoint-based reasons in a way that I think is inconsistent with the democratic principles that we're supposed to be defending, which is that the government in a democratic society may not act for viewpoint discriminatory reasons when it regulates people or speech. And so I'm not sure the view works, but I do think to the extent that there is going to be movement on the First Amendment status of non-citizens and non-permanent resident speech, there is going to have to be argument about what democracy means and what it means for the rights of non-US citizens. Second, and this is I think, the story about non-citizen rights is part of a larger story, which is that even as the court has in some ways articulated a very expansive First Amendment, it is a First Amendment that is very subservient or very sensitive to, very deferential to the needs of prosecutors. Alina, you talk in your paper about the prosecutorial discretion cases, or the Neves case, and the Gonzalo v. Trevino case, where the court clearly doesn't want to read the First Amendment as too much of an intrusion on the discretionary authority of the coercive agents of the state, the police. And there is a way in which the modern First Amendment, even as it articulates a sort of a kind of imperial and expansive vision of what counts as speech and how broadly the First Amendment applies, so that First Amendment law starts swallowing up more and more law, also tends to be very deferential to the needs of regulators, and particularly those who maintain security, whether it's domestic security or national security. And I think this is also a front on which, if there is to be any movement on the rights of non-citizens and on immigration exceptionalism, I think it's part of a broader critique that has to be made from within and beyond the First Amendment about why it is the case and why it should not be the case that the civil rights of both the free speech and other civil rights do not need to take this backseat to prosecutorial discretion. And third, I think also the government speech doctrine and the court's receptivity to the idea that, well, a democratic government can viewpoint discriminate when it is articulating its own programs and its own policies. There's a way in which, despite saying viewpoint discrimination is always anathema in the First Amendment, the modern doctrine allows, as a practical matter, an enormous amount of viewpoint discrimination on the government's part. And so there's a way in which the stories we are talking about here today are part of a broader kind of domestication, no pun intended, of the First Amendment to make it powerful in certain ways and very, very deferential to government power in others. And to make it, I think, in general, a tool that can be used very powerfully to strike down certain kinds of laws, those perhaps that constrain and interfere with the operation of certain kinds of markets, but that do not fundamentally challenge the ability of the government to maintain what it considers its version of security. And that idea that First Amendment rights have to always give way in the interest of security, whatever that may look like and however they may operate, I think is a fundamental problem, but it's a fundamental challenge in this area.
Thank you so much, Genevieve. So both Genevieve and Ahilan raised questions about who are the people. And Christian, that's where I want to turn to you. Let's talk about the preamble to the Constitution, which begins with the language, "we the people." Are immigrants, including undocumented immigrants, included in the "we the people" language? You've recently published a piece about originalism. So what would originalists say in response to that question? Who should be answering this question? Do we trust the US Supreme Court to answer this question? And where are your views on this?
Thank you, Alora. Thank you to all the panelists. I'm excited to be back at Columbia. I was a writer in residence here a few years ago, and I actually followed up on a lot of the cases that Alina was talking about, and Ahilan as well, and I'm really heartened to see where these cases have gone and how they've been resolved. One problem with journalism, and I'm a journalist, I'm not a legal scholar, is that once we report on something and we publish the piece, we kind of step out and we don't follow up on the cases. That's a big failing of journalism. But you guys do the hard work and you guys see these cases through to the very end, so thank you for that and for informing me on where these cases stand today. Also, I should note that please, I will not give you a dissertation on these legal principles with the verve and knowledge that the other panelists have. But I do follow trends. I do follow the courts. I do look at the Supreme Court very closely, what it does, what it doesn't do. And I can give you kind of the bird's eye view of where things are at the moment. And as Alora was saying, I'm not an originalist, I'm not an expert in originalism, but I do follow what the current court does with these topics and these subjects. And as you may know, even though this is not a Second Amendment talk, this is a First Amendment talk, the Supreme Court is very much engaged in this project of what the people means because of its interest in the Second Amendment right to bear arms. As you know, that right, according to Heller, protects the people's right to bear arms. And there's an open question in the courts right now whether that language covers undocumented immigrants. Right now, the Justice Department, as a result of Bruin, the Second Amendment decision that basically now mandates judges to engage in a historical analysis of gun regulations to ensure whether or not they comport with how regulations were at the founding, now has judges basically going crazy, becoming historians on gun regulations. And one regulation in particular, one gun law that has come up because federal public defenders are challenging it in court is whether the undocumented or the non-citizen ban on the possession of a weapon under federal law is constitutional under Bruin. And of course, federal public defenders, they defend many non-citizens who are facing these gun charges. And the Justice Department now finds itself in a very interesting position because these are criminal cases. So far, we've talked about civil litigation, and criminal lawyers, they have a way of litigating things. I don't know to what extent. I would love to be a fly on the wall of those conversations of how the civil division, which handles a lot of these weighty constitutional issues, is informing the criminal lawyers and the prosecutors on how to defend these cases. But right now, that's what the courts are trying to determine, whether the people covers these non-citizens who happen to be, if not gun owners, they definitely have been found to possess firearms, which subjects them to incarceration, prosecution, and obviously after that, deportation. And this is not an academic question. Just speaking of what the people means, over the summer, after the Supreme Court tried to once again clarify what the Second Amendment means, the Fifth Circuit, in a case very much raising this issue, said point blank, well, the Supreme Court hasn't clarified this issue, neither will we. We're just going to follow our own precedent, and we're going to say that non-citizens are not, quote, members of the political community. So what does that mean, that non-citizens are not members of a political community? Is that historically based? Is that grounded in any particular theory or understanding of the Constitution? Who were part of the political community at the founding when this nation first got started? No one knows, but there's been scholarship. There's people way smarter than me who have written on this, who have said, hey, look, why are we even bothering with whether or not undocumented immigrants were covered by the people language at the founding. Of course they weren't. There were no immigration laws at the time. If anything, we were trying to build a nation. There were lots of immigrants coming. People wanted to kind of, settle and kind of start their own communities. Of course, we were a nation of immigrants, and everyone is included in this language. That's what the scholars are saying. But now, if this question comes to the current Supreme Court, how are they going to answer the question? And that matters because of the reasons that have been already explained, that once the Supreme Court answers whether the people covers non-citizens, that applies to the First Amendment too, because the people is in the First Amendment. It applies in the Fourth Amendment context, because the words the people are also in the Fourth Amendment. So if you have this broad pronouncement, and I'm dreading the historical analysis that the Supreme Court will do if and when this gets there, will they want to answer the question? Because if they do, that could have really, really strong ramifications for these other areas of the law. And honestly, I don't know what's going to happen. And as a journalist, I'm just following the litigation. But the reality is that judges are not happy with the status quo of the Second Amendment law. And because they're having trouble even applying the instructions that the Supreme Court is giving them, now they're all over the place. And because they're all over the place, circuit splits are bound to develop, and the Supreme Court, sooner rather than later, is going to have to answer the question. And honestly, I'm among the skeptics who doesn't trust the Supreme Court to answer it correctly. In a way, I hope they don't, because as we've seen in other contexts, Ahilan wrote a great piece about Munoz a couple months ago, which is another immigration case that they decided. They just apply their own view of what the text of the Constitution means very selectively, depending on who the claimant or who the plaintiff or who the defendant is. And the reality is I'm just very, very, very worried about what the final answer will be in this context.
Christian, thank you so much for all of those insights. And thank you to everyone in the audience who has started sending in questions using the QR code. Feel free to keep those questions coming. I really appreciate it. So I'm going to kick us off with a question that's on my mind and clearly has been on the mind of one other audience member. Let's look forward. There are only 18 days left until the presidential election. What do you expect will remain stable in this area of law? What do you expect will change? What advocacy strategies might we collectively use under a Harris administration versus a Trump administration? And one of the audience members asked about Trump's plan to target immigrants in large numbers as a key priority. In that context, how can the First Amendment be used as a defense?
So thank you for that question. Thank you to the audience member who raised it as well. It's a really tough one because I think immigrant rights activists and advocates have been contingency planning for a very long time, and I think it is quite alarming, frankly, under either administration. With a new Trump administration, I think it's very clear that at least some of the policies of the past will return. And we did see not kind of an effective mass deportation strategy. Frankly, there have been more deportations, or at least with respect to removals under both Biden and Obama than there were under Trump. But what he did so effectively, Trump, is essentially have a kind of a chaos strategy of, and I think that's in part why so many immigrant rights leaders were targeted, because it was a PR strategy. It's a way of creating a chilling effect, exactly what the First Amendment is supposed to protect against, across immigrant rights organizing overall. And so in that sense, I do think communities do need a strategy of being able to both marshal the kind of attention that they need to their leaders, to be present for these interactions with ICE. A lot of frankly, the evidence that we haven't talked about that, but what you need to prove a First Amendment retaliation claim requires there being a presence, not just, a federal government says we did it for this reason, we're claiming that, and there's no proof of what's happening. The retaliation claims have to be established. And then this fight in the courts to be very consistent in our arguments to push back against particularly jurisdiction stripping issues, which will be significant. So I think it's coordination between activists and journalists and those of us who would have to litigate these claims. With the Harris administration, I would expect they would continue, and because of organizing and advocacy and what people were able to put forward, the Biden administration did put in some of their prosecutorial discretion memos a line about not tolerating retaliation based on First Amendment protective activities. So that's kind of their official policy position. But we see that it still happens. And it happens to the most vulnerable people, people who could, in theory, be picked up because they have an old deportation order. People in detention, this is a huge issue. People have been organizing in immigration detention for as long as we've had immigration detention. We don't know anything about what's happening inside unless we can hear about what's happening inside from them. And the retaliation that's going on currently, again, we've seen it in New York City and the surrounding area, retaliation against our community members in Orange County Jail who were transferred after a hunger strike, again, happening under the Biden administration. So I think those cases of retaliation will still continue, perhaps not on the scale. And we have to be cognizant both about our arguments, about slippage in criminal law enforcement, because that affects us as well. And then I am very scared about the issue that Christian has written about, and everyone should read his piece, because I do think it's going to keep popping up in these different contexts. And even though I completely agree with Ahilan that there are very good reasons to say that whatever we do with the people shouldn't attach itself to free speech based on the clause, I think it very much maps the actual public dialogue. It's all a cycle because immigrants' voices are being suppressed, and we are hearing a powerful anti-immigrant rhetoric from many political leaders on the right and left. I think this idea that immigrants, people who've lived in this country for decades, are not part of the people is very much reflected in public discourse. And so that is a place where a single court statement, even if it is something that can be narrowed, will, I think, galvanize that sentiment. So we have to protect against that in our speech. I think that has to be something that, as part of our activism and advocacy, we push against, and so that the courts, we have a counterweight to what could be happening in the courts.
And just to add quickly to what Alina just said, Inquest.org, which is the publication that I'm an editor at, we actually just published a piece precisely about what you said, that there's a lot of anxiety in the immigrant rights advocate community for whatever the outcome of the election is. This is not a Trump thing. This is also a Harris thing. And there's a lot of, the quote that the writer uses, Silky Shah of Detention Watch Network, the word is they're doing a lot of scenario planning, really preparing for the worst. And in that environment, one thing that Silky says in her piece is that we need to be very mindful to not get caught up in language or narratives around national security or around public safety, because historically these narratives that certain immigrants are a threat to, people, that there's criminals in the streets that are, doing terrible things to Americans, or that certain immigrants are national security threats, you tend to put people into categories, into buckets. And when you do that, you dehumanize some at the expense of others. And when you get into those binaries is when you start passing terrible policies and you start kind of folding to what some in the political spectrum want, which is for you to make decisions, pass policies based on fear, based on feeling, rather than, just evidence and what's real and the truth, So I would encourage people who are wondering, what can I do in this environment, not knowing what's going to happen, is one, don't fall prey to those narratives and be discerning in when you hear politicians talk about it. And if you care about immigrant rights, support these organizations, because they're going to need it for sure once whoever wins the election.
Just on a quick note, people should find Abe Paulus, who's sitting right there with Baji, Black Alliance for Just Immigration, because just one of the forefront leaders that needs support in this movement fight. So just wanted to point that out.
Thank you.
Ahilan, Genevieve, do you want to chime in on this question?
I mean, I agree with what's been said. I think part of the reason I wanted to draw that distinction between people who already have deportation orders, and I would put also into that category people who are entirely undocumented, like a lot of the students that I represent in the University of California right now, and people who do have status, although they're non-citizens, is because I think that really matters in a very practical way operationally on the ground, and would particularly matter if there's massive protest activity against, say, a mass deportation campaign by the Trump administration. Because while I do think it's important to be appropriately fearful, it's also really important to be calibrated in how we think about that. And it's really different. I mean, legally, it is really, really different if you are somebody who already has a removal order, or even somebody who's undocumented and has no sort of obvious sort of legal defense, as opposed to if you're somebody who has a status. And then the other thing I would, so that's something I definitely keep in mind. There's 1.5 million TPS holders in this country now. I think there's around, I can't remember the total number of parolees, but there's a huge number of people who are here on paroles of different kinds, and the government can't probably, I think, sort of categorically terminate either of those off schedule. There's a schedule that they sort of have to follow, certainly for TPS, and until they do that, those people are lawfully present and can't be deported for their speech under current law. Like, that's the current law, and the court would have to change that. Not to say that they wouldn't, but they would have to change that in order to do that. The other thing I would say is there's a lot of people in these liminal statuses in immigration law. I know you all know this well, but some who may not be as familiar with immigration law, it's not like you're either legal or not legal. And you see that not just in the campaign finance context, this context of concept of U.S. persons in Blumen is sort of borrowed from FISA and other kinds of ideas, but even deferred action, like DACA, means you're undocumented, but the government has decided that they won't deport you for a certain time period and will give you a work authorization. Like, what is that? And there's no like legal, illegal definition in the immigration code where you're either this or that. So one thing I think that the Trump administration, a future Trump administration could potentially do is try to move a lot of people from one bucket to the other, or test the limits of how this First Amendment doctrine intersects with these kinds of various forms of liminal statuses. And that's an area, I think, of doctrinal concern and also very real practical concern. Because certainly DACA holders, just to take one example, have lived here with lawful status and employment authorization in very large numbers since now for more than a decade. But whether they are situated like green card holders or even TPS holders who have a statutory basis for their status, or instead they're more like Jean or Montreville or Ravi Ragbir, like Alina's clients, is kind of unclear. And that's definitely an area of something to watch, and I think in my view be very concerned about in a potential Trump administration.
I guess the only thing I'd add, and this is just at the level of ideology or discourse, is that one thing that struck me about particularly the way in which the Trump and Vance talk about why they want mass deportation, or the very strong anti-immigrant sentiment that they've been mobilizing, is that, well, it's not that they hate immigrants, they just want to prioritize Americans, It's just like, those Democrats, they're just worrying about other people, but we're worrying about our people. And I think when it comes to the First Amendment, and when it comes to things like retaliation against people who are criticizing the immigration practices of the current government, I think it's very important to push back against that. Restricting the ability of people to criticize the government affects us all. And the problem with this effort to divide between the rights of us and the rights of them is to ignore the ways in which our rights are coexistent. And so particularly when it comes to speech, which is supposed to inform and enable all of us to participate in this shared project, it just seems very important to push back. You cannot deny the rights to those without denying the rights to us to hear what they have to say, just at the discursive level.
Thank you. So we just have a few minutes left on this panel. I'd love for you to introduce yourself and ask your question. There are a number of other questions that have come in the chat, so I will ask the most controversial one in addition to your question, and then we'll let you all close.
Yeah. Thank you very much. My name's Lev Citrin, and there are two things that I've heard here, one of which I know for a fact to be untrue, and the other one that completely puzzled me. So the one that's not true, I think slipped in Genevieve's talk, where it seems to me that she assumed that non-citizens or citizens' free speech is protected and has the widest possible application. And I assure you that this is not true, because I myself had a case. I've tried to publish my own book, and I've discovered that the government blocks author-published books from the mainstream marketplace of ideas, libraries, bookstores, only giving those to the corporate books. So the proper distinction, it seems to me, is between corporate speech and individual speech, and government tries to suppress individual speech and to facilitate corporate speech. And what puzzled me was in Alina's talk, where she linked free speech with immigration, and I kind of thought, look, suppose there is a murder, and a person comes forward and says, I'm the murderer, and the government comes and arrests him, and the person says, wait a minute, I was just exercising my free speech rights, and the government says, well, but we are not arresting you for your free speech rights, we're arresting you for murder. And the same thing, I just couldn't understand the logic. I mean, I understand that lawyers are very smart people and that they can link things that are not really mixable, but in any event, here, you know, where a person is in the country illegally and says, I'm in the country illegally, kind of sticks out his head, and the government says, okay, we are deporting you, and suddenly it's a First Amendment issue. That I could not understand at all. So I'd appreciate it if you could comment on those two. Thank you.
Thank you for sharing those questions. And I will share one other from the audience that came in. So the questioner asks, many prominent universities around the country have recently come under controversy for expelling and suspending non-citizen students who are engaging in protest, which has direct consequences for the students' visa status and whether they can stay in the country at all or must leave basically immediately. What role do you think universities, public or private, play in this ecosystem of ideological exclusion and deportation policies and the subsequent enforcement that's involved? What role should universities play?
Well, I'm happy to address both the question, thank you for raising it, that you raised to me, as well as take a stab at this one, as which is a really important and timely question. So in terms of this issue of like, well, if a person, you know, the government is coming after someone because they broke a particular law, whether it is murder, as you noted, or broke an immigration law, versus they're coming after that person, they're choosing to select that person of the many people who might fall into that category because of their speech, is in many ways a classic First Amendment question. If you have a person who is, I think the classic example is a employee of a state university, and they are not, they're not tenured, they're a contract person, there's no reason that they have a right to get another year at that university. If they can establish that the reason they didn't get the new contract is for an impermissible constitutional reason, there is a scheme in First Amendment law that allows kind of burden shifting. They can prove their piece with evidence that the reason I was selected for this was because of my speech. The government has a chance to say, no, we would have done it anyway, and here's why. And that is the classic question that we're just hoping to get to in the immigration context. You know, in the case of Ravi and Jean, yes, they had final deportation orders, but as it turns out, at the time there were 900,000 people in the United States who had final deportation orders with orders of supervision, those other, 898,000 people were not selected to be deported, just the two who happened to be highly critical of immigration policy in New York City. And that, again, is the classic First Amendment problem. So in the complexities of law, it is this kind of scheme where both sides will have their say. But in this context, the government is saying you don't even get to that, you don't get that far. No one gets to scrutinize why we did this. And that is different than in other First Amendment contexts. On the question of universities, I do think this is incredibly important. We, during the first Trump administration, worked very hard with universities to create policies essentially of welcome. Some places called them sanctuary university policies, to recognize that the choices that a university makes will have a impact on their students who are not US citizens, and they have to be cognizant of that. They are just differently situated. And so when universities are educational institutions, their mission is to help students learn and to be part of this discourse. And so they should be aware that if they use punishment to respond to protest, to speech, that for non-citizens, what might seem like a reasonable response, perhaps a suspension in certain cases for somebody who's repeatedly violated certain rules that are designed to strike a balance, if that student faces deportation because of it and cannot be part of the learning environment at all, that is a failure for the university mission, in my opinion. And so I think they should be very cognizant of the consequences of their actions and adjust them accordingly. There are other ways to respond to violations of rules that do not involve someone being deported from the United States.
Yeah, I can speak just to the online question as well. I mean, I definitely share your view, Alina. I've been deeply disappointed, I would say, by universities in general, and I can speak specifically to my institution, the University of California and UCLA in particular, by the extent to which it has repressed just a huge amount of student protest activity over the war in Israel, Gaza, and now wider war. And I think there's a long tradition in kind of blue pro-immigrant states, you could say more generally, of adjusting responses of various kinds to different disciplinary activity because of the fact that that disciplinary activity sits atop a very draconian and harsh immigration deportation system. It's like California changed a whole load of its laws that used to punish things up to 365 days, for example, to 364 days, because that shift rendered a bunch of conduct, otherwise identically situated conduct, not deportable anymore. I could give you like 100 examples like this, where there's very deliberate adjustments that are made to the way the state approaches discipline because of the fact that they don't want to kind of become partners to this repressive deportation machine that operates underneath it. And so to me, it just seems like quite obvious that you should make similar kinds of adjustments in the context of students. If you want the students to be able to participate in the life of the university, and the failure to do that, I think, is sort of best understood, I think, as just a piece of a lot of this repressive activity which has happened by the university, not just with respect to non-citizens, but also with respect to citizen protesters as well. That being said, I mean, to be clear, like, I actually think if you're going to run a student visa system, if a student drops out and is, disciplined for, whatever reasons, forget the protest activity for a minute, like, it does make sense that under some circumstances, the university might have to say, like, look, this person's not coming here anymore, and we can't say that they're here on a student visa because they're not really a student anymore, and maybe there might be particularly good reasons for doing that. So, and to me, the idea that because of that, like, I don't have a problem with that system if you're going to run a student visa system. The idea that therefore we have to apply that rule with respect to non-citizen students who are in encampments or whatever is crazy, you know, and it's not really consistent with the way at least in California, the state has approached these kinds of questions in a whole bunch of other contexts.
Can I just say quickly in response to the question? Okay, I have completely failed in my ambitions as a presenter if you thought that I was saying that everything is protected. What I was saying, I think, what I was trying to say, I guess, because this is my entire scholarly project, to suggest that in theory, what the First Amendment cases suggest is an incredibly expansive, ambitious, optimistic, democracy-forward notion of the range of speech, speakers, speech acts, forms of symbolic communication that should get protection against government regulation. Especially in sort of the early dramatic cases, the court seems to be suggesting sort of very, very expansive protection for speech of all kinds, including unruly speech, critical speech, embarrassing speech, speech that makes the government look terrible. The First Amendment, as a practical matter, has never lived up to that promise. And it is the job, I think, of all First Amendment scholars, litigators, and theorists to try and get it to live up to its democratic aspirations. And one of the areas where it has never lived up to that promise and does not live up to that promise today is with the speech of non-US citizens, but not only there. And so I'm sorry if I conveyed the impression that everything is protected. Lots and lots is not. But the idea of the sort of the conception of free speech that is at the heart of the modern First Amendment is a very expansive, optimistic, ambitious idea. And so I think one of the jobs of both as a practical matter and as a theoretical matter of litigators and scholars and members of the political community is to hold the courts and hold the government feet to the fire. To say, if you want to wrap yourself in this sort of very attractive language of free speech, and if you want to use free speech as a way of saying that America is better than other places and what it means to be America, then you have to commit to that vision, which means allowing all this kind of speech that you otherwise don't want to allow. And the courts don't always do that, but that's the job of the critic to keep pushing.
Okay, Christian, you get the last word.
Well, all I'll say is that just keep an eye out on what your courts are doing. As for me, I'm really just interested in what's going to happen, obviously, with the election, but also with a lot of these doctrines that are still moving through the courts. I tend to look at how the law affects real people. And one group of people that we haven't talked about are those who are in detention and who very much are also basically deportable, but many of them are not even in detention for having done anything necessarily criminal or something that you would call in violation of the law. The immigrant rights movement is very broad. It covers many, many folks, many people. And to the extent that you can find one group or one organization that you can get involved with, they really need the help. And now with the election, because there's this political fervor, nobody knows what's going to happen. Lots of funding is going to the campaigns, but not necessarily to the organizations. I would say to just get involved, because that's where the rubber meets the road. That's where all of these doctrines and these ideas that we're talking about actually come alive. And to the extent that you can help folks realize the promise of the First Amendment, I think that's one place where we all can be involved and try to make this country the more perfect union that we like to say we are. So that's all I'd like to say.
That's the perfect place to end this panel. Let's give the panelists a big round of applause.
Thank you, Laura, for the wonderful moderating. We're going to take a break until 11 o'clock, and then we'll be right back here for panel 2. Hi everyone, welcome back. I hope you had a chance to get caffeinated. We're going to continue with our program with our second panel, which will be moderated by my colleague at the Knight Institute, Ramya Krishnan.
Hi everyone, welcome to this panel on foreign speech, the First Amendment and national security. It's a pleasure to have such a great panel with me today. I'm going to introduce everyone on that panel. To my right, I have Noah Chauvin, an assistant professor of law at Widener University Commonwealth School of Law and formerly counsel in the Brennan Center for Justice's Liberty and National Security Program. Then I have Anna Diakon, a staff attorney at the Knight Institute, whose litigation focuses on government transparency and government surveillance of speech. And then finally, I have Evelyn Dueck, an assistant professor of law at Stanford Law School and formerly a senior research scholar with the Knight Institute. So on this panel today, we're going to be discussing government efforts to restrict the exchange of information across borders in the name of national security. We're going to hopefully address a bunch of really interesting questions like when is national security a legitimate justification for suppressing cross-border speech? What legal frameworks constrain the government's hand in this arena? And how do these restrictions on cross-border speech that are imposed in the name of national security, how are they shaping public discourse and dialogue in the US today? And just before we dive into things, I want to remind people to please submit any questions that you have using the QR code that is behind me. And for those of you who are here in the room, you feel free to ask your questions in person. So I'd like to start with some table setting. Particularly since Russia's effort to interfere in the 2016 election, there's been a lot of talk about how new tech is really changing the game when it comes to foreign influence operations and the threat that they pose to democracy and national security. But while new tech may have introduced fresh vectors for exerting foreign influence on the American political process, concerns about foreign influence aren't new. And so, Noah, I wanted to start with you because in your draft paper, you write about how fears about foreign influence are as old as the country itself. And so I'm wondering if you could give us a brief tour through this history, talk about when foreign influence has been seen as a threat to democracy and when it's led to censorship.
Absolutely. Thank you for that, Ramya, and thank you to the Knight Institute for having me here today. I'm thrilled to get to join you all. Like Ramya said, concerns about foreign influence date back to the founding of the country. We can see them reflected explicitly in the Constitution itself. That the Foreign Emoluments Clause prohibits officers of the United States from accepting any present emolument, office, or title of any kind whatsoever from any king, prince, or foreign state. Right? So it's explicitly there in the Constitution. It's also reflected implicitly in other aspects of the Constitution. So in Federalist Number 68, Alexander Hamilton talked about one of the benefits of the electoral college system for selecting the president being that it would reduce the risk of foreign influence on the presidential election process. Right? In his farewell address, announcing he wasn't going to seek a third term as president, George Washington also warned the nation about the perils of foreign influence on domestic political processes. Right? So these are long-standing concerns that we've seen since the founding. Genevieve talked in the first panel about concerns during the 20th century about communism and the influence of the Soviet Union on the United States political process. And I'll note, right, that fears about foreign influence aren't entirely baseless. As Ramya said, right, we know that during the 2016 election, Russia sought through a variety of means to influence the presidential election, to support President Trump and Bernie Sanders in their campaigns. And they used a variety of tactics, including notoriously the fake social media accounts. In the past year, we've seen similar efforts from a variety of nations, including rival states such as Russia, the PRC, and Iran, as well as from putative allies such as Israel and Turkey, right, to influence politics in the US. But while foreign nations do try to influence our politics, excessive fears of these efforts have led to some of our nation's most shameful censorship and surveillance regimes, including the Alien and Sedition Acts of 1798, right, which the Federalists used to target and prosecute their political enemies for core political speech, right? They were motivated by concerns about foreign influence. The Palmer raids during the first Red Scare, right, are another excellent example of this. And of course, COINTELPRO, which was the FBI's illegal surveillance program targeting the leaders of the civil rights and anti-war movements, which again was ostensibly justified by concerns about communist influence on those movements. You know, we see these problems kind of continuing into today. A prominent contemporary example is the forced sale of TikTok, which I believe we'll be talking about later on during the panel. And so these are kind of long-standing concerns, but as Ramya said, new technology has changed both the ways in which foreign nations try to influence our domestic political processes, and also the kind of techniques that the government has to censor and surveil.
Thanks for that, Noah. So as you sort of briefly touched on there, new technology, or at least claims are being made that new technology, and particularly with the advent of social media, that this has changed the landscape dramatically. As I mentioned earlier, you know, national security officials often claim that new technologies have intensified the threat posed by foreign influence operations, but it seems like it's also created new opportunities for surveilling and controlling foreign speech. Just last time, we had the Supreme Court issue a decision in a case about jawboning, which involved claims about the government pressuring the social media platforms to take down disfavored speech. So what's new and what's just hype here? And Evelyn and Anna, I'd love to sort of bring you both in here.
Sure. So I think on the government control of speech front, to your second question, one thing that is new is social media surveillance. And a variety of government agencies have social media surveillance programs, and they use those programs to monitor both domestic and foreign speech. But on the foreign speech front in particular, I would say a big sea change happened in 2019 during the Trump administration, when the State Department issued a new rule. And under that rule, nearly all applicants for immigrant and non-immigrant visas would have to disclose the social media handles, Evelyn included. So used in the last 5 years on 20 different platforms. I'm sure you had all 20.
That's right.
This rule affected an estimated 15 million people a year. So this gave the government a huge trove of information that they could use to assess people's speech and association, not just at the time of their application, but it would give them the tools to continue to monitor them when they came into the country. And this obviously has many different problems with it. The first of which is that it chills the speech and the association online of visa applicants. I think it's completely understandable that many visa applicants are reluctant to engage online on issues related to politics or human rights or other sensitive issues, because they don't know how that information is going to be used against them in the visa application process. And when there are these restrictions on foreign speakers, it doesn't just affect them. It affects every US listener, every person here that wants to hear from and engage with those speakers online. And then, of course, a second issue is that there's no evidence even that this program works at all. So the Knight Institute submitted a Freedom of Information Act request related to a Biden administration review of the use of social media handles in the visa vetting process. And we obtained one email chain, among other documents, between intelligence officials. And in that chain, an intelligence official said, they admitted, that this social media disclosure requirement added, quote, no value to the visa vetting process. And yet the program still remains in place. And I think we see this time and time again with surveillance programs. Once they're in place, it's much easier to put them in place than it is to get rid of them, because there's always some hope that maybe they'll be useful in the future.
Just say one of my favorite jokes used to be every time Knight would announce an update about this case would be just to tweet out, as a current and likely future visa applicant in this country, I obviously have no thoughts about this requirement to submit your visa handles, except that what a great country this is with its very strong First Amendment. It was very funny the first 5 or 6 times, I'm sure.
7th and 8th as well.
Yeah. Thank you. So yeah, I mean, and I will say, like, the chilling effects, I am like one of the most privileged visa applicants that you can possibly probably imagine. And it was real when I would think about what I would be tweeting, the fact that this was something that I would have to submit to the government. So those chilling effects are absolutely real. Obviously, like, social media has transformed public discourse, political discourse in so many ways. And foreign interference is just one of those many ways. The way in which I first got into this field, that I first started thinking about these issues and researching it was, in 2016, 2017, I was casting around looking for a dissertation topic to do my SJD on, and this was back when, like, fake news was the big crisis. The big threat to democracy was, like, Macedonian teenagers that were producing articles that said Pope endorses Donald Trump. Like, this was the thing that everyone thought was going to bring down the republic, which seems so nice and quaint these days. But this was the first sort of way in which it exploded onto the public sphere. This, the threat of foreign actors interfering in various ways in political discourse. And this was, it was a few months later that we realized it wasn't just Macedonian teenagers, it was the Russian government and Russian actors as well. And then there has been, since the steady drumbeat of many state-based influence campaigns around the world. And now, of course, we obviously also have this question about foreign-owned platforms. We've sort of adverted to TikTok already. But what can countries do if they control the actual infrastructure, the actual platforms themselves? Now, the first thing to say is that there's not a lot of transparency in this area about the extent or effects of these kinds of activities. That is a huge issue when we're trying to work out, what happened, what is happening, what could happen. But to the extent that there is, I mean, the evidence suggests, and as Noah sort of said and says in his paper, the evidence suggests that many of these campaigns are not very effective and are unlikely to have, like, the fear of the campaigns dramatically outstrips the effectiveness of the campaigns itself. Every so often, Facebook, Meta, and it used to be also Twitter, but not so much anymore, would announce these takedowns of these bot farms or groups of state-based influence operations, and they'd sort of detail the very lackluster engagement metrics that these, like, thousands and thousands of accounts that are very cheap to set up, very easy to do, but they're not reaching anyone. So it's like this philosophical question: if a bot posts in a wood and no one's around to hear it, does it actually do anything? And I mean, the answer is probably no. But of course, in an age where everything is very close and the stakes feel very high, anything at the margins matters. And so I understand the anxiety about it. But one of the things that I think is more problematic is, and to really get to sort of why we're here today, it's not clear to me that foreign domestic is the right the right thing to be worried about, right? Like if we're concerned about lack of transparency about manipulative and inauthentic influence campaigns, it's not obvious to me that a domestic-grown, manipulative, inauthentic influence campaign, I mean, we might think that that might be more effective at finding the potential audience that might actually swing an election one way or another than from a foreign country. So I'll sort of leave it there, but it seems to me that that line, the foreign domestic line, is not the right way to be thinking about the very real problems that we might have, the very real anxieties about the way that social media has transformed our political discourse.
So thank you, Evelyn, for very nicely teeing up my next question. I mean, I think this whole panel, in a way, is about the thin line between foreign and domestic, so maybe this is a theme we're going to keep returning to. Debates about restrictions on foreign speech, I think, tend to assume that the burdens of these restrictions fall mainly, if not entirely, on foreign speakers. I think that is a theme that runs through the government's argument in the TikTok case, for example, and it's one that I think has run through a lot of the commentary about the case as well. And so, Anna, I want to turn to you first, and I'm just hoping you can tell us, is this an argument that has gotten traction in the doctrine?
Yeah, I would say, first of all, I think under the First Amendment, it's generally assumed that foreign speakers outside of the country do not have First Amendment rights. But as you alluded, they are not the only people affected when their speech is restricted. And there is a right to receive information that US listeners have, a constitutional right. And the Supreme Court has alluded to that right, as Genevieve spoke a little bit about earlier, across the decades. And it's also talked about that right, particularly in the context of the right to receive foreign speech. And so the first case I'm thinking about is a 1965 case called Lamont v. Postmaster General. And in that case, the court struck down a law that prohibited the delivery of what they called communist political propaganda unless the intended recipient had affirmed that they wished to receive that material. So in that case, the courts, held that the requirement was unconstitutional because it basically was at war with the wide open debate and discussion that the First Amendment was meant to protect. And it also talked about how that kind of requirement would be a deterrent effect for people who wish to receive the information, but maybe they held a sensitive position or for some other reason were really reluctant with having the stigma of that requirement attached to them. And then the next case I'm thinking of is one called Mandel, and that's a 1972 case. That involved a foreign speaker named Ernest Mandel, and he was a self-described revolutionary Marxist. And he was seeking a non-immigrant visa into the country to basically attend academic conferences, give lectures, travel around. And so though his exclusion was ultimately upheld for other reasons, the court did acknowledge in that case that it wasn't Mandel that had a First Amendment right to speak, but the academics who invited him had a First Amendment right to hear him speak. So that was, again, another reiteration of this idea that there's this right to receive information. And then about 15 years later or so, there's another case called Mies v. Keen. And it was a little bit different on the facts. That case involved a challenge to the Foreign Agents Registration Act, and in particular its disclosure requirements. So in that case, the plaintiff wanted to show Canadian films, but those had been identified as political propaganda under the law. And because of the stigma attached to disclosing that he wanted to show these, this political propaganda and he wanted to run for office, he did not want to have to adhere to these disclosure requirements. So there, the court took a different approach and it said, well, actually, these disclosure requirements actually foster the freedom of speech because it gives more information to the US listeners to help them figure out how they want to weigh or interpret these films. But the implication of that, and they also said that because there was no prohibition on showing the films, the people could still watch the films and engage with them, then there was no burden on protected expression. But the implication of that, much like in Lamont and Mandel is that US listeners have a right to receive this information, and that the laws that burden them should be treated through a First Amendment lens. I think this picture has been complicated more recently, and in particular, and I think Evelyn will be talking about this case later, the case Holder v. Humanitarian Law Project in 2010. So that case involved US citizens and organizations who wished to provide training and expert advice and assistance to organizations abroad that had been designated as foreign terrorist organizations. And they brought a case seeking to enjoin the application of the law to them, saying, no, we have a right to speak to these groups. All we want to do is support their non-terrorist, non-violent activities. Although this case, unlike the other ones, didn't directly implicate the right to receive information, I think it's closely related because it involves their right to speak with and engage with foreign speakers. And so in that case, the court did uphold the law as it was applied to the plaintiffs. It held that the training and advice that the plaintiffs wished to give was, even though it was supposed to be in support of their nonviolent activities, they said it's fungible, that it would legitimize the group's terrorist activities and its terrorist goals. And although there's language in the court's opinion that says, oh no, what we're doing here, we're not prohibiting pure speech and association. We're only prohibiting these, this material support. It's very, very different. This case has had, in the 14 years since, has had a major effect, I think, in chilling the speech and association of between U.S. persons and designated groups and individuals abroad, or even people adjacent to those groups and individuals abroad. And that has had the effect, I think, of making it more difficult for U.S. listeners to receive that information.
Thanks, Anna. So, Evelyn, I want to go to you next because, as Anna mentioned, HLP is very much at the heart of your paper about the long online shadow cast by the material support laws. And you write that HLP isn't just a big departure from traditional First Amendment principles, that it's really based on this totally misguided assumption that foreign speech or content can be divorced from domestic content, and that we can readily distinguish between these two things. So can you explain to us why is that a misassumption, and how is this false premise shaping the moderation of content online?
Yeah, great. So to sort of understand what Humanitarian Law Project did, it's maybe useful to take a bit of a step back, which is to say, when you teach the First Amendment, when I teach the First Amendment, you start with these sort of majestic opinions and these majestic cases that birthed the modern First Amendment. And you teach sort of the tragic dark days that are now consigned to the dustbin of history, where the legislatures would try and criminalize a mere association or assembly with groups that the government had decided were bad or dangerous, many of these cases about communists. And you teach that we no longer do that. And the opinions that sort of said, no, if people are not sharing the unlawful aims of the group or trying to further the unlawful aims of the group, that mere association or mere assembly with people that the government says are bad or slaps this label on is no longer permitted. And you teach this as a wonderful story of progress. And then I get to the Supreme Court's 2010 decision in Humanitarian Law Project, and I teach it as a puzzle. It's a puzzle for many of my students because, so as Anna was saying, federal law, there's this federal law that makes it a crime to knowingly provide material support or resources to a foreign terrorist organization. Material support is defined very, very broadly to include any service or including expressive activities, including training or expert advice. And there is no intent requirement that you are intending to further the unlawful aims of the group. So as then Solicitor General Elena Kagan, wonder what happened to her, described the theory of the law when she was defending this law in Humanitarian Law Project. She said, Hezbollah builds bombs, Hezbollah also builds homes. What Congress decided is that if you help Hezbollah build homes, you're also helping Hezbollah build bombs. So you may not be intending to in any way further the unlawful acts of the terrorist group, but any assistance at all is criminalized. Now, there is no constitutional protection for giving someone building materials. But as we just discussed, there is constitutional protection for association and expressive activities, and this was what this NGO, Humanitarian Law Project, wanted to engage in. They wanted to engage in training of two organizations, two FTOs, and included training them on how to pursue their aims non-violently. So how to petition the UN for relief, how to pursue political advocacy rather than violence. So they had no intention of assisting the FTO's unlawful or violent aims. In fact, exactly the opposite. And so this is the puzzle that it sets up for my students, the sort of pretty direct, you would think, conflict with these precedents that I've just taught them. And the court rejects the argument that the government brought in that this law doesn't really need to be scrutinized under the First Amendment because it's not targeting speech. This is not a law about speech. It's just targeting mainly like money, building materials, like other kinds of material, like material support. And it just happens to sweep up a little bit of speech, but that's not a First Amendment problem. The court rejects that. It says, no, this is restricting speech. This is a First Amendment problem, and we need to subject this to demanding scrutiny. And then this is where the puzzle comes in. The court then upholds the law and the application to the Humanitarian Law Project regardless. And essentially because of this deference to the government's national security aims, that combating terrorism is an urgent objective of the highest order, and it was lawful for Congress to conclude that aiding a foreign terrorist organization's lawful activity, as Anna was saying, it's fungible, it creates legitimacy, that will help the terrorist organization as a whole. But Chief Justice Roberts and the court's opinion does, I think, feel some uneasiness about this, because it is inconsistent with these other precedents, and it clearly cannot be right that the government can come in and say national security and create a First Amendment loophole. And the court doesn't want to overturn all of these precedents that I've just told you about, that the First Amendment is so proud of, these celebrated cases. And so the court instead gives these a number of limiting principles. And one of these limiting principles is that we do not suggest that Congress could extend the same prohibition on material support at issue here to domestic organizations. So you can do it with respect to foreign organizations, but not with respect to domestic organizations. Again, I think implicitly recognizing that this is inconsistent with the cases that would say you cannot do this, but for some reason the fact that the organizations are foreign allows this prohibition, this criminalization to be applied in this case. There's no elaboration of this, by the way. There's no explanation of why that's material. So we have to do some work to infer what the court is thinking and how or why that can be justified. Now, I don't think it can be. I think it's an incoherent line and normatively unjustifiable. But we've already sort of touched on that in the first panel, and we're going to touch on that again later, and so I'm going to skip over sort of that. My accent might give some hints as to my feelings about the assumption that foreign speech is somehow less valuable than domestic speech. But I want to skip to, even if that were the case, the court's assumption that there are these two spheres of discourse, there's these foreign groups and then these domestic groups, and we must protect one but not the other, that in an age of global platforms and global discourse, that those two spheres are not, you can't neatly separate them. And this is where social media platforms come in, and the impact of the material support law and the court's decision in Holder on how they moderate content. Now, again, I want to go back to what I said earlier. It's very hard to know exactly how platforms moderate content and sort of work out exactly what's going on. So we sort of triangulate based on connecting dots and a bunch of anecdata. But we know, and civil society organizations have been sort of raising alarm for years and years and years about the bluntness of the way that social media platforms moderate terrorist content. And this is not just to say, oh, they're taking a very broad interpretation of terrorist content or violent or moderating gruesome imagery that would be protected by the First Amendment, and they're taking it down. That's bad. We could have many debates about sort of where the line should be. Should that kind of stuff be on social media? I want to skip that debate as well, because to say this is a separate point, the point is that because they are so risk averse and so anxious to remove that bucket of material, in part because of their potential liability under the material support law, they're removing a bunch of stuff that I think everyone would agree would be protected valuable speech. And I give some of these in the paper, some of these examples in the paper, when YouTube introduced a new moderation tool to get rid of terrorist imagery. It took down a whole bunch of thousands of videos documenting human rights abuses in Syria. Facebook at one point was removing all references to the Al-Aqsa Mosque, one of Islam's holiest sites, because the Al-Aqsa Brigade is on the government's FTO list. And so when protests were happening at Al-Aqsa Mosque, all of this content was being removed as well. It removes, these social media platforms often can remove news coverage of terrorism and terrorist acts because their tools are not that smart. They're not very context aware, and they're applying a blunt hammer here. And then one example from the last year, which I wouldn't even believe unless Facebook acknowledged and apologized for this mistake, but Instagram at one point was auto-translating the word Palestinian in users' bios to read Palestinian terrorists, which I think just sort of, it was a mistake, but in part because of the biases that are in the automated tools that these platforms use to detect this kind of content. So in their anxiety to not be exposed to liability, these are the kinds of tools that they're deploying and the risk averseness that they're adopting. And we do know that this is in part because of the law. Again, they don't come out and say, we're worried about liability here, so this is what we're doing, but they use the FTO lists in choosing what organizations to prohibit references to. And of course they do. This is exactly what you would expect a rational, risk-averse intermediary to do. There's lots and lots of literature about the fact that if you have vague or overbroad laws, what are intermediaries going to do? They're not particularly invested in this content or in individual pieces of speech. They're much more invested in not being charged with a crime. And so of course they adopt an overbroad interpretation. That's exactly what you would expect a risk-averse intermediary to do. But this clearly has impacts on domestic discourse, not just foreign groups. I think the reason why should be obvious, but my paper uses the example of discourse around Israel and Palestine. I don't think it needs to be sort of drawn out why that is an important matter of domestic debate. And even if the impact of platforms moderation in the shadow of these material support laws was just limited to foreign content coming out of the Middle East, that would still have a dramatic impact on domestic discourse because it limits, as we were just talking about, limits listeners' rights, limits how Americans can understand what's happening in the region. Social media has been a huge source of information, but it's also not so limited. Domestic speakers also get swept up in these laws, in the moderation efforts of platforms. Newscasters, protesters, students groups all find themselves encountering restrictions on social media platforms as a result. And that chilling effect, is something that the First Amendment doctrine, First Amendment also ordinarily recognizes as a natural thing that's going to happen as a result of broad and vague laws, and a thing that should make laws unconstitutional. The court in Holder Humanitarian Law Project didn't think about these impacts. It didn't talk about it, but I think it should have, and it should, and that the law, for that reason, is a violation of the First Amendment.
Thanks, Evelyn. So, Anna, this line that Evelyn has been riffing on, this difficulty of drawing a clear line between foreign and domestic discourse and the collateral damage of trying to enforce that line, that's at the heart of a case that you're currently litigating. And so I'm wondering if you could tell us a bit about that case, and maybe in the context of doing that, just tell us the sort of, argument strategies that free speech advocates like you have been trying to limit the fallout of HLP.
Yeah, so last December, the Knight Institute filed a lawsuit challenging the Treasury Department's efforts to prevent Americans from engaging in political discourse with sanctioned people abroad. So what had happened, our client is an organization called the Foundation for Global Political Exchange. It's a US nonprofit organization, and its mission is to promote professional and academic enrichment and engagement, and it does so by organizing these small group immersive dialogues with, in the Middle East and North Africa. And these events are called exchanges. And so participants in those exchanges are policymakers, government officials, journalists, academics, other people who are interested from the US, Europe, Australia, et cetera. They go to these exchanges because they provide them an opportunity to engage with the full range of viewpoints from stakeholders in a particular country or region. And so the foundation sets up these events, these exchanges, because it believes that that's the best way for these US or European journalists, academics, et cetera, to get a full, unvarnished view and understanding of the political dynamics in a given country, to make sure they're not just getting this biased, one-sided, or lopsided view from news reports or other things. And so in 2023, the foundation planned what was its 21st Beirut exchange in Lebanon. And it planned to invite as speakers approximately 30 people, stakeholders, politicians, members of parliament, from across the political spectrum in Lebanon. And among those 5 speakers, the political situation being what it is, were 5 individuals who had either been sanctioned by the US government themselves or who were members of a sanctioned organization. And so this case did not involve the material support law that Evelyn spoke about, but there are definitely similarities. So this involves the Treasury Department's Office of Foreign Assets Control, or OFAC, which administers several different sanctions programs that are supposed to be directed at economic and trade sanctions. And 3 of those programs were implicated here. Those are called the Lebanon Sanctions Regulations, the Global Magnitsky Sanctions Regulations, and the Global Terrorism Sanctions Regulations. So although they all target different groups of people, they're similar to the material support law in that they forbid the provision of services to or for the benefit of blocked individuals or entities. So, from the perspective of our client, simply including designated people in the exchange's political dialogues, it didn't seem like providing a service within the meaning of those regulations. OFAC seemed to focus on, as I said, trade and economic sanctions. So they were, it seemed like it would target financial services or accounting services, maybe transportation services. But, given the chilling effects and the real fear of facing, pretty, severe penalties if you run afoul of these laws, they wanted to make absolutely sure that what they were doing was permitted under the regulations. So out of an abundance of caution, they reached out to OFAC to say, hey, we just want assurance that this is okay. And to our client's surprise, but maybe not many people here's surprise, OFAC wrote back, and it said that including those designated individuals would in fact be a service prohibited under the regulations because it would be providing a platform for them to speak. So really just goes to the heart of speech activity there. And it also then further determined that it would be contrary to US policy to give a specific license for them to engage in that activity anyway. And, this position is an extreme one. The idea that Americans can't even engage in political dialogue with people whom the government has sanctioned, it's a really dangerous idea and a really dangerous position for the government to take. So we filed a lawsuit in federal district court challenging that decision, and we primarily made 3 arguments. The last of which, to Ramia's question, does go at the idea of cabining the Humanitarian Law Project case. So the first argument was that OFAC had just simply exceeded its regulatory authority. As I alluded to before, this, simply engaging in political dialogue with foreign speakers or designated speakers did not constitute a service within the meaning of the regulations. And so second, we argued that even if it could be construed as a service in some very, very broad definition of the term, the activity falls within statutory exemptions that limit OFAC's authority. And so where does that authority come from? The three regimes are all primarily authorized by a law called IEPA, which is the International Emergency Economic Powers Act. And when enacting and later amending multiple times IEPA, Congress took steps to ensure that the authority it was granting to put in place these trade and economic sanctions would not infringe upon the speech and association with people abroad. And so the law's exception, the law explicitly states, for example, that it does not include the authority to regulate or prohibit personal communications. Sounds a lot like dialogue, political dialogue. The law also expressly does not give the authority to regulate or prohibit the importation or exportation of information or informational materials. And as explained by Congress in a conference report, when Congress included those carve-outs, it was expressly trying to, and this is quoting it because it's a great quote, it sought to protect the constitutional rights of Americans to educate themselves about the world by communicating with people of other countries in a variety of ways, such as by sharing information and ideas with persons around the world. That is the heart of the Foundation's mission at issue in this case. And so third and finally, we argue that OFAC's decision to block this kind of political dialogue violated the First Amendment. And because, as we've discussed, Americans have a right to engage in political discourse with foreign speakers, even those the government deems dangerous or subversive. And even Humanitarian Law Project, I think, that Evelyn talked about, which is criticized for its stunning breadth. I don't think it even goes this far. OFAC has gone way beyond the bounds of that case. And I think the reason why is really fundamental. If OFAC can limit who Americans can hear from, if it can limit the ideas that Americans take in, then it can influence the ideas that Americans hold. It can change their whole perspective and the frameworks from which they're working. And this is precisely, to my mind, what the First Amendment is designed to protect. But happily, though, in some good news, rare it seems in this realm, but just a few weeks after we filed suit, the Treasury Department reached out to us wanting to initiate settlement negotiations. So that's a good sign that Treasury did not want to dig in here and defend its decision. And hopefully it's a sign that the agency realizes that it severely overstepped in this case. We've been engaging in settlement discussions since then, and I don't have anything to announce yet, but hopefully within a few weeks we'll have some good news to report.
That sounds very hopeful. Thank you for that rare bright spot, especially after the doom and gloom of HLP. So we've been talking a lot about First Amendment rules, First Amendment doctrine, and Noah, your paper focuses on the normative dimensions of combating foreign influence through censorship. You argue that these dimensions are largely missing from debates about restricting cross-border speech, and so please tell us, what are these missing normative stakes, and what do they tell us about how the court should balance the competing interests at stake when it comes to these sorts of restrictions?
Sure, absolutely. So I'll start off by saying, as we've been talking about, right, we're in a moment where people in government, in civil society, in the population more generally, are kind of deeply concerned about foreign influence on our political processes. So we proposed and enacted a variety of mechanisms to help combat foreign influence, including ones that restrict speech. And this is something that civil libertarians have objected to quite strenuously. Including the Knight Institute, right, has been really, really great on this issue. But the opposition to this foreign influence motivated censorship has been done in largely consequentialist or utilitarian terms, right? That is that our arguments against the censorship have focused on the benefits to society of a robust free speech regime and the relatively low likelihood that these influence efforts are actually going to impact people's political behavior. And Evelyn talked about this a little bit earlier on in the panel, right? She joked about the Macedonian teenagers, but it's true, right, that social scientists have looked a lot at Russia's efforts to influence the 2016 presidential election and found that basically, despite the myriad things that Russia did, particularly on social media, wasn't able to impact people's voting behavior or beliefs. So I want to be clear, right? I think the benefits to society of a robust free speech regime, right? The kind of practical benefit that we get from having free and open debate, I think is a really important normative point. But my paper addresses another dynamic. I'll say before I get into that, right? The reason that the opposition to kind of foreign influence motivated censorship has been so focused on these sort of utilitarian questions is because that's where the First Amendment doctrine is, right? The kind of doctrine that we have requires strict scrutiny of content and viewpoint-based restrictions, and the standard asks, right, whether the restriction on speech is necessary for the government to achieve a compelling interest, right? That's a utilitarian kind of question. My argument in the paper is that what's missing from our kind of resistance to foreign influence motivated censorship are questions about the moral value of speech, right? And my position is that free speech is valuable in and of itself, regardless of whether it provides some broader societal benefit, right? So as Justice Thurgood Marshall put it in an opinion, free expression serves not only the needs of the polity, but also those of the human spirit. And the idea is that free expression, it protects individuals' ability to define themselves, right? Their kind of autonomy and their basic human dignity, that there is something kind of inherent in being human that requires one to be able to kind of think for oneself. Now, importantly, the autonomy argument applies not only to the rights of the speaker, but also to the rights of the listener. Anna talked about this a little bit earlier, and the ways in which the First Amendment doctrine already indicates protection for the rights of the listener. And this protection is particularly important in the foreign influence context, because we're generally talking about speech that's being kind of promulgated by non-citizens, right? Non-LPRs, right? Folks who don't have these sort of substantial voluntary connections to the United States and are also located outside of the country, right? And the First Amendment is generally understood not to protect the speech of those individuals. And so focusing on listener rights and the ways in which that speech is important, and accessing that speech is important to listener autonomy is particularly important in the foreign influence context. I make the argument in the paper that, right, focusing on or adding in these kind of autonomy and dignity arguments to resistance to foreign influence motivated censorship is important not just as a moral question, although I think it's a very important kind of moral question, but there are practical reasons to do so as well. The first is, as Christian talked about on the first panel, we're seeing an increasing turn from the Supreme Court and a number of other kind of conservative judges towards an originalist or history and tradition approach to interpreting much of the Constitution, including the First Amendment. Justices Thomas and Gorsuch have repeatedly been making originalist arguments in opinions that they've written, generally dissenting from denials of cert. In other contexts as well. We've also seen prominent circuit court judges, including Judges Thapar, Newsom, and Oldham on the 6th, 11th, and 5th circuits, respectively, saying that First Amendment doctrine should consider the kind of history and tradition of speech restriction in determining what sorts of regulations on speech should be permissible. Judge Oldham, in his net choice opinion in the Fifth Circuit, chastised the social media companies who were opposed to Texas law for discussing Supreme Court doctrine and not history and tradition, which is just a baffling line. And so the reason that making the moral argument is going to be particularly important when dealing with originalist judges is that the founders viewed freedom of speech, and in particular the right to receive information, as a natural right, and as a right that fell outside of the bounds of government regulation. The government didn't have the ability to kind of restrict the right for the public good. Now, as I talked about earlier, we have to weigh that history against the deep concerns that the founders had about foreign influence and things like the Alien and Sedition Act that happened shortly after the founding. Right? This is one of the reasons why originalism is challenging, because we have conflicting histories. But nevertheless, right, this appears to have been kind of a core animating motivation behind the First Amendment. And so for originalist reasons, we might want to focus more on the autonomy and dignity argument. Another reason to kind of make that argument is that political culture is deeply important to protecting rights. And we can see this particularly in the realm of free speech, right? The kind of First Amendment protections that we have, which are quite robust, right, developed in part as a result of kind of protracted litigation strategies, but also because free speech advocates won the cultural battle, right? There's robust support among the American population for free speech. However, there's some troubling evidence that seems to indicate that support for free speech is declining, particularly among young people. And there's a number of polls that have been done that appear to reflect this. Polling also indicates that this may partially be due to a sense that the marketplace of ideas doesn't function online. There was a survey done where people said they were becoming increasingly disengaged from politics, in part because they couldn't tell what was true and what wasn't. And so the moral argument becomes important here because even if it is true, right, that the marketplace of ideas is not functioning optimally, and that new technologies change the extent to which we can kind of rely on it to help us achieve truth, nevertheless, protecting free speech can still be important if we're protecting it in part for these moral reasons. Lastly, the paper talks about how free speech is increasingly regulated more by private companies than by the government, right? Evelyn's paper talks a bit about the things that social media companies have done in response to legal concerns, perhaps, but they're remarkably hazy about exactly, right, what the legal position is that would require them to have the policies that they have. Right? These private companies, right, don't need to follow First Amendment doctrine. Right? They don't need to ensure that any restrictions they have on speech are necessary to achieving a compelling aim. In fact, they have good reason not to. Right? They want to kind of maximize the number of users that they're going to have on their platforms, the amount of time that users are going to spend on those platforms, and that often is going to require being more restrictive of speech than the First Amendment would allow the government to be. But in kind of trying to resist censorship from these platforms, one argument that might be effective, or an additional argument that might be effective, is the moral one, right? These companies, I don't think, care about sort of abstract moral values any more than they care about the marketplace of ideas, right? They have a particular purpose, and it's not either of those things. But to the extent they're seen as acting in an immoral way, that can hurt their brand and ultimately their bottom line. And so for all of these reasons, I think absolutely we need to continue to make the utilitarian and consequentialist arguments. As I said, I think they're kind of required by the state of the First Amendment doctrine. But I also think it's important to include these moral arguments against foreign influence motivated censorship.
Thanks, Noah. So I mentioned TikTok earlier, and I want to circle back to that case because it seems to me the case on foreign influence and the First Amendment right now. Supporters of TikTok, the TikTok bans, argue that America has a long history of shielding infrastructure, including communications infrastructure from foreign control. And they echo the sort of argument embraced by then Judge Kavanaugh and Blumen, a case that Genevieve Lakia talked about earlier, saying that these kinds of prophylactic efforts are necessary if we want to protect our tradition of democratic self-government. And this is an argument I think that the government also makes in the case, pointing to, for example, the risk that China could hijack TikTok's algorithm in order to manipulate not only sort of domestic political discourse, but elections in particular. And so I'm wondering, what you all sort of make of this argument and how you think courts should approach the balance of interests at stake here. Evelyn, why don't you start us off?
Sure. I mean, I think I showed my hand on some of this earlier, but I guess I want to go back to one specific thing I said, which is, what does the First Amendment mean if the government can come in and say national security at any moment and get around the First Amendment? And so we can have all sorts of debates, and I would love to and have had, but just noting the time about, what if this was a Chinese-controlled platform that somehow had the specific key to unlock American public opinion, which everyone's been looking for a very long time, but they have found it and can somehow manipulate the content on the platform such that suddenly people can be made to believe things that they wouldn't otherwise believe. There's no evidence that that's the case, or that the government knows that to be the case, and they should be made at least to demonstrate exactly what the threat is that they're concerned about, because otherwise this debate has centered around TikTok, but TikTok is not going to be the last. It wasn't the first, and it's not going to be the last foreign-owned communications platform that many Americans use. And so this is going to be a recurring problem that we, as a globalized world, need to think about. And if there's a First Amendment exception that gets created for the government with these foreign-owned platforms, that they can just say, oh, trust us, there's really good national security reasons to ban this platform, then I think that's a pretty dark place that the First Amendment is supposed to stand against.
Yeah, I can't add much to that, but I will say, along the lines of what Evelyn was getting at, what comes to my mind is just, where does it end then? If the courts accept these arguments, I have a lot of trouble seeing like a natural stopping point there. I think a ruling upholding the TikTok ban would damage the First Amendment. It would give the government a massive amount of power to control what kinds of ideas and information Americans have access to. And even from a practical foreign policy perspective, I think it would be pretty devastating because other countries, of course, would look at it as a precedent and say, hey, well, you're doing this, now I can justify my own attempts at, efforts to censor and to control my own citizens. And, other countries are doing it too, look, the US is doing it. And again, on another practical point, I think some of these harms could be dealt with much more effectively in other ways, like federal privacy law, for example. So there's just other ways of handling these problems, and upholding this ban is only a dangerous one.
I agree entirely with what's been said. I don't have a great deal to add to it, other than to say, building on Evelyn's point about there being serious questions about the extent to which, any efforts from the PRC to influence, political opinion in the United States, to the extent those exist, and much of the government's briefing was classified, so who knows, maybe they have evidence of that that hasn't been publicly shared. But this is a kind of particularly low stakes environment in which to kind of trust the ability of people to kind of think and decide for themselves, right, what to believe, because we don't have really any evidence that efforts of that kind work. And so if you're worried about my autonomy argument, I think it's actually pretty low stakes, because I don't think we've seen that foreign governments are able to kind of control what people think.
Can I just add one more thing, which is to say, I was being a little bit flippant earlier about the threats here. And again, I don't want to sort of dismiss any concerns about our current information environment and the way that algorithms sort of affect our understanding of the world and the way in which these platforms do hold enormous power over public discourse. But again, foreign domestic doesn't necessarily seem like the right line to draw or the right way to combat this. And I go back to one of a very, very early piece, before I was in this space, Jonathan Zittrain wrote this piece that's, the headline is, Facebook could swing an election and you wouldn't even know it. And it was about a study that Facebook had done, which showed that if it showed people a get out the vote banner, I can't remember exactly the details, it was either I voted stickers or get out the vote banner, that this had some meaningful discernible effect on voting participation. And his argument was, Facebook sits on an enormous wealth of data about people's voting dispositions and various swing districts, etc. They could manipulate that power, show that image to people in relevant districts, and potentially swing an election. Now, that remains true today, by the way. There are no laws that would restrict that Facebook doing exactly that kind of discriminatory manipulation. And it doesn't necessarily make me feel better that it's Mark Zuckerberg or perhaps Elon Musk making those decisions than anyone else.
So we've got a question in the room, and I'm going to take that question and add one of the questions that we've received online, but let's start here.
Thank you. I'm Michael Myers, president of the New York Civil Rights Coalition. I want to ask a question particularly to Evelyn and perhaps Anna as well. And that is, I used to be on the national board of the American Civil Liberties Union back then, before they got rid of me. The government had a USA Patriot Act, which the foundation community, all these big foundations, Ford Foundation, Rockefeller Foundation, et cetera, took the language from the USA Patriot Act and put it in their grant criteria, that their grantees could not advocate terrorism or do anything in terms of free speech which violated the USA Patriot Act's language. We thought, in the civil liberties community, we thought that the ACLU would be opposed to that. And we had a big fight on the national board of the ACLU and resignations over that, because the executive director of the ACLU, the new executive director of the ACLU, came from the Ford Foundation and had advised the Ford Foundation to adopt that crazy language that attacked free speech rights of Americans. So my question to you, Evelyn, my question is, has there been a litigation on the part of U.S. citizens, grantees, for example, of these foundations? Has there been litigation to challenge the restrictions in grants to them, that they cannot speak certain ways because of the USA Patriot or because of the policies that the foundations adopted that reflected the USA Patriots Act?
So I don't know enough about that particular fact set to comment, but I will say sort of one of the points I make in the paper that I think is really relevant to this, that is I think really important, is, you know, these private intermediaries that operate in the shadow of the law, they make these decisions incentivized by the legal structures that the law creates, but then they say these are our private decisions, right? And Noah was saying this as well, that whether it's the foundations or whether it's the social media platforms, they say, here are our private rules, we are making these are our content moderation rules, we're taking down this content for our own reasons, and there are many reasons why they might take down content or might make certain decisions, and we might think, oh, you wouldn't make that same decision if the law didn't exist, but that's not what they say, and then that creates as a practical matter, a very difficult litigation problem in order to find someone with standing to challenge because there's obviously no First Amendment right against a social media platform and their content moderation rules. And if they don't come out and say, we are doing this because the government told us to, it's very hard for people to bring litigation in court about that. And so that's part of the problem here about why are we in this situation where I can sort of describe to you what I think is a pretty unsatisfactory state of affairs, where a US law is resulting in a whole bunch of censorship of protected expression. How can that be? And part of the answer is that just as a sheer practical matter, finding a plaintiff with standing and getting the evidence to substantiate a lawsuit would be very difficult.
Just to add one thing, which is actually from Evelyn's paper, I think you pointed out that a lot of these companies have an interest in not explicitly saying their interpretations of these laws. They don't want to publicize how they're interpreting it, what they think their obligations are, I think for pretty obvious reasons. And so that's another issue contributing to being able to find someone with standing, is they're intentionally kind of keeping it close to the vest and not disclosing their rationales.
So we have a few minutes left, and I want to ask one of the questions we received online. If the court ultimately concludes that there is no way to make a meaningful distinction between foreign and domestic speech, what do you think this may mean for their decisions? Might they become more speech inclusive or less? It's a good question.
It's a great question, because what it points to is something that that we don't often talk about in First Amendment law. It's like the hydraulic effects of certain rules. So you might have, so the most obvious might be that we have a broad First Amendment that doesn't prohibit, that does prohibit content-based or viewpoint-based distinctions in many cases. And we might think that the reason why the First Amendment allows like lots of content-neutral time, place, and manner restrictions that can be pretty onerous and restrict a lot of expression might be directly in response to the fact that, well, otherwise you might have this completely unwieldy state of affairs where how can you regulate speech if you can't make any content-based distinctions, allowing content neutral. So just to say that like rules that look like they are separate are actually influenced by the rest of the doctrinal architecture. And so it might be true that the question I think is implying that, well, if we put all foreign and domestic speech on the same constitutional level, could that have, I think, maybe potentially terrible implications, because we so badly want to restrict foreign speech that we now need to change the rest of the doctrinal architecture to facilitate those restrictions. I mean, I don't know. I have to say, like, that would be a nice problem to have. I don't necessarily think we're going to have a situation where they get put on the same level anytime soon. But I mean, the TikTok case will be an interesting test case.
May I ask a question?
I'm not sure that we do. Well, Anna and Noah, did you want to jump in? Go for it.
I didn't have anything.
Yeah, I think that that's actually probably all the time we have. But thanks so much to the panelists, and thanks to everyone listening.
Thank you, Ramya. Thanks to all the panelists. You're all invited to join us for lunch, which is just outside, and at 1 o'clock we'll begin our keynote address with Catherine Marr, who is the head of NPR. Thank you.
That season 3 of our latest podcast series called Speech and the Border, at the Frontiers of Censorship and Surveillance, a topic very relevant to today's discussion. In fact, episode 1 of our podcast features Ravi Ragbeer, who is mentioned in our panel 1 discussion. And so we're very excited for this series to take place. Speech at the Border will drop on November 13th and will be available on Apple, Spotify, and wherever you listen to your podcasts. So please subscribe, share your thoughts. We'd love to know what you think. And join me now in listening to a bit of a trailer of the podcast.
Hi, I'm George Wang, a lawyer at the Knight First Amendment Institute at Columbia University. On the next season of our podcast, Views on First, we're diving deep into an issue we've all been hearing a lot about.
The border. The border.
The border. Our border.
Our border.
Border.
The border.
But we're going to look at this issue from a different perspective. We're going to look at the border as a site for censorship and surveillance.
I just want to know what technology the US government is buying. It turns out a lot of that technology is at the border.
At the Knight First Amendment Institute, we fight to defend the freedoms of speech and the press guaranteed by the US Constitution, freedoms that were meant for everyone to enjoy. But the truth is, the international border is a gray area, where those First Amendment protections become fuzzy. For example, nearly all people who apply for a visa to enter the United States are required to hand over their social media account information to the State Department. That information gets swallowed up by shadowy surveillance programs inside the federal government.
Once you give the social media handle to the government, it's not just going to keep it, right? It's going to use it in order to find out stuff about you.
In fact, anyone crossing any border into the United States can have their devices seized and searched, whether they like it or not.
I still to this day don't know what they did with my phone and why I was singled out.
You know, they're told in some instances that we're at the border, we can do whatever we want.
It may sound hard to believe, but the government has even used its power to try to selectively deport permanent residents for engaging in constitutionally protected protest. Not 100 years ago, recently.
Why should we be afraid of this man and his ideas?
This is about every single immigrant who is under the threat of deportation, who lives under that.
Even U.S. citizens face government efforts to ban speech from abroad, like a certain app that might be on your phone right now.
There's been anxiety about TikTok and the potential influence that it could exert over youth.
If TikTok is shuttered, if it goes dark on January 19th, 2025, it will be a black mark for the United States.
This is not just happening in the United States. On a global scale, repressive governments are turning to digital tools to reach across borders to stifle the speech of journalists and activists.
Maybe they're interested in her contact lists or her call logs. Maybe they want to peek at her emails or her voice notes or her private and intimate photographs.
This is not an attack on journalists. This is an attack on people, on the people's right to know.
From the Knight First Amendment Institute at Columbia University comes Speech and the Border, at the Frontiers of Censorship and Surveillance. Each episode, you'll hear from a Knight Institute lawyer like me, involved in cases aimed at protecting vital First Amendment interests at the border and beyond. Available wherever you listen to podcasts on November 13th.
So there are very few people who've thought as deeply about the issues we're dealing with today as our keynote speaker for this afternoon, Catherine Marr, who is the president and CEO of National Public Radio. In this role and in many previous ones, she's been an extraordinarily effective advocate for human rights and democratic freedoms. Before joining NPR, she was the CEO of Web Summit, She also served for 5 years as CEO of the Wikimedia Foundation, which hosts Wikipedia, one of the world's most popular digital platforms. Before that, she worked on rights, democracy, and innovation at Access Now, the World Bank, the National Democratic Institute, and UNICEF. All of that you probably already knew, but I will tell you something you probably didn't know about Catherine. In her capacity as CEO of Wikimedia, Catherine was also a client of the Knight Institute, which, with the ACLU, represented Wikimedia in a challenge to surveillance conducted by the National Security Agency. In court, the NSA defended its surveillance practices by arguing that the constitutional protections for free speech and privacy should apply with less force, or maybe not at all, to communications that cross the international border. Because the NSA successfully invoked the state secrets privilege, the courts didn't engage with that argument. But I thought it might be worth recognizing that the conversation we're having today about the meaning of constitutional protections and about the proper limits on government surveillance power is exactly the one we couldn't have in court. We're very lucky to have Catherine with us this afternoon. Please join me in welcoming her.
Hi, everyone. Thanks so much for having me here. And Jamil, thanks for the kind words. So I should preface this by saying, because I am a Wikipedian at heart, and because I work for a journalistic organization, I want to start by acknowledging I'm going to tell you a little bit about the history of our work on the First Amendment and freedom of expression at Wikipedia. And also, I did not have the chance to fact check every single one of these stories with all of my colleagues. So in the words or the parlance of Wikipedia, trust but verify or check the citations. So I'm delighted to be with you here today within 100 miles of the US border. As you just heard from Jamil, I've been working on issues of freedom of expression for some time now in various capacities. And as global mobility and cross-border information flows continue to increase while freedom of expression space continues to decrease around the world, I truly appreciate the fact that you are all here working on these issues. I'm not an academic, but I am fascinated by some of the papers that were submitted for today's event and look forward to reading them more deeply in my free time. But I'm here to really speak from the perspective of a practitioner. As you heard, from 2014 to 2021, I was at the Wikimedia Foundation, which is an organization that is built on a few critical principles. Freedom of inquiry as enabled by user privacy and anonymity or pseudonymity. Freedom of expression as enabled by robust policies around the sharing of information, limited only by law or encyclopedic relevance. And freedom of assembly enabled by our shared digital spaces. And as a tertiary source, Wikipedia is built on secondary sources, such as peer-reviewed academic papers and reliable institutions of journalism, which are in turn built on the bedrock of freedom of expression, and notably, in certain cases, a history of courage as holders of knowledge and information and inquiry sustained information that was considered critical or threatening in certain jurisdictions where it was outlawed in others. At Wikipedia, we could not do our work without a robust and thriving free press or academic freedom any more than you can build a house on an unstable foundation. So I say that just to recognize the shoulders of giants that we all stand on when we construct knowledge. Of course, the internet and cross-border global mobility has also made it much more challenging to earmark oppression by freedom or geography. Oppression or freedom by geography, and as a result, we know that technical tools and legal tools for censorship have also grown more sophisticated, which reminds me of one of my favorite Wikipedia stories from some of our early days. In 2009, an editor on French Wikipedia wrote an article about a signals intelligence listening station in a rural part of the country, just outside Lyon. The listening station was not a secret. It was widely known to exist by the surrounding community and was actually the subject of a French television program where I think they went inside and they interviewed an officer based at the station. I think it was about sort of the employment opportunity that the station provided to the local community. But it's one thing for this knowledge to exist locally, and it's an entirely other thing for this knowledge to exist online, where anyone in the world could find it. So in 2013, in a vain attempt of security by obscurity, which we all know works very well, the French Internal Security Services demanded that the Wikimedia Foundation take the article down. As was policy, we reviewed the page, found nothing illegal, and refused. They then hauled in the Parisian Wikipedia editor who was closest to them, directing him to use his admin privileges to take the article down. Despite explaining this would be futile, he complied because they threatened him with detention and charges. The article was promptly restored by an editor in Switzerland, outside of French jurisdiction. And in a classic example of the Streisand effect, the article was expanded and went from only 60 viewers to more than 10,000. So those were heady days. Information wants to be free, of course. And as Wikipedia expanded, we found ourselves it was clear that we were on a collision course with issues of freedom of expression globally, where the bounds of acceptable speech varied dramatically from those safeguarded by the First Amendment. While we were headquartered in the United States and very deliberately built a hosting infrastructure that anchored around US presence with very lightweight cached infrastructure, lily pads, and strategic non-US jurisdictions, none of these efforts were fail-safe for our people or our community, who, like that French editor, were often subject to harassment and at times detention, arrest, and imprisonment for their work on Wikipedia. So I would be remiss if I didn't note that as we speak, there are multiple people around the world serving time for their participation as encyclopedia editors. In Belarus, editor Mark Bernstein was doxxed, arrested, and is currently serving a sentence of 3 years of limited mobility for his edits to Russian Wikipedia about the Ukraine invasion. In 2022, editor Pavel Pernikau was sentenced to 2 years in a penal colony for 2 edits of Wikipedia related to Belarusian political repression. And more significantly, at least in some ways for my mind, in Saudi Arabia, Arabic Wikipedia administrator Osma Khaled has been sentenced for 32 years for, per Wikipedia, swaying public opinion and violating public morals by making edits critical about the persecution of political activists in the country. His friend and fellow admin, Ziad al-Sufyani, was sentenced to 8 years. I know both of these men personally. They are doctors, primarily involved in editing Wikipedia to improve the content and quality of medical articles. So while in the United States, Wikipedia may only be an encyclopedia, outside the United States, it remains very much a contested tool of power. In 2017, I was 1 year into my tenure as the executive director of Wikimedia Foundation when we received notice from the Turkish government of an objection to information contained within 2 pages on English Wikipedia. They requested that we change or remove the information, or we would face the risk of Wikipedia being blocked across the country, a country with more than 80 million people. In 2015, we'd migrated all of Wikipedia to HSTS, or HTTP Strict Transport Security. And although Wikipedia was already available via HTTPS, this was a significant change to move to encryption by default. And it wasn't uncontroversial at the time, because at that point, many countries had adopted a practice of selective Wikipedia blocks, meaning if you were, say, in Qatar, you might not find a certain article, but you could largely access the rest of Wikipedia. Moving to HSTS would not only prevent such blocks, but since the protocol, as a protocol, it enabled us to forward secure the sites for a designated period of time. We chose 1 year. It also bound our hands so that if we were under pressure to undo the security layer, we wouldn't be able to. We were committed on a rolling basis going forward. It was, in some ways, a cute cat gamble to mangle poor Ethan Zuckerman. In 2008, Zuckerman wrote that the majority of people, the cute cat theory of activism, wrote that the majority of people are uninterested in social activism, but they are interested in cute cats or any suitable, quotidian internet behavior, from pornography to sports fandom, and build social and sharing platforms for these purposes that often prove to be useful for activists as well. And he went on to argue that because very few people like activism, but many people like cute cats. It's difficult for governments to censor these platforms without making the cute pet cat people mad and inadvertently politicizing them so that they would move from an otherwise neutral social platform and its user community into a more politicized space. So this was our cute cat gamble. We wanted to encrypt all of Wikipedia so that all of it would be available. And it mostly paid off. Most countries made the choice that all of Wikipedia was better than none. And so Iran, for example, went from being partially available to totally available. And a few others, such as China, most notably, went in the other direction. As of today, we are still blocked there. In 2015, we had a brief issue in Russia where the cute cat theory largely prevailed. The Russian censorship agency, Roskomnadzor, was dissatisfied with an article related to cannabis. A court in the eastern part of the country filed a blocking injunction, and we briefly went 404, only to re-emerge a few hours later following public outcry. Wikipedia editors in Russia had played a game of chicken with the censor, and not by removing the article, but with a flurry of edits that increased its scientific and sociological value, claimed victory. So did the censor, but mostly so did the Wikipedians. At the time, The Verge reported an EFF employee as saying, "These are kind of the first real-world tests. By making these decisions more all or nothing, even the governments we tend to disagree with politically will realize that nothing isn't an option." I wish that that were still true. In 2017, we found ourselves playing brinkmanship again, but this time with the Turkish government of President Erdogan, who has now held the presidency or leadership of Turkey for 21 years. Erdogan's administration was reportedly displeased with two articles on English Wikipedia, one on state-sponsored terrorism, which cited reports that Turkey was providing arms to the Islamic State in the Levant, and the second objection was to a little bit more personal on foreign involvement in the Syrian civil war, referencing an alleged controversy involving the family of Erdogan, his own immediate family, purchasing and smuggling oil across the border, directly funding the Islamic State. It was at this point we got a letter. And we often got letters at Wikipedia, notice of suit for some reason or another. There's a reason that the legal team at Wikipedia for many years had a life-size Chewbacca cut out at the entrance to their desks. They were the anti-censorship resistance, small and mighty. So of course, at this point, we had a few choices to make. Usually when we got letters like these, we sort of reviewed a couple different courses of action. One was do nothing, which is often the right choice when receiving a letter without any legal basis or jurisdictional basis, raising an issue about a well-reported, well-cited Wikipedia article. We would respond politely and let everyone know we weren't going to do anything about it. The second option was to censor Wikipedia, which I want to be very clear, we would never do that. The Wikimedia Foundation not only operates the Wikipedia sites, but we take pains to differentiate between our hosting duties and that of user-generated content versus editorial or publishing decisions. Wikimedia Foundation does not control the editorial policies of the community, and had we made changes to the pages, which again, we would never do, someone, like that Swiss editor, would have invariably put them back up. Further, we were always very concerned about the slippery slope argument. The moment that we would take one article down, it would be instant leverage for any state anywhere to block us until we removed content that offended them, which is why we never made it technically possible. Every single page on Wikipedia is available for editing in a single definitive instance, so we couldn't selectively block country by country. You couldn't see multiple versions of the same page. It's just not feasible based on the architecture that we use. And we always felt like it was impossible to prove a negative. If we ever found ourselves in a place where readers could have reasonable concern that we had omitted something and silently removed pages, that would be trust that we would never be able to recoup. So, never censor Wikipedia. But we could notify the community, and so we do. Wikipedians ultimately have policy control, and within their guidelines, they can choose to make editorial changes to an article, add additional sources or context or scope. They can improve the article if the information is not well cited. They are also information activists, not political activists, and the act of informing them about the consequences of editing allows them to be able to make decisions about how to evaluate their own circumstances and participation. We notified the Wikimedia community in Turkey. They declined to make changes to the pages. They let us know they'd prefer it be blocked than censored. And as in the case of Russian Wikipedia, they improved them, increasing citations, which unfortunately for our discontented president, only elaborated on the issues of his concern. We stayed blocked in Turkey for more than 2 years, starting in April 2017. We were the issues of reporting, documentaries, and political campaign promises. Wikipedia was mirrored and hosted by third parties who took advantage of its freely licensed content to run versions of the site that were in fact censored. And I actually don't know whether Wikipedians were more upset by the censorship or the fact that the mirrors ran ads. We enlisted counsel, working with Turkish internet law and freedom of expression scholars Yaman Akdeniz and Kerem Altıparmak to challenge these blocks in the Turkish court. And we failed on 2 cases, of course, but appealed all the way up to the Turkish Constitutional Court, which is their equivalent of the Supreme Court, the highest court in the land, just to hear crickets for 2 years. While we waited, with these delays being so significant, we also took the case to the European Court of Human Rights, arguing that the block was a violation to the right of freedom of expression. Because the delay had dragged on for so long, the court expedited our case, drawing attention of international rights bodies. And finally, in December 2019, the court lifted the ban, 10-6, finding in our favor. I'm always struck by, during the time of this block, 49,000 new articles were added to Turkish Wikipedia, either by Turkish speakers outside of Turkey or people using circumvention software. So despite the fact that this was not available to people within the country, they still continued to build free knowledge. So this is perhaps an argument that information doesn't know borders, but perhaps not, because these issues were never limited just to countries abroad. In the aftermath of Edward Snowden's 2013 leaks, and I'm going to speak a little bit about what Jamil was just referencing, disclosing the widespread use of mass surveillance in the United States and programs by the NSA, various organizations brought challenges to the practice, and most notably, the ACLU's litigation on behalf of Amnesty International and Amnesty v. Clapper, whose case against James Clapper, who was the director of national intelligence at the time, went before the Supreme Court before being dismissed on the basis of standing. The court found, I'm radically simplifying this, that Amnesty's claim that their privileged communication with clients was being intercepted was too speculative to proceed. Wikipedia was among those technology platforms named in the leaked materials as a target for HTTP surveillance. This was before we'd made the switch to HSTS. And we felt as though with the failure of the Amnesty case, it was time for us to file our own suit, again, represented by the ACLU, represented by Jamil, thank you so much, and along with pro bono counsel from Cooley, which was one of our law firms at the time, challenging the NSA's mass surveillance program known as Upstream. We saw the case as an opportunity to stand up for our values, not just abroad, where we'd been doing it for some time, but here in the US, for the rights of Americans, the rights of those living in the United States, but as well the sort of consequent potential beneficial impacts that reducing this disproportionate surveillance would have on our communities around the world. The chilling effect that our editors and readers experience knowing that their communications were caught up in a dragnet. And this impact was very real, not just in terms of the data that we saw around readership of sensitive articles, but the conversations that we would have with individuals who themselves felt subjected to that chilling effect. I remember having a conversation with an American Wikipedia editor based in DC who was a long-term humanitarian technologist. He worked on humanitarian development overseas. He was in the process of applying for security clearance for a new job and told me that he'd stopped reading sensitive articles about the war on terror because he was concerned that his behavior would be misconstrued. We filed suit for this reason on behalf of that editor and every other one of the hundreds of thousands of editors around the world and our more than 1 billion readers. For our American readers, this was a violation of their First and Fourth Amendment rights, and more broadly, a violation of the universal rights to privacy, free expression, and free inquiry for all of those around the world. As you heard, from 2015, we faced an uphill climb. Our case was initially dismissed, but the Fourth Circuit Court of Appeals found that we had plausible standing, given the enormity of all of our digital communications, and sent the case back to the district court. In 2018, it was dismissed again on the basis of state secrets. We appealed one more time to the Fourth Circuit, which this time upheld the government's position that our litigation infringed on state secrets. And in 2023, nearly a decade after the initial leaks and almost a decade after we'd filed suit, our petition for hearing in front of the court was ultimately denied and the case was dismissed, meaning that, as you heard Jamil say, these issues have never truly gotten an airing. Today, I'm at NPR, which is the largest public media news organization in the country. We broadcast through 247 member stations, work with 200 newsrooms and 3,000 public media journalists in all 50 states and Guam. Our reporting is on the airwaves that cover more than 99% of the geographic United States. We're there when no other news can make it through. In the aftermath of Hurricane Helene's ravaging of North Carolina and eastern Tennessee, when the internet and electricity were down, public radio's reporters were there to provide life-saving information, and you saw photographs of people huddled around radios at the ends of their driveways, sharing the news, sneakernet, writing down what they were hearing and walking it to their neighbors who weren't able to be so mobile. As a news media organization, we are on the front lines of the right to free expression. And as some of you have explored for the session today, the right of American citizens to know not just what's happening in their country, but around the world. The freedoms of the First Amendment make it possible for our reporters to pursue stories through Freedom of Information Act requests, including a recent Murrow Award-winning story by our own Daniel Estrin on the deaths of Syrian civilians during a U.S. military operation targeting Abu Bakr al-Baghdadi, which led to the introduction of legislation requiring the Pentagon to review cases of civilian harm. These freedoms also allow our journalists to cross the border and report on what is happening abroad, thanks to our journalists and producers stationed in nearly 20 foreign bureaus around the world, and the many others who travel on assignment, most recently in both Ukraine and the Middle East. These are vital freedoms. We take this responsibility very seriously. As a public media organization, our single responsibility is the right of citizens to know. We view ourselves as the scaffolding of democracy. And that is very much aligned with this First Amendment right that we're all here to discuss today. It is a bedrock, and it must be protected. It allows us to ensure our citizens can know and hold our officials to account, not just at the ballot box, but through all of the other mechanisms of democracy that are available to us. So thank you for your continued work on these issues, and thank you for having me here.
Thank you, Catherine. So if we had won that case against the NSA, I would be very happy to take all the credit. But since we lost, I feel obliged to note that other lawyers who represented you are here too. So
thank you for all your work.
Alex Abdo and Patrick Toomey and Ashley Gorski are all here.
Thank you. It's wonderful to hopefully put some names to the faces to the names that I remember from so many emails and briefs. So thank you.
So I want to start by asking you a question about press freedom. So this has been, as we all know, an extraordinarily grim time for press freedom, with so many journalists around the world imprisoned or even killed for their work. I wanted to ask you whether the climate for press freedom globally has affected NPR's ability to inform its listeners about the world outside the United States, and more broadly, whether you think the climate for press freedom globally is affecting Americans' ability to understand the world.
Very tangibly, it has affected our ability to inform. We used to have a correspondent based in Beijing. She's now based in Taiwan, in Taipei, because it's impossible to have her full-time there. We are one of the only organizations that has had a correspondent out of Moscow for the last few years after Evan's detention from the Wall Street Journal. That has become an increasingly precarious consideration and something that we think very deeply about in terms of our capacity to report meaningfully from Russia and also maintain the safety and security of our people. We have had to, I'm trying to think if there are other instances where we've actually had to pull folks out. I mean, we send people into countries. We just had one of our correspondents come back from Sudan. We've had folks in Venezuela recently. It has certainly made us, I don't want want to say more cautious, but we have to take additional precautions in order to be able to ensure that we're reporting and reporting well. To this day, I think we're one of the only organizations that still has someone on the ground in Gaza as well. We have a stringer there, Anas, who has been remarkable in being able to ensure that we're able to report what's going on from the perspective of Gazans. And does it affect our ability for Americans to know? I don't see how it couldn't. I don't see how it couldn't. I think that it is a tried and true tactic as well of, and this is, I'm speaking about my experience outside of NPR as well, of authoritarian states to close off avenues to accountability in the broader global remit is silencing journalism at home and preventing foreign correspondents from being able to report from within. And so it's not simply that the American public doesn't know. There are many stories that the global public has no access to today, and I think that that has consequential implications for the ways in which we conduct foreign policy around the world.
Let me ask you a related question about the challenge of foreign disinformation, which is a challenge that has come up several times already today and will probably come up again this afternoon. So I think it's probably fair to say that democratic governments around the world are acting very aggressively now to protect their citizens from what the democratic governments at least characterize as foreign disinformation. Here in the United States, the Treasury Department has sanctioned RT and Sputnik, and as a result, Americans can't access these media organizations that are state media for Russia. Congress has banned Americans from accessing TikTok. What should our attitude be towards those kinds of interventions? On one hand, I think we can all agree foreign disinformation is a terrible thing. It's a real thing. It sometimes a consequential thing, although there's a real debate about how consequential. But on the other hand, we don't generally allow or trust the government to protect us from misinformation or disinformation in other contexts. So is foreign disinformation different? Should we think about it differently?
The million, billion, $1 trillion question.
We actually have a whole symposium about this. So,
yeah. And what were the answers? I think about this in the context. I was just at the Public Broadcasters International Conference, which is a gathering of public media broadcasters, which is different than state media broadcasters. And included there were representatives from some of the international arms of these organizations, like Deutsche Welle. We have Voice of America here in the United States, which broadcasts outside. And it is unquestionably an action of influence that we are, by funding media organizations that operate, even, I will not question or impugn the journalistic credentials of Voice of America, that's not at all what I'm saying, but it is unquestionably an argument that we fund that work in order to be able to advance our values. And our values in this instance are freedom of expression and freedom of inquiry. And I know that one of the arguments is that that's exactly what these other entities are attempting to do, is advance a certain set of values, whether it is the Turkish broadcaster, which has made significant investments over the course of the last few years in purchasing access to television broadcast rights all over sub-Saharan Africa. It is a means of forward projection of influence, economic influence, political influence, and the like. I don't know that I am particularly comfortable with pulling things down off broadcast spectrum and channels. I think that it is, I think we are at a place where we find ourselves, as we get accustomed to blockers with regards to what sort of information we should have access to over public airwaves, I think that that is a dangerous, concerning precedent. But I do admit that I'm of multiple minds because I was at Wikipedia, and we know how disruptive, pernicious, and active some of these campaigns to undermine credible information are, and how well-funded they are.
I guess one question is whether we could address the real risks presented by these kinds of campaigns with mechanisms other than suppression, right? Whether, I mean, you sort of mentioned offhand the possibility of transparency around all of this, but maybe there are transparency mandates that we could impose.
Well, transparency mandates, I think transparency is very useful. I'm a fan of transparency. I also don't think transparency is a substitute for communication and understanding. And, we can become overwhelmed at times by transparency. There's this sort of obfuscation via transparency that can occur. And I'm specifically, dump the documents, dump the data. People are overwhelmed by what information to pay attention to or listen to. I'm not arguing against transparency. I just don't think it's necessary but not sufficient. I really wish that we were approaching this less from what do we block and more what do we build. And this to me comes back to the fact that as we look around the country today, there is such a devastation of credible news organizations at the local level. So forgive me for getting on my soapbox for a second, but 85% of Americans believe that local news is a net good. That is a bipartisan agreement that Americans have across the country that local news is something that is meaningful to their communities and that it should be supported. Only 15% of Americans are willing to pay for local news, which is a problem, but 85% of Americans believe that local news has meaningful, positive impact in their communities. And where you see communities that still have local media organizations, you see lower rates of partisanship, higher rates of voter and civic participation. These are positive correlated outcomes with access to journalism and scrutiny that happens at the local level. And that existence of local news also, I believe, has a transitive property to confidence in other forms of news. We saw this when I was at Wikipedia. If you trusted your local article about your hometown, you would have transitive trust to other articles that were of greater abstraction relative to familiarity to you. So when we divest from local news, whether it's an individual matter of choice or because private equity is stripping media organizations for value, whatever the case may be, what we're actually doing is harming the context of information integrity in our own environment, disrupting trust and undermining the foundations of the ability of people to have credible context for how to evaluate information and creating a distance between whether I trust news writ large versus any source of information. So rather than start with let's block external influences, I would far prefer that we are building the competence and qualifications of folks to understand the media environment. I also think that the media itself has a role to play here. We do not spend nearly enough time explaining how journalism works. And I'm not talking media literacy. I'm talking about the fact that every single journalist adheres to a code of standards and ethics that their organizations and their J schools, including the one here at Columbia, inculcate at the earliest stages of the profession, and the profession itself is self-regulating. Journalists look to other journalists and apply high degrees of scrutiny as to their qualifications and their competence in terms of upholding these ethics, and we almost never explain these to the public in a way that doesn't sound patronizing and doesn't sound as though we're teaching you how to read the news.
So I want to ask you one last question.
Sorry, that was a little bit of I told you I was going to climb on my soapbox. I apologize.
So I want to ask you about the internet as a tool for democratization. So for a long time, we used to think that the internet would be a tool for democratization, and in many ways, I think it has been. But it's increasingly been a tool for domestic and transnational repression as well. And you have thought about the internet a lot, especially in your role at Wikimedia. And so I'm curious to know, are you still optimistic about the internet's democratic possibilities? Find a way to say yes.
I mean, look, it's technology is not good nor bad, nor is it neutral, right? It is good and it is bad, and it ends up mirroring the proclivities that we have as human beings and replicating the same structures of our societies in many ways. And in this particular instance is an amplifying tool that allows for those who seek to create harm at scale. I think that one of the things that I've always been struck by is all of our normative expectations about privacy and speech are based on centuries of evolution of those norms. So the example I always use on a privacy basis is Germany and the Netherlands, right? They're right next to each other. And in Germany, you keep your shades closed and your windows. It's very important that you keep your shades closed because it's a matter of privacy and it's actually a matter of respect for your neighbors. And in the Netherlands, you keep your shades open to demonstrate that you have nothing to hide and you're a good, upstanding citizen. And this all sounds totally reductive, but it's functionally true. These are norms that are, and yet both societies have a deep and abiding commitment to privacy that is both part of their national legislation and part of their participation in the broader European project. And they have totally different means by which they enact those experiences of privacy. I think about this because our expectations and norms around how we communicate the bounds of speech, the bounds of harm, the bounds of privacy are very much based on sort of the speaker's corner in the public park. They're very much based on communal norms. And they have grown to the size of the nation state over the years because we have had a system that allowed them to grow and test within constructs of precedent over time. The internet does not have that. The internet is asking us to apply these normative expectations, which may vary country to country, culture to culture, as I just gave the example of these two countries that sit side by side with many, many consistent value sets, apply those at the scale of 4 billion people or 5 billion people at this point. We do not have a means by which we can negotiate those edge cases where those values collide and how we actually govern the application of that. So is the internet a good thing? In many ways, it has advanced so much of our quality of life and particularly closed the delta on issues in places, I started my career at UNICEF, where infrastructure had always failed to serve the needs of people, of civilians, in terms of their basic human needs. That is an unqualified good. How we work out these norms over a 30, 40-year period when we've always had centuries to figure it out, that is the sort of existential challenge of the day.
Catherine, thank you so much for being here.
Thank you.
Thank you, Catherine. Thanks, Jamil. We're going to continue now with panel 3. If the panelists could please come up to the stage, we'll get started.
Good afternoon. Is that working? Okay, great. My name is Alex Abdo. I'm the litigation director at the Knight Institute, and we'll be discussing surveillance at the border and surveillance across borders. And as I'm sure you've gathered over the course of the day, the border is, though not quite a law-free zone, certainly one where ordinary legal constraints on government power have given way to notions of sovereignty and exclusion. One particular consequence of that treatment of the border by governments is that surveillance at the border and transnational surveillance across borders has gone relatively unregulated. That's the phenomenon that this panel will be covering, and we have an incredible panel to do so. You can see the fuller bios in your packets, but very briefly, let me introduce who we have with us. To my immediate right is Ashley Gorski. She is a senior staff attorney in the ACLU's National Security Project, where she has litigated enormously important cases related to privacy, government surveillance, racial and religious discrimination, free speech, and she was one of the lawyers who worked on the case that Catherine and Jamil mentioned, challenging NSA surveillance on behalf of Wikimedia. To her right is Ron Diebert. He is the founder and director of the Citizen Lab at the Munk School of Global Affairs and Public Policy at the University of Toronto, where he is also a professor of political science. And to his right is Jaya Ramji-Nagalis, who is the Associate Dean for Research and the I. Herman Stern Research Professor at Temple Law School, where she also supervises the Temple Law Asylum Project. So I'm going to start with Jaya and Ron, who have drafted essays for the symposium. I'll ask them a question and give them an opportunity to tell us about their contributions. But before that, let me just remind you that you should feel free to submit questions using the QR code behind us, or if you're in the room, you can also, or instead, feel free to use the microphone. It's not there at the moment, but if it comes back, you're free to use it. If it doesn't, just use the QR code. Great, so let me kick things off. So, Jaya, let's start with you. You and your co-author, Nicole Ramos, who unfortunately couldn't be with us today, drafted an essay explaining how surveillance at the US border has been used to stifle the legal representation of migrants, and also to suppress the distribution of Know Your Rights material to these individuals seeking to cross the US border. Can you tell us about what you've documented and why the law hasn't, at least of yet, been of help?
Thank you, Alex, and thanks so much to the Knight Institute for hosting us today. So in our paper, we're really interested in the availability of First Amendment rights on the other side of the border, al otro lado, in Mexico, for US citizens and non-citizens with respect to actions by US government officials, primarily US Customs and Border Protection, and by Mexican officials acting in concert with CBP. So if you can think of this as a matrix, you could see that the applicability of the First Amendment will be most obvious for US citizens interacting with CBP and hardest to enforce for non-citizens with respect to Mexican officials. Our essay, we're really focused on border lawyering, so the provision of information about legal rights and processes to undocumented migrants in Mexico. So about legal rights and processes to enter the US for folks who are at the border in Mexico. So I'm calling it border lawyering because this can extend beyond lawyers, right? Know Your Rights presentations, accompaniment at the ports of entry, other activities that don't require someone to be barred as a lawyer in the US, but there are also some activities that are more limited to lawyers, so representation, legal representation at the port of entry in Mexico, and then subsequent litigation in the US to challenge activities at the border. So I'm really interested in the location, right, outside the US, the different actors, so we have a foreign government acting in concert with the US government, we have lawyers, some US citizens, some not, folks who are working with lawyers, and then they're working with undocumented migrants, right? So all of these, I think, are going to impact the First Amendment analysis. So as the border has increasingly become a site of encampment or warehousing, whatever you want to call it, and political contestation and theater, we've seen surveillance and harassment of border lawyering actors on the rise. So I'm really sorry that Nicole cannot be here to present. Hi, Nicole, I think she's watching us. As these are really her experiences as a border lawyer for al otro lado in Tijuana. Nicole is a former student of mine. She is extraordinary, and she has been in Tijuana directing the Border Rights Project for al otro lado for many years now. So some of what she and her coworkers have experienced was under the Trump administration has been well documented, including official government reports, but also continues to some extent under Biden. So just one example of that is the CBP officials, that CBP officials under Trump created a database about the activities of US citizens with respect to the migrant caravans coming north through Mexico. And so under the Biden administration, there was a First Amendment lawsuit challenging that database, and the Biden administration litigated that through to summary judgment, which they won. So it's not that there is a kind of continuation of the defense of the policies, at least. So there are a variety of methods of harassment that Nicole and her coworkers have faced. So it's clear, and this is clear in the DHS Office of Inspector General report, that CBP is working with Mexican authorities to deport border lawyers from Mexico. One of her colleagues was deported. She was on vacation with her family in Mexico. She was detained at the airport and deported. And then another colleague was prevented from entering Tijuana, even though her 10-month-old son was in Tijuana. So there's work there and holds being placed on their passport with the Mexican government. What they've also seen is officials, US government officials, sharing information about them with private actors who then spread that information through right-wing nationalist media platforms. So this multiplies and amplifies the sources of harassment. And then they've also seen really ongoing surveillance by Mexican border officials, physical observation, photography, attempts to intercept conversations and infiltrate their offices, and then digital means, potentially an installation of spyware, an attempt to install spyware on their phones. I just want to make clear that I'm not a First Amendment scholar. I have a very good teacher in the audience here who gave me a very long reading assignment, including several cases he's litigated. So there's a lot of case law, but given the limited time, I just wanted to raise two cases. So first of all, U.S. v. Hansen, the Supreme Court last year upheld an anti-smuggling statutory provision that CBP has used to justify the surveillance and harassment of border lawyers. And the underlying Ninth Circuit decision held that the provision of certain legal advice to undocumented immigrants is protected speech under the First Amendment, striking down the statute as overbroad and unconstitutional. Of course, a very helpful finding that was then overturned by the Supreme Court. And then the Phillips versus CBP case, which I mentioned earlier, the database lawsuit under the First Amendment, that ends in summary judgment in favor of the government. So I'm somewhat less optimistic, perhaps, than others about the role of the First Amendment here. But Alex is going to correct that, I think.
Well, we should definitely jump into that. But before we do, let me just invite Ron to the conversation. So Ron, you and your co-author, Sienna Ansis, drafted an essay describing what you call digital transnational repression. Can you tell us what that is, why it's an effective form of repression, and, similarly to Jaya's description, why the law has been slow to keep pace with it?
Yeah, happy to, and thanks, by the way, to the Knight Institute for the invitation to come here and for you for moderating this panel. A couple disclaimers right off the bat. One is I'm Canadian, I'm not American. I had to cross a border to get here, and being the director of a security-conscious research lab that deals with very high-risk human subjects, it's quite an ordeal for me to cross any border, maybe especially this one. The other disclaimer is I'm not a lawyer. And I feel a bit out of my depth in some of this conversation. Sienna Ansis, my co-author, is a senior legal advisor at the Citizen Lab, and she really did the heavy lifting on this paper. So if you ask me any hard legal questions, I might have to invoke that other amendment of yours down here. So to transnational repression. Well, by way of background, for those of you who don't know, major focus area of the Citizen Lab, we are a group of investigators, researchers whose focus is on digital security issues that arise out of human rights concerns, constitute as a kind of counterintelligence for civil society is the way we think about what we do. Do a lot of forensic work, for example, and one of the areas that we've, I think, really pioneered is around detecting the abuse of very sophisticated mercenary spyware. This is technology that's marketed by firms to government law enforcement, intelligence agencies, in this case to infiltrate a target's device. And once inside a device, of course, it's highly revealing. They can find out, any communication, any email or text that have been exchanged, even those that are end-to-end encrypted, turn on the microphone, the camera, and so forth. And we've been doing this for many, many years. And it is one example of what we would call digital transnational repression. So transnational repression in the conventional sense, been around for a long time. It's basically about governments who reach across borders outside of their territorial jurisdiction to suppress dissent or chill political opposition abroad, usually these days involving refugees, immigrants, and others who have in many cases fled abroad for their safety to get out of the reach of those governments. And traditionally this has happened in many different ways. everything from targeted assassinations to abuse of Interpol red notices and other forms of harassment and intimidation. The digital component is really quite game-changing, I would say, for this area, and I think it does deserve a different category of its own. As I described with our research on spyware, what we're seeing is it's opened up all sorts of new opportunities for malicious actors to undertake surveillance or harass into silence people who are based abroad. So people think they leave their country, they're now in a country like Canada or maybe the United States, feel a bit more secure, and they find out, actually, no, I'm not, because the people that I have escaped are able to, in the case of mercenary spyware, actually get inside my device. And the latest, most sophisticated versions of this technology quite literally have no defense. So there is nothing a user can do to protect themselves from, for example, the latest version of Pegasus spyware manufactured by Israel-based NSO group. Going back many, many years, we started to recognize in the course of dealing with the victims of this type of surveillance that they were experiencing various forms of trauma, frankly. And we decided this is something that warrants further research. So we decided to set up a research project, a qualitative project, where we wanted to interview human subjects. And we're just about to publish a major report on this, where I and my team interviewed more than 80 individuals. This project has a particular focus on the gender-based dimensions of digital transnational repression. And what we've discovered is pretty consistent across these more than 80 individuals, regardless of the country that they have fled from or their particular experiences. They're very similar in terms of the effects that they have. Most importantly, a silencing effect. And it is really kind of common sense. So again and again, we're hearing from victims that whereas once, the internet was, like most people, kind of critical to their day-to-day life, or their mobile phone is essential for their activism, their advocacy, their professional life, whatever. Now, because of what they're experiencing, they're afraid to go online. They're unwilling to associate with members of their extended diaspora. They no longer have social media accounts. They've effectively been harassed into silence. And that's where I think the connection to the First Amendment really comes in here. We're clearly seeing in the course of these interviews the profound impact it's having on people's ability to associate and express themselves.
Thanks, Ron. So let me turn to Ashley, and then we're going to dive into each of these papers and areas. But Ashley, before we get to that, maybe you could tell us first, why and precisely how you lost the Wikimedia case. No, I'm just, no, more. So you've litigated cases in both of these areas, and I thought maybe we could start with, the context that Jaya's paper raises. You've litigated a case relating to CBP's discriminatory questioning of Muslim Americans at the border. Can you tell us about that litigation and what guidance it offers to optimists like me who think the First Amendment can play some role in regulating government authority at the border?
Sure, and thanks, Alex, and thanks to the Knight Institute for having me today. So at the ACLU, we are representing currently 3 Muslim Americans, U.S. citizens, who, when they come back to the U.S., come home from international travel, they are stopped at the border. Border officers take them into secondary inspection, and officers ask them questions like, how many times a day do you pray? Are you Muslim? Do you attend mosque? Are you Sunni or Shia? How religious do you consider yourself? These are questions that have absolutely no relationship to any legitimate objective that CBP could possibly assert. They are predicated on the false and harmful assumption that the practice of Islam is inherently suspect. We have a host of constitutional claims in this litigation. Most relevant here, we are arguing that these questions violate our client's right to free association because they're compelling disclosures about our clients' associations, about the mosque they attend, about whether they are Sunni or Shia. And those questions have to satisfy, under Supreme Court precedent, exacting scrutiny, which requires the government to show that the questions are narrowly tailored to an important objective. And the government can't meet that burden here. In addition, one of our clients was very clearly retaliated against for his protected beliefs and his speech invoking his rights at the border. He was carrying a religious journal, and as soon as the officers saw the religious journal, they began intensifying the scope of their search. They asked additional religious questions. The stop was extended. He was basically penalized for invoking his rights and for being Muslim. And during the first panel, there was some discussion of First Amendment retaliation. Again, this is a clear instance of retaliation against an individual for their protected beliefs and protected speech. So one of our arguments in this case is that the First Amendment applies at the border without exception. These are US citizens. I think that makes the argument even clearer. And the government hasn't really disputed that point. Now, the government has invoked its broad authority under the Fourth Amendment. There's a lot of very problematic language in a lot of cases about the government's authority at the border to search people. And there is a narrow exception to the Fourth Amendment's warrant requirement at the border. But there's no comparable exception in First Amendment doctrine. The First Amendment applies with full force, and the government really hasn't argued to the contrary. Unfortunately, the district court dismissed our case last year, but just this month, the Ninth Circuit Court of Appeals reinstated it, so we are moving forward to discovery. So there's a lot of reason for optimism and for hope here. Yeah.
Can you tell us about the Ninth Circuit decision, and does it, I don't know, does it give you hope that you'll win on the substantive question, or was it a procedural ruling?
Well, it was a very strange posture. So in the district court, the government made a host of arguments with respect to each of our constitutional claims, saying we hadn't stated a claim, and the district court unfortunately agreed with the government on that count. On appeal, the government's only argument essentially waived and abandoned its other arguments. Its only argument on appeal was that we had not shown a pattern or practice of discriminatory religious questioning, so it was a kind of procedural argument. And that was clearly not going to be a winning argument. We have 3 clients. They were subject to this questioning on 10 separate occasions. There's extensive documentation in government reports of dozens of other Muslim Americans being subjected to similar religious questioning at the border. So it was a clear case for us, and now the case will go forward.
Great. So let me turn back to Jaya for a minute, and but anybody can feel free to jump in on the question. I guess when I read your paper, one of the reactions I had was, it seemed to me that there was a fact pattern here that might present a great opportunity to, give a court a chance to articulate First Amendment protections that might actually do some good work. And I wonder, if you, in working with Nicole and hearing about the kinds of experiences that Al Otro Lado is experiencing at the border, could come up with that fact pattern, could come up with a test case to build the kind of First Amendment protections you want to see. What would that look like?
Yeah, it's a great question, and I think, the main thrust of my answer is just more clarity, right, about these questions about extraterritorial application, U.S. citizens, non-citizens, going through Mexican government officials, and the applicability to the provision of legal services or legal advice, know your rights information to undocumented migrants, right? So kind of that intersection. And so that's where it would be really helpful to see clarity. So, for example, a U.S. Supreme Court decision that clearly says the First Amendment applies abroad, right? So we have all of this contestation about that question. So Reed v. Covert tells us the Bill of Rights protects U.S. citizens abroad, but some speech falls outside those protections, right? A clear and direct threat to national security. And so that makes me concerned about these anti-smuggling statutes, right, from U.S. v. Phillips, and the framing of migrants as national security threats, and then kind of the unspoken role of race with respect to national security, right? Who's a national security threat? Oh, of course, it's these migrants trying to come in from Mexico. So it would be helpful to have some clarity there. And also, of course, the federal courts have found no First Amendment right of association or speech where the migrant has no underlying legal claim. But how far does that extend? It would be really helpful to understand what that is, because of course as lawyers, right, you're going to present that asylum claim even though you know that it's a 30 to 40% recognition rate. So does that mean they have no, who decides whether they have no legal claim? How far does that extend? And so I guess I would start by pushing for recognition of the right of US citizens to offer legal services to undocumented migrants outside the US. I think in terms of remedies, you want the litigation to change the practices of CBP, right? Which is a really, really hard nut to crack, right? So just thinking about training that can be implemented, consequences that can be implemented to try to shift the culture of the organization, right? Which I think you need to really think creatively about how litigation can do that, and then thinking about lawsuits against individual officials possibly, and the uphill battle against qualified immunity. Another place that I think would be helpful to see some clarity is collaboration with Mexican officials and how the First Amendment plays in there, right? There's a lot of obscuring what's happening, but right, thinking about whether the U.S. government is required to protect U.S. citizens' right to speech outside the U.S., or at least not to collude with foreign officials to limit their speech rights outside the U.S. And then, yeah, just thinking about through the battle between anti-smuggling statutes and the First Amendment, how to constrain the carceral approach to migration. And I will say that if I'm even less of an expert in the Fourth Amendment than the First Amendment, but I just want to note that the U.S. is making Mexico do its dirty work, right, by putting the names of border-alluring actors on this list, on this passport hole, so that it's the Mexican government who's detaining and deporting people, right? So also just thinking about all of that and how to get, so it's a lot of questions, and it's maybe not one litigation, right? But I think there are a lot of places where we could just use more clarity in the law, in a good direction, which is an awfully optimistic thing to hope for, I think.
Ashley, what do you think? Do you think that your litigation provides a framework for establishing some of the rights that Jaya is talking about?
Well, the litigation is on behalf of U.S. citizens. We do have an expungement claim, which is similar to the claim that was at issue in the Phillips litigation that you were discussing. That's not our only claim, though, in part because our plaintiffs can show that they're going to be subject to the questioning again. And I think that one of the challenges in these cases is that oftentimes it's clear that there has been historical government misconduct, but there are legal doctrines that make it very difficult to sue the government actors for their historical misconduct. And then if you're trying to alter training practices, if you're trying to get some kind of remedy going forward that would change the government's implementation of its policies, you have to show that the injury is ongoing, it's likely to recur, and then litigators have often relied on these expungement claims in cases where they can't necessarily show that they're going to be subject to the unlawful conduct again. They can say, but my information or my client's information is in a database, and the government's retention of the information in that database is an ongoing harm because the information was unlawfully collected, and it could be used against me in the future in all kinds of ways. And that in itself is an ongoing harm that merits a remedy that's forward-looking. But it can be very difficult, and the Ninth Circuit's ruling unfortunately narrows the set of circumstances in which those types of expungement claims are available to litigants.
Thanks. So let me turn back to Ron for a second. So Ron, I'm hoping we can focus on spyware for a second as one of the mechanisms of digital transnational repression that your paper discusses. And this actually aligns with one of the questions that just came through on the QR code. I'm hoping you tell us, answer a couple of questions. One is, to what extent has law been, and I'm mindful of your disavowal of legal knowledge, but to what extent has law been effective at holding the use of spyware, especially the abusive use of spyware, to account? And full disclosure, the Knight Institute is litigating a case against NSO Group on behalf of 18 members of a Salvadoran newsroom who were targeted using Pegasus spyware with the NSO Group's Spyware, based on the Citizen Labs investigation and in close collaboration with you all, technical expertise and consultation. So can you tell us a little bit about what you've seen internationally in efforts to hold the use of spyware accountable? And then I also want to just dig in a little bit to one thing you said. You said it emphatically, there is no defense, or that we have no defense against spyware. A lot of people will see a technical problem and look for a technical solution. And so from your vantage, you are a technical expert. Why isn't there a technical solution? Why isn't there more that we can expect from our phone manufacturers, from technologists defending against those kinds of attacks?
Yeah, those are both really good questions. So I may not be a lawyer, but I've been surrounded by lawyers for the last 10 years. I feel like I've gone through kind of law school by osmosis. Learned a lot too about litigation, and both the pros and the cons actually. And I can speak to it both in terms of holding companies accountable, but also as a research group like ours, some of the experiences that we've had being even a non-party to some of the litigation, but because of the work that we do is sometimes the evidentiary basis for some of the litigation that's going forward. We actually, for those who are interested, on the Citizen Lab website, we actually keep a updated list with links to as many of the documents as we can find of all of the cases of litigation involving not just NSO Group, but all of the other surveillance vendors that are in this space. I'd say the picture is a bit mixed. I think it's very important that victims have a pathway to justice and accountability, and typically that has to come through exercising some legal avenue of redress. The problem is, well, there are many problems. One is that often it's the case that the court will say, well, this is the wrong jurisdiction, or they can't demonstrate the harm occurred in this jurisdiction. There's that, and in some other cases, I think, we just had Apple announce that they're withdrawing their lawsuit, which is interesting. I can understand some of the justification that they made for it, but I know it's also disappointing for some people who want to hold that company responsible. I think what ultimately needs to happen, though, to really deal with this issue, and actually this is broader than just spyware, it has to do with digital transnational repression as a whole through social media, through the internet and other means, is to start building a suite of responses. And maybe in some cases, again, I'm not a lawyer, but I know some people have recommended that countries could pass legislation making it permissible or okay, whatever the language is, for someone to sue a foreign government in their jurisdiction. And I know there's been some promising developments in the United Kingdom around that, for example, recently in some cases involving the countries that were operating the spyware. Same could hold true around the manufacturers of the spyware. Perhaps I'll answer this in a later round, but maybe ironically, the United States government has actually gone the furthest in quite aggressively dealing with digital transnational repression. A variety of legislative, institutional, punitive measures have been taken, but at the heart of it, I think there's a contradiction and a tension, which we can talk about later. With respect to the technical question, look, there are a couple of things at work here. One is that we have highly paid, highly trained engineers who come from some of the world's most elite signals intelligence agencies. In the case of companies that are affiliated in one way or another, connected to Israel, these are veterans of Unit 8200, extremely talented engineers who have a lot of resources, and all they do all day is look for some exploit that they can use as an anchor to then implant spyware. That's against a digital ecosystem whose prominent characteristics are invasive by design and highly insecure. Security is largely an afterthought. The business model is to move fast and break things. And that's principally why you have this situation where the technology is advanced to such a level, the latest versions are known as zero-click. In the past, in order to activate spyware on someone's device, you'd have to trick them into opening an attachment or clicking on a link, and that would activate the exploit. Now that's not necessary at all. You can fire an exploit at any device anywhere in the world, and because the manufacturers of the operating systems of those devices are not aware of the vulnerabilities that are being exploited in those systems, they're sitting ducks. So, you don't need to take my word for it. If you look at the latest version of Pegasus that we at the Citizen Lab captured and did a responsible disclosure to Apple and Google, both of them came out and said, while this was active, there was literally nothing anyone could do to fix the problem.
Do you have any hope that we would, at some point, end up in an ecosystem that is capable of protecting users from those sorts of threats, or do you think that that there's something inherent to the cat and mouse game of digital offense versus digital defense that always favors the attacker, or the economic incentive?
It's a kind of systemic feature of the landscape. It's going to be very difficult to reverse. For example, what I describe about the ecosystem being invasive by design and highly insecure. Those are not just surface characteristics. That's a representation of the business model of social media, of surveillance capitalism. So, you need to fix that before you could fix the underlying problem. It's very daunting to think about fixing that. However, it's not entirely bleak either. I think, again, the United States has actually led the way in holding accountable firms that are associated with digital transnational repression or human rights abuses through sanctions. NSO Group, a variety of other firms that we and others have uncovered have been put on the designated entity list. Individuals have been sanctioned. That's like, I wouldn't have believed that 3 years ago that would have been possible, and now it's happening. And there are at least normative guidelines. There's I would say a regime that's starting to develop internationally. 21 governments have pledged to do something similar to the United States. None of them have. We hope they will. But those are promising small steps, I think. So we shouldn't get discouraged by the seeming futility of the big picture. There are little things that we could do to help in the meanwhile.
So I want to turn back to Ashley for a second. One of the arguments that NSO has made in all of the lawsuits that have been filed, I think all of the lawsuits that have been filed in U.S. court against it, at least 2 of the 3, is that these are cases that don't belong in U.S. court. They belong perhaps in Israeli court where NSO is based, or they belong in the courts of the jurisdictions where the victims live. I'm not aware of anyone trying to sue NSO in Israel, but imagine a parallel suit here. Imagine that it was a foreign victim of U.S. Surveillance by, say, the U.S. government or U.S. government implicated surveillance. We're trying to hold the U.S. government accountable for that kind of sophisticated technological surveillance. We don't have an example quite of the U.S. government's use of spyware, but we do have your litigation against the NSA. Can you tell us a bit about how hopeful you would be for the prospect of law being a meaningful mechanism of accountability? I mean, maybe you can start by telling us about the Wikimedia case that we've alluded to a couple of times today, how that turned out, and whether there's any, whether you have hope for the next case turning out differently.
Well, I think in your hypo, the plaintiff would be a foreign person. Is that right?
Yes, but let's suppose you can get over that. Get over that part.
Okay.
And suppose they have rights to assert in a U.S. court.
Yes, if they have rights to assert in a U.S. court, I do have some hope, but litigation is uphill for the reasons I will explain. In 2015, the ACLU, later joined by the Knight First Amendment Institute, brought suit on behalf of journalists, human rights workers, lawyers, and Wikimedia, which hosts Wikipedia, everyone's favorite internet encyclopedia. And this was a suit challenging a form of warrantless NSA surveillance of Americans' international communications. Unfortunately, Catherine spoiled the ending here. The suit was, and Alex at the beginning of the panel, the suit was not successful. We litigated for 8 years. We did not prevail, and this surveillance continues under an authority known as Section 702 of the Foreign Intelligence Surveillance Act, or FISA. And to understand why this surveillance is so pernicious, why it's so controversial, it is helpful to have a little bit of historical background. So just very briefly, For decades, when the US government wanted to conduct foreign intelligence surveillance on US soil, even when it was targeting someone who was a foreigner abroad, it had to go to a secret court known as the Foreign Intelligence Surveillance Court, and it had to make a showing that its target was a foreign power or an agent of a foreign power. Now, after 9/11, the Bush administration just ignored these rules, blatantly violated the statute, violated constitutional rights, engaged in widespread warrantless wiretapping, other forms of warrantless surveillance. When this came to light, there was significant public outcry, and the Bush administration tried to put this warrantless surveillance on more of a legal footing. And one way in which it did that was to lobby Congress for the authority that became Section 702. Under Section 702, targets no longer need to be agents of a foreign power. The executive branch can target any non-US person abroad to collect foreign intelligence information, which is defined to encompass even information about the foreign affairs of the United States. There's no longer judicial review of targets, and even if there were, the standard is so low it would be effectively meaningless. Targets do not need to be suspected terrorists. They don't need to be suspected of any criminal wrongdoing. They can be academics, human rights workers, journalists, any ordinary person who's a non-US person located abroad. And at last count, there were more than 268,000 of these targets. They, of course, communicate with Americans. So the NSA, under Section 702, can capture all of these targets' communications, including their communications with Americans, without getting a warrant. And in the Wikimedia case, there were significant First Amendment harms to our clients. People who worked for NGOs were self-censoring in their conversations in ways that made it difficult for them to do their jobs. We represented lawyers who were having to make additional trips abroad to speak with witnesses and clients in person because they were concerned about their ethical obligations of confidentiality and concerned about the prospect of Section 702 surveillance of their communications. And for Wikimedia, we had empirical evidence that after the Snowden disclosures, after the public learned about the full scope of Section 702 surveillance, people were not reading terrorism-related Wikipedia pages. Catherine talked about the one example of someone she was connected with who described this for them personally. We had empirical evidence showing that this was happening at scale. There was a significant and sustained drop in readership of terrorism-related Wikipedia pages, in addition to a lot of anecdotal evidence where people were saying, I'm reluctant to edit these pages. I'm very concerned about Section 702 surveillance. I'm not engaging with the site in the way that I used to. And when you are talking about the world's largest encyclopedia, this enormous repository of human knowledge, that is a very real loss and a very real harm. But even with that harm, after years of litigation, the courts did not allow our case to proceed. It was ultimately dismissed on secrecy grounds. The Fourth Circuit accepted the government's argument that it could, in theory, have secret evidence that would defeat Wikimedia's standing showing. And in 2023, the Supreme Court declined to hear the case. So that was the end of the road for this litigation. I think one of the lessons here, again, is that litigation is uphill. It's not impossible, but elections matter, political mobilization matters, legislative reform matters, and elections matter because they affect the composition of the judiciary. But I think there's still some reason for optimism. Wikimedia 2.0. We continue to litigate in challenges to foreign intelligence surveillance, including in criminal cases, and that's part of the work that we do. But this case, it did have a disappointing ending.
I want to come back to that. Let me go to Jaya for a second. Actually, let me just come down the line. So if it turns out at the end of the day, and I'm too much of an optimist to give hope, for the law as at some point constituting an effective constraint on the practices that we're all concerned about. But if it turns out that law is not going to be, at the very least, sufficient, what would you like to see? So Jaya, for you, for border lawyering, what would you like to see if not clear legal constraints on CBP authority? What would you like to see? And Ron, what's a framework for regulation of spyware that you would like to see? I know many people have called for a moratorium because they don't believe in the ability of, or an outright ban because they're not confident that we could come up with a framework that would meaningfully constrain spyware. And Ash, if you were allowed into court, what would, if you could design law that would get you around the problems that you faced so far, what would that look like?
Yeah, great. Thanks so much. And I think I'm going to echo Ashley a little bit here. And I'm, with all due respect to the litigators in the room who do amazing things, I think litigation is not, even if litigation is successful, it's not the only answer, because I'm not a First Amendment scholar, but I spent a lot of time studying CBP, and that, I think litigation alone is not going to solve this problem. And so in terms of effectiveness and reality, to Ash's point, I think a lot depends on who is in office. And so if we're thinking about what's happening in Mexico, is Sheinbaum going to be an improvement on AMLO? Like, we'll see whether she is less willing to have her INM officers engage in the kind of behavior that happened under Lopez Obrador. I think there's another election happening somewhere. Someone mentioned that. I'm trying to pretend it's not happening. But no matter the outcome of the US election, undocumented migrants are just going to continue to be the target of vitriol and repression. So we really do need to think about political and cultural angles in addition to litigation strategies. So, as I said before, the culture of CBP is a real problem, right, dating back to 2003 when INS was broken up into the enforcement and benefit arms. It's now a real culture of enforcement that I find terrifying. The more I learn about it, the scarier I find. So short of abolition, I think what we need is some serious First Amendment training of officers, right? That's why I talked about training, because people need to get in there and start changing the culture. And they also need to take that training seriously and understand that they're going to face consequences. And I think that's going to be pretty difficult based on what I know of the culture of CBP. It's really, litigation's an uphill battle, so is politics, right? So international law, right? If we're thinking about international law as a solution, it doesn't have a lot of teeth in terms of enforcement, but it can be used to name and shame, right? That could be useful for its expressive function, maybe a special rapporteur on transnational digital repression, or, the UN Human Rights Committee, right, could clarify that they think that border lawyering activities are protected under Article 19, right? There are a bunch of different routes you could take using international law to clarify the law, to issue reports, right? And also when it comes to Mexico, the Inter-American human rights system, right, their government actually pays attention to it, unlike ours. So that's a potential route, and involves shaming by, some of its peer nations. And so, whether or not they take that as seriously as pressure from the US, we'll see, but it's one way to go. And then I think we just need to think creatively about what are the other levers, both on the governments and on companies, right? So thinking both about, some of these companies producing spyware, maybe there aren't any levers, but maybe some of the other companies in Silicon Valley, right, are there roles that the corporate world can play in preventing this mass surveillance, right? What else can be done on kind of the technical side, as you were asking Ron earlier?
So I'll just pick up and first address the question of a ban or a moratorium on spyware. I respect a lot of my colleagues and some of the organizations that are advocating for a ban, but I come from an arms control background, and one thing I'm very wary of are rhetorical calls for something like a moratorium or ban when there really is no viable verification mechanism. And I think that's definitely the case in this area. It'd be simply impossible to have states agree to this in any meaningful sense. And furthermore, there's a risk it would drive a lot of the technological innovation further underground, making it yet more difficult to verify, which is why I think personally the focus should be on slightly lower level measures that are more practical and realistic. The problem here is, I'll be frank, it's pretty grim. Regulating this space is extremely challenging. I would say there are two inherent conflicts of interest in this space for virtually every government. One is, it gets to what Ashley was talking about with Section 702, which is that as much as, for example, the United States has really led the way in terms of all of these initiatives around digital transnational repression for victims in the United States, it has this posture internationally. So there's a obvious contradiction and perhaps a limit to how far they could go. The second is that virtually every government, and especially the United States, has a dog in this race, so to speak. Every government has well-resourced national security agencies, signals intelligence agencies that want to be very well-equipped. A lot of them have enormous outsized influence within their government bureaucracies. They can invoke the risks of national security to squelch a lot of measures to constrain what they're doing or bring more transparency and accountability. For example, I'll give you from Canada. In the United States, I think interesting measure, an executive order from the Biden administration around this topic was put forward, and part of it has to do with identifying companies that are violators of human rights abuses abroad or present a risk to national security. That's quite a remarkable thing coming from the United States. You don't even need to show that a foreign government used spyware even to engage in domestic repression. It's enough that the firm sold to that particular country that has a bad human rights track record. However, Canada, which has signed on to this statement, has done nothing of the sort. And they're completely opaque about our own law enforcement and intelligence agencies' use of spyware. There's zero transparency in my country. It's very old school British culture of intelligence, which is basically, no one should ask us any questions about what we're doing because you can trust us. Well, that's not the world that I would like to live in. I mean, ideally, you'd want to see states follow and be guided by a framework that comes from international human rights law. But we're a long way from there, obviously. So I think the challenge is to find little bits and pieces where you can move things forward, and that has to come from governments, from civil society, and from technology platforms.
Let me just follow up on one question for you, Ron. So, and this, dovetails with a question that we got through the QR code too. Your paper gestures at the possibility that international law might impose an obligation, or might be understood to impose an obligation on states to protect their own citizens from digital transnational repression originating from abroad. Now, that may not be effective for a lot of states, depending on which state you're talking about and their ability to, influence the behavior of other states. But say you're talking about the U.S., is there a meaningful possibility that that obligation could actually improve the situation, could actually protect people from these sorts of abuses, or, to your earlier point, if there's an attacker willing to deploy the spyware, there's nothing that can be done, and no matter what the political pressure happens to be.
Well, it feels to me like what's going on in the United States now around digital transnational repression is a bit like what was happening around disinformation a few years ago after the 2016 election and the pandemic. There was a lot of attention to the subject, and a lot of initiatives were happening, some good, some bad. Right now, transnational repression is very au courant, and there's a lot happening. I do think, however, there is this contradiction in principle and practice in the United States, and that presents a limit until that changes to how far things could go addressing it. But clearly there are a lot of people who buy into the argument that they have an obligation to protect people. Notice the language though. So for example, right now, I'm sure people have been following this, Canada is involved in a very serious diplomatic dispute with India. And this has to do with the murder of a Sikh separatist in Canada, organized by India and undertaken, by the way, with subcontracting to organized criminal groups. So, a clear case of transnational repression, undoubtedly digital transnational repression as well. But in taking the action that the Prime Minister has taken, the language that's used is very much about a violation of sovereignty, violation of Canada's territory, not human rights. Last thing I'll say about this, as much as I think it's it's good what is happening, the responses that are taken, the government being vocal about it. Back in 2018, we at the Citizen Lab discovered that a Saudi permanent resident, Omar Abdulaziz, had his phone hacked by Saudi Arabia with Pegasus spyware. We published our report on October 1st. Very next day, Jamal Khashoggi, his close confidant, was murdered. There was not a peep from the Canadian government about that at all. And it was so disappointing to me. If you don't condemn that sort of thing, you're actually inviting it, was my view. And here we are, many years later, and somebody is assassinated in Canada. I think my view is that governments, at the very least, should be speaking out and condemning this sort of activity.
Ashley?
So I think the question earlier had to do with what I'd like to be able to argue on the merits in court. And so speaking from a US constitutional perspective and starting with the First Amendment, for surveillance activities that are capturing information of people in the United States, information and communications of people in the United States or Americans abroad, if those surveillance activities are undertaken in retaliation for the exercise of First Amendment rights, like described in your paper and everything that's happened with El Otro Lado, that's categorically unlawful, period. If the surveillance activities are undertaken and in the service of viewpoint discrimination, if they're fundamentally about discriminating against people on the basis of the content of their speech, those activities should be subject to extremely strict scrutiny. Now, if the government is using surveillance to collect information about people's protected associations, that surveillance needs to be subject to exacting scrutiny, which is a little looser than strict, but still requires there to be real narrow tailoring. That the surveillance needs to be tailored narrowly to the government's objective in collecting this information. And then finally, regardless of what the government's actually collecting through its surveillance, if the surveillance is chilling American speech, if it's chilling the speech of people in the United States, at a minimum, it should be subject to intermediate scrutiny, which requires a means-ends fit that just isn't there when it comes to Section 702 surveillance and other forms of foreign intelligence surveillance. And then more broadly, we've been talking a bit about international human rights standards. The Biden administration has put forward some very modest reforms in recent years, including the adoption of a partial necessity and proportionality test in its signals intelligence activities. It does not go far enough. And of course, the document setting forth this test says that this document does not create any rights enforceable in court. But I would like to be able to argue that the government's surveillance activities, even when they're not directly implicating the rights of people inside the US or Americans abroad, still need to be necessary and proportionate.
I want to ask you one more question, Ashley, but I'm going to, we have about 15 minutes left, so if folks have questions and want to come to the mic, feel free to line up. While folks are doing that, let me just ask you one additional question. So there was a sense, especially in the conversation between Jamil and Catherine, after Catherine spoke, that part of the problem, at least when it comes to digital transnational repression, to the ability of actors to reach across borders to abuse human rights, stems from the interconnectedness of our digital world. It's a feature of this globalization, which I think is why Catherine paused when Jamil asked her whether our globalized public discourse is a good thing. But there are some activists who you've worked with in the European Union who are trying to leverage that interconnectedness as a way of applying European notions of privacy, which tend to be more protective here in the United States. So I wonder whether you could tell us about that, and also tell us whether you think that's going to be effective, whether you think that's a promising avenue for importing some more rights protective regime into the United States.
I like that we can continue on this theme of optimism tempered by harsh reality, but optimism survives nonetheless. So yes, it's true. There are Europeans who have really flipped the script or turned the tables on the downsides and the the risks associated with this increase in globalization and interconnectedness, which of course is an avenue for transnational digital repression and some of our worst instincts as human beings, but also is a way in which to pressure the US government to enact surveillance reform. So Max Schrems is a great example of this phenomenon of an activist working in the European Union. He's an Austrian privacy activist. And for context here, under EU law, when companies in Europe want to send large volumes of personal data to the United States or outside of the European Union, it's incredibly cumbersome. It's costly, it's difficult, EU law makes it challenging. So in the late 1990s, to facilitate these large-scale data transfers, which are important to our globalized economy, the EU and the US negotiated a special agreement. And that agreement was predicated on the idea that the US provides an essentially equivalent level of protection for Europeans as the EU. This is obviously false. And after the Snowden disclosures, it was very obvious that it was false. And so after the Snowden disclosures, Max Schrems brought a lawsuit against Facebook in which he challenged this special agreement under EU law. It went up to the EU's highest court, which struck down the agreement, said, this doesn't look quite right. And so then the US and the EU went back to the negotiating table. The US made some completely cosmetic changes, negotiated a new agreement. Max Schrems brought another lawsuit. I provided expert testimony in that lawsuit with the assistance of my ACLU colleagues, including Patrick Toomey, who's here today. And that case went back up to the EU's highest court. It again struck down the special agreement, finding that US law did not adequately protect the rights of Europeans. So after that, the Biden administration's really in a bind here because they're not about to unilaterally, radically reform US surveillance law. Congress didn't seem to have much appetite for extending rights to non-US citizens. But what the Biden administration did was put forward the policy that I referenced earlier. It incorporated a version of a necessity and proportionality standard into an executive order governing the acquisition of intelligence, signals intelligence. And it also created a data protection review court in an effort to make the Europeans happy. Now, this third iteration of the agreement is currently being litigated. It remains to be seen what will happen, but Max's efforts did lead to some reforms here on the US front.
Great. So I think we have a couple of questions at the mic. Go for it.
Thank you, Alex, for taking questions from the bullpen. This is really towards Jaya and Ashley a little bit. You guys have brought up sort of CBP, and to you, Ron, as a Canadian. You guys have brought up CBP.
Thank you.
No problem. Welcome. And, sort of at the border, I know you had brought up some of your clients being questioned. About a year ago, my organization, the Black Alliance for Just Immigration and the American Immigration Council, came out with a report about CBP being at George Floyd protest. I think they were in 18 cities, aerial surveillance, and sort of being involved in these protests. So I was wondering if you guys could speak a little bit to CBP's sort of mission creep, right? Protests are, supposedly protected by the First Amendment. Being involved in these type of activities, particularly when it comes down to citizens and non-citizens sort of, expressing the First Amendment right.
Yeah, thank you. It's a great question, and part of the reason I say, the more I study CBP, the more I find it terrifying, and the more you see the stakes of this election in particular, I think, because, it's not, unfortunately, a surprise to me or anyone who's a student of history that the militarization of the border is going to creep into the interior, and it's going to affect both non-citizens who are protesting George Floyd and citizens who are protesting the war in Gaza, right? So it kind of comes full circle now. I don't know that CBP has been at these protests per se, but it is very concerning, kind of relates to the question that was brought before the first panel about, and I appreciate it, Alina and Ahilan, the responses you gave to that, about what best practices might look like at universities for students involved in the protest, but there we have a very real challenge, right, where the terms of your visa depend on you being enrolled in school, and if you are suspended for being engaged in protests, right? That right is going to be gone. So I think, the intersection of immigration and the right to speak is very concerning. And I think I am worried, given the plans that are being expounded in the 2025 plan about what that means if we're going to deport all the undocumented immigrants in the country, and we're thinking about the expansion of CBP in the interior. What that means both for people's physical security, but also for the expression of First Amendment rights for anyone who's a non-citizen, anyone who looks like or sounds like they could be a and I say that with scare quotes, right? Could be a non-citizen. So yeah, the mission creep is very concerning, and I offer culture change, but I don't know that that's enough, and I don't know that that's possible.
Great. So we'll take one more question from the mic, and I have another question that came through on the QR code. We'll take those two, and then we'll be at just about time. But please go ahead.
Yeah, I'm just. I've heard something that kind of made me, well, I won't say awake, but a couple of things. Someone mentioned that the hope for the future is in the change of the composition of the courts, which implies that judges do not really follow the law, but follow their own inclination. And furthermore, there was this mention of different kinds of scrutiny, strict scrutiny, intermediate scrutiny. I know that the reasonableness test is usually called by lawyers a mirror test, where if you stand in front of a mirror and manage, after you delivered your argument, to not fall down laughing, then it passed. So the problem seems to me, the number one problem is with the courts and with the real absence of due process when it comes to judicial decision-making process. My personal experience is that judges simply replace parties' argument with their own completely bogus argument to decide cases the way they want to. And I sued a bunch of federal judges for fraud, and their argument is that in a case known as Pearson against Ray, judges gave themselves the immunity in cases when they act from the bench, quote unquote, maliciously and corruptly. So they do a run around the due process. In effect, we are proud of having due process, but we delegate its exercise to people who are not obligated, or say they're not obligated to follow due process. And this way, judging is arbitrary, and that is why you cannot really get anything in the courts. You have to march in the streets, and etc. So my question is really about the press. The press really refuses to look at how courts operate. There is really, it must have been 1,000 journalists that I've talked to, and they all say, no, if it comes to judges, this is a branch of a government we're not going to talk about. They talk about two branches of government, but not about judiciary. So isn't the problem, the root problem is how judiciary operates, that it is not bound by due process?
It's people all the way down. Let me offer one reflection on this question, and then maybe turn it over to Ashley. So it's interesting to note how in a number of important cases, either in this area or in closely related areas where you're dealing with national security, a flip of one vote could have actually made a pretty significant difference. So, the case that was mentioned that Jamil litigated up to the Supreme Court, that resulted in a decision a few months before the Snowden disclosures, Amnesty versus Clapper, was a 5-4 decision on standing. And so, if one justice had voted the other way, and there was good reason to think at the oral argument that it might have come out the other way, if one justice had voted the other way, we might have had a different rule on when challenges could be brought against secret surveillance programs, and maybe even surveillance programs that relied on sophisticated spyware. So Ashley, if Clapper had come out differently, would your world be different? Ron, would you have more hope in the courts to adjudicate these kinds of cases? Or would we still be dealing with the issue that you later ran into in the Wikimedia case with state secrets? Would that have been the next hurdle? You would have cleared the first hurdle, but there would have been another one just ahead that would have tripped you up.
No, it's a great question. I like this counterfactual. I do think things would be very different if one vote had flipped in the amnesty case. State secrets would still be a hurdle. In the Wikimedia context, though, it was kind of the nexus of the two. It was the state secrets and standing question. But even if standing hadn't been in the picture, would state secrets have been a hurdle? Yes, but again, hard to say. Things would be different. I think the First Amendment basis for standing might have changed things too, and maybe there would have been a focus on the First Amendment claims absent the state secrets privilege. But I do want to underscore, I don't think that judging is entirely arbitrary, and especially in this space, the way courts approach surveillance issues does not fall neatly down partisan lines.
Well, if Clapper had come out differently, at the very least, the civil procedure bar wouldn't be mad at Jamil. So the last question comes from a digital submission, and this one for Jaya. So the question, I think, has to do with the way in which the government characterizes the work of Al Otro Lado. I think the question is asked whether the difficult issue is that the government thinks it can surveil their work because they believe that by providing information to migrants or facilitating the circumvention of the immigration laws. Whereas in reality, they're providing legal counsel, and if that narrative were more widely accepted, either within government or by courts, maybe the legal case would be stronger, the First Amendment case would be stronger. Do you think that's right, and how can that case be made?
Yeah, I mean, I would agree with that characterization, and it's the problem that I was referring to before. I come at this from a migration angle, and the smuggling and trafficking laws that come from international law just take a carceral approach to migration. So everything gets painted with this very broad brush, and certainly there are bad actors who, engage in violence against migrants and others. But what it means is that facilitation of movement can also be brought under that brush and characterized, right, as being engaged in illegal activity. And that's also when you invoke the government might be able to invoke this national security exception to the First Amendment. So that's of real concern, and certainly part of the solution is convincing the government, and frankly, I don't know that the Harris administration is going to buy into that any more than the Trump administration from what we've seen so far. And also the general public, right? Because I think, right, there's this feeling that, these people on the border, right, they shouldn't be coming in when actually many of them have a legal right to come in and have their asylum claim heard and determine whether or not they're allowed to stay. But that is really a challenge that we're facing right now, I think, as immigrants' rights advocates. Like, how do you get that message out that this is about enabling people to find safety and freedom, right? Isn't that what we're supposed to be about as a nation? Enabling people to find a country where they can come and express their political opinions freely, where they can engage in dialogue with other people, and not fear violent retribution. So, on that cheery note.
On that aspirational note, let's end. Please join me in thanking our panelists, especially Ron for hazarding the U.S. border to make it here today.
Thanks, everyone. We're going to take one more short break, and then we'll be back here at 3 for our last panel of the day.
the lapel, so when I usually have the option, I always get the...
Hi, everyone. If you could please take your seats, we're going to get started. Okay. Thanks so much. I'm Katie Glenn Bass. I'm the research director at the Knight Institute. Thank you all for spending your day with us, and thanks to those of you who have been watching the live stream online as well. Our last panel today is on protecting the right to receive ideas from abroad. So a number of the panel discussions today have referenced the listener's rights, so the rights to receive information from others, in this case from abroad. And we're going to dig in on that. We're going to hear more about the history of those rights, some of the foundational cases that sort of form those concepts. Because as others have pointed out, listeners' rights are both very important for some of the battles that we are having these days over forms of information, and they're also actually quite well grounded in the case law, even though they don't often feature in mainstream discussions of the First Amendment, which are often framed as the right of a speaker to speak. So we'll hear a little more about the listener side of the equation, and we'll talk about how the US government has viewed foreign speech in the past, how it should view that speech. And we'll be looking both at the Cold War context that we're going to hear about in a few different papers, as well as current debates over things like the TikTok ban and how we should respond to disinformation campaigns run by foreign actors. And finally, we'll also be talking about the particular value that foreign speech can have in terms of enriching US public discourse and debate and facilitating our ability to self-govern. I have a really great lineup here to discuss this with us. So starting from farthest away, Chinmay Arun is a research scholar and the executive director of the Information Society Project at Yale Law School. Next to her is Nick Robinson, who is a senior legal advisor at the International Center for Not-for-Profit Law, where he manages the US program. Next to him is Sam Lebovic, who is a historian of US politics, culture, civil liberties, and foreign relations, and a former senior visiting research scholar at the Knight Institute. And then next to me is my colleague, George Wang, who is a staff attorney at the Knight First Amendment Institute. Thank you all for being here. Thank you for writing papers. We have 3 great papers that were written for this symposium that we'll be discussing and connecting to the broader context we've been discussing today. I'm going to begin by asking George to briefly present his paper, Listeners' Rights in the Time of Propaganda, the story of Lamont versus Postmaster General, which is an in-depth exploration of the history of that case, whose significance George will explain for us. And just to brag a little bit on George's behalf, George did some really fantastic archival research for this piece. He is probably now the world's leading expert on the archives of Corliss Lamont, who is the plaintiff. So George, tell us about Lamont.
Thank you, Katie, and thank you everyone for being here. Good afternoon. So my paper, as Katie mentioned, tells the story of Lamont versus Postmaster General, which has been mentioned a few times at various panels already during the day. Lamont is this fascinating case from the 60s, decided during the height of the Cold War, which invalidated a federal law barring Americans from receiving communist political propaganda from abroad unless they requested that it be delivered. The story of Lamont is one of the vital importance of listeners in the constellation of interests safeguarded by the First Amendment. It firmly established for the first time that the First Amendment protects the right of the public to receive information and ideas from abroad, even when the government deems that material subversive and un-American. Incidentally, Lamont was also the very first time the Supreme Court struck down an act of Congress on First Amendment grounds. So with how I'm speaking about Lamont right now, you might imagine that this is a landmark case that is the cornerstone of our First Amendment doctrine. Yet for all of its apparent significance, Lamont is largely an overlooked and underappreciated precedent. Although the Supreme Court has at this point recognized the rights of listeners as important to the First Amendment repeatedly, Lamont itself has not spawned a robust right to hear and know from foreign sources, as Sam may well talk about in a moment. So the goal of my paper is not just to tell the gripping tale of how the Lamont case came to be, but to give Lamont the recognition it deserves as one of the court's most important First Amendment decisions. So I want to spend the rest of my opening remarks just giving a brief history of Lamont, and hopefully over the course of our panel discussion kind of talk about a couple of the other pieces of my paper as well. But let's just jump right into it. So Lamont involved the challenge to Section 305 of the Postal Service and Federal Employees Salary Act of 1962. The law directed the Postmaster General to intercept and detain foreign mail that was determined by the government to be communist political propaganda. It provided that the intended recipients of the mail would be notified of such matter had been received, but the mail would only be delivered upon the addressee's request. So this is where our protagonist, Dr. Corliss Lamont, enters the picture. One late July day in 1963, Lamont receives a notice in the mail from the post office informing him that it had intercepted and detained a copy of the Peking Review number 12 that had been addressed to the small publishing company that he ran. The notice was sent pursuant to Section 305, and it informed Lamont that the magazine, which was an English language periodical published by the Chinese government, was communist political propaganda. And it gave Lamont a choice. He could return an included reply card indicating that he desired delivery of that magazine, or the magazine would be destroyed. So rather than do any of these things, Lamont decides to bring suit instead and challenge Section 305 as unconstitutional under the First Amendment. So let me say a few words about Lamont the man before diving into Lamont the case. Lamont is really a fascinating figure. He was a philosopher and professor, born to a prominent New York banker and educated at Phillips Exeter and Harvard. So in short, he was, a kind of privileged rich guy. And there's very little about Lamont's background that would suggest that he would become this kind of, patron saint for radical causes. But that's what he did. He was a longtime director of the ACLU and then a longtime leader of the Emergency Civil Liberties Committee. And by the time he had filed this lawsuit against the Postmaster General, Lamont had already tangled with the State Department, the FBI, which Lamont called the Federal Bureau of Idiots, the House Un-American Activities Committee, and even Senator Joseph McCarthy. And he did all of this while summering in Maine. Okay, so Lamont files suit, and the case eventually reaches the Supreme Court. And it's worth pausing here to underscore what was so unique about the circumstances giving rise to Lamont's case. Lamont's complaint did not allege that the government had done anything to prevent him from writing or otherwise expressing his views, and nothing about Section 305, the law, purported to prevent Lamont from saying anything he wished. Rather, the only speakers whose activities were subject to the law were foreign entities, for instance, the Chinese agency that published the Peking Review. And as we discussed this morning, there are some serious questions about whether these speakers from abroad even possess First Amendment rights to assert. So instead, what remained for the court to consider was the fairly novel contention that the First Amendment protected Lamont's right to receive information independent of any speaker's right to speak. The court hears the case on April 26, 1965, and a little less than a month later issues its opinion, and it's unanimous. All the justices who participated in the decision agreed that Section 305 was unconstitutional. So Justice Douglas was assigned to write for the court, and Justice Douglas's majority opinion was, equal parts, I would say, revelatory as well as cryptic. Even as his opinion engaged in these really fundamental ideas about who and what the First Amendment protects, it was also vague and pretty difficult to parse. So, for instance, Douglas wrote that the law reflected an impermissible attempt by the government to control the flow of ideas to the public that was at war with the uninhibited, robust, and wide-open debate and discussion that are contemplated by the First Amendment. But he did very little to explain the nature of the underlying interest at stake, or to make any philosophical or doctrinal case for why and how the First Amendment protects the rights of listeners. Justice Brennan did a little bit better in a concurring opinion. Brennan's concurrence more explicitly drew out the logic that was missing from Douglas's majority. He explained that the key question before the court was the scope of addressee's right to receive information and ideas from abroad, although he acknowledged that the First Amendment contains no specific guarantee of access to publications. Brennan reasoned that the right to receive publications was nonetheless a, quote, fundamental right. He wrote that the dissemination of ideas can accomplish nothing if otherwise willing addressees are not free to receive and consider them. In other words, it would be a barren marketplace of ideas that had only sellers and no buyers. Thus, even if foreign speakers lacked any right to speak under the First Amendment, the American public had a right to listen to and consider what these speakers had to say. I'll say, despite the status of Brennan's opinion as a concurrence, it's actually not at all clear that Douglas disagreed with Brennan. In a memo from Douglas to Brennan prior to the publication of the opinion, Douglas professed that he liked Brennan's opinion very much and asked whether there's anything in his own opinion that stands in the way of Brennan joining it, noting that he would be very happy to circulate the necessary revision in order to accommodate Brennan's needs. Unfortunately, there was no recorded response from Brennan, and Douglas's opinion went to the printer largely unchanged from its original formulation. So, despite the fact that Douglas's language in Lamont is maybe a little muddy, the principle at the heart of the decision is actually quite clear. The court's ruling powerfully recognized, in a time of deep uncertainty and distrust, that preserving the free flow of ideas across borders is vital to maintaining a robust democracy. And Lamont stands for this idea that the First Amendment does not just protect the rights of speakers to speak, but also the rights of the public to listen and to learn about the world. And it turns out that nugget of truth is as important now in the digital age as it was during the Cold War. And with that, I'll turn it over.
Thank you, George. So I want to follow up on something that you just said, which is the government may not interfere with the free flow of ideas, because this was striking to me in their decision and in this paper. Because the government, one of their arguments was, well, we're not preventing people from receiving this information. They just have to tell us that they want it. And that's not satisfactory to the court. Can you talk a little bit about that, both the ways the government tried to evade this sort of constitutional review, but then also why the court wasn't satisfied by their arguments?
Yeah, that was a really interesting part of the development of the case. So, one thing to know about the law, this 1962 law, was actually it was an attempt to legislatively revive this practice that began in the 50s of mail interception on an administrative basis. And that program was ended by President Kennedy when he took office in 61. And so it was really this attempt to bring it back. And all through that time that this administrative program was running, there were attempts to challenge it on First Amendment grounds. But what the government did in each of these cases was to, once a lawsuit was filed, the government would get in touch and say, okay, well, we'll just send you your mail from now on. So now the case is moot, and please dismiss the case. And no challenge really successfully got there. And that happened in Lamont's case as well. He files suit. His lawyer gets this letter that's like, okay, well, we're going to add your information to this list, and we're going to send along your information from now on. So please voluntarily dismiss the case, because obviously it's moot, right? But Lamont's lawyer, Leonard Boudin, a wonderful, famous leftist lawyer, says, he decides to amend the complaint to add this idea that, the very keeping of this list also is a burden on Lamont's right. This ultimately, by the time it gets to the Supreme Court, actually the post office decides to change policy again. It sees the First Amendment weakness of this keeping of lists, a keeping of lists of people who want communist propaganda. They see that it's vulnerable under the First Amendment, and so they change policy again and say, okay, we're not going to keep the lists anymore. And so really there were all of these ways that they were trying to dodge it. And the main thing that the court looks at is, it kind of doesn't matter what the mechanism is. The important thing is that it's a burden on these individuals' rights to receive information that they want, information that they need to be democratically engaged citizens.
Great, so one more question for you, and then I'm going to bring Sam in. You noted that this case hasn't necessarily gotten the attention from the courts or from the public that you would expect it to merit. You would think that it's a really foundational cornerstone of First Amendment law. But as you note, it is not heavily cited in future court cases, and it's not necessarily a big part of the public conversation either. Why do you think that is? And what do you think might change if it did have a more significant place?
Yeah, I think it's unfortunate. And, you know, I think there are a couple of reasons. One of them is, as I mentioned before, Justice Douglas's majority opinion, while I think is really great on principle and right, is somewhat vague and confusing, and as I said, doesn't really provide that theoretical kind of heft to why it's important to protect the rights of listeners. I think another reason is, you know, this case has been mentioned before, but the case of Kleindienst versus Mandel, which, you know, really relied on the logic in Lamont, but in Kleindienst, the government decides that the plenary power doctrine, the government's plenary power over immigration, overrides even these kind of free speech concerns. So I think those two things eroded the value of Lamont. And I think that the last thing is that, you know, the logic of Lamont really found the most purchase in kind of the strangest place, which is actually the rights of corporations, the First Amendment rights of corporations. So there are the cases that establish the commercial speech doctrine, the case of First National Bank versus Bellotti, they rely on this logic of, you know, it's not necessarily the corporation's speaking rights that are at issue, but rather the rights of the American public to hear things about, you know, prescription drug prices or other information. And so this logic of Lamont about the importance of information to listeners kind of gets subsumed into these, you know, kind of corporate First Amendment rights cases, and I think all of that sort of muddies the water with Lamont. But I think Lamont, a revitalized Lamont, is, as I said before, just as important now as it was during the Cold War, because if you think about what it means to be a citizen, an engaged citizen of the US and of the world, it means hearing a diversity of viewpoints, understanding what's going on in the world, and using that to inform your own advocacy and your own discussion. And it's really important to our system of free expression and really our democracy to value those rights of listeners.
Thank you. Sam, your paper also looks at the Cold War context, and it discusses Lamont, but it also discusses a number of other fights that were being had at the same time over similar concepts and ideas. The way you put it is, do Americans have a right to know about the world? So can you talk to us about your paper?
Sure. Thanks all. Thanks for having me. You know, in the early Cold War, there's actually just a kind of tapestry of border censorship policies in place in the United States. Many of them don't sort of bear the label of censorship policies, but that's what they are. You know, George has nicely talked about some of the postal regulations. Some of those are these kind of obscure regulatory, made-up laws, really, sort of stitching together Foreign Agent Registration Act and the Espionage Act to say that you can't receive propaganda from a communist country. But there are also currency control regulations to sort of prevent you from sending American currency to North Korea or Vietnam that mean you can't bring information in without a license. There are also three other sorts of border censorship policies in place that I think are really important. The first is there are a whole host of passport regulations in place in the early Cold War, which basically mean that the passport division can deny an American citizen a passport if they think that that person's travel will not be in the best interests of the United States. At the time, it's illegal to leave the country without a passport, and so that means that actually one woman is in charge of the passport division office from 1927 until 1955. She's kind of like a second J. Edgar Hoover type figure, a real conservative. She boasts, you know, one of the things I believe in is denying passports to communists. And so this means that people like W.E.B. Du Bois, Paul Robeson, a host of other radicals are grounded, kind of imprisoned in the continental United States in the early Cold War. So you can't travel overseas if you're subject to one of these censorship practices. Foreigners who want to enter are also subject to visa denial on ideological grounds. That's what happens to Mandel. I think it's important here, you know, there's a long and sort of celebrated list of individual luminaries who were denied entry to the United States during the Cold War. You know, Charlie Chaplin, Pablo Neruda, Hortensia Allende, 350 Hiroshima survivors who want to come to New York to discuss nuclear disarmament in the 1980s, and the list goes on and on. But even more important, there are thousands of people who are denied visas because they're a member of a communist party or a suspected communist party. There's a process in the law that allows you to apply for a waiver, that the Attorney General can give you a waiver to come into the country even though you're formally barred. And what that turns into is really a licensing system. And that has direct First Amendment implications, particularly for journalists working for international communist newspapers who want to come to the United States. They get a visa that says you can come in, but there are conditions attached. There's a guy that I look at, a French journalist for a communist newspaper, and one of the conditions is that while he's in the United States reporting on the United Nations meetings, he won't report anything that's, quote, un-American, is one of the sort of conditions attached to his entry visa. So there's these travel documents to come in and out of the country, and then the final form of travel restriction are what's called area restrictions, and this is rather than denying an individual a right to a travel document, the US government declares entire parts of the world sort of off limits to United States citizens writ large, and this is North Vietnam, North Korea, the Soviet bloc in the early 1950s, some of the most consequential fronts of the early Cold War. All of these practices together, I think, have serious impacts on the quality of the US public sphere and debate in the United States. They obviously are censorship mechanisms targeted at the left and have real implications for domestic civil liberties, rights of association. They also, I think, though, should be seen not just as sort of pretextual technocratic reasons to go after the left and punish them. I think they're also an effort to monopolize foreign relations on behalf of the national security branches of the US government. And one of the things I think is helpful from the historian's point of view to think about in today's discussion is that information has tended to flow across territorial borders throughout history. The development of the national border as a kind of key filtering mechanism to prevent information coming in and out is a mid-20th century invention. And in the US, it's particularly tight in the early Cold War for a variety of reasons that have to do with the law, but also have to do with the national consolidation of media companies, the closing of the US border to immigration in 1924, which is still ongoing until 1965. And so what we often think of as the kind of rise of America to world power, the kind of US becoming a global force in the 1950s, can also be seen as an era of Americans really becoming insulated in their public sphere at home, where they have less access to information from overseas for a variety of reasons. And I think this has real consequences for American foreign policy. But also thinking back to sort of Evelyn's comments earlier about some of the hydraulics at play, it's also worth thinking about the fact that the rise of the First Amendment as a judicially enforced kind of glorified right of free expression comes at the moment when there's actually less foreign ideas coming into the United States writ large, which means these particular kind of choke points around passports and visas and area restrictions take on outsized significance.
Thanks, Sam. So to start off, this right to know about the world that you sketch out in your paper, do you see that as synonymous with listeners' rights, or is it a related right? How would you describe the scope of it?
Sure. So the idea of a right to know about the world is partly something that I came up with as a way of capturing a host of the civil liberties protests against this array of border censorship protests. But it's also something that one of the key activists in my story, a radical journalist by the name of William Worthy, who is one of the sort of forgotten figures of US 20th century politics, I think. He argues at one point that what defines his work, and he gets his passport stripped for traveling to Hungary and China without a passport. He goes to Cuba without a passport, and there's a series of legal cases that come out of that. He brings classified documents home from Iran in the early 80s at a point when travel to Iran is regulated. And he's asked, why does he keep sort of getting himself in legal trouble to do foreign journalism? And he says, I believe the American people have a right to know what's being done in the world in their name. So that's his kind of framework for it. So I don't think it's actually listeners' rights straightforwardly, particularly because one of the things I develop in the paper is when we look at Lamont and we think about the way that the courts have, in reaction to this series of lawsuits and series of actions of civil disobedience pushing at the borders of these that's an unintended pun, pushing at the kind of sutures between these border censorship practices. The courts begin to recognize certain types of rights that are impinged upon by censorship of passports and visas, but they never come out and really make a claim that citizens have a right to travel overseas to gather information, that citizens have a right to receive information from abroad. They break it down into a host of kind of ancillary rights or subsidiary rights, a Fifth Amendment right to travel as a kind of right of self-fulfillment. Sometimes they talk about a right to receive information in the Lamont case, but it's really a very passive vision of citizenship, that you're just going to sit at home and consume the documents that you want, and that your right to buy things can't be interfered with. And this right to know about the world, I think, is a much more active vision of citizenship. It's a right to travel, to information, and then to use that information to advocate at home and communicate at home. And it sees the central First Amendment right not just as a passive right of listening, but as an active right of communication that involves both sort of inputs and then further outputs. And I think that would be a more productive way to imagine the right. It would open up more possibilities for challenging bad practices at the border.
Great, thank you. One thing that I wondered as I was reading this paper is sort of the right to travel in the digital age, and sort of, is there a way to tease out, Sam or George or really anyone, the importance of physically being somewhere, or of allowing a speaker to enter the US physically in an era when, in theory, you could Zoom with anyone anywhere around the world. You can see a great deal of the world without leaving home in terms of pictures and recordings and things. But it does seem to me like there's something very important about the physical ability to move in space. So how might we try to articulate that in this digital era?
Yeah, I mean, I think this is just about the difference between a conversation and the right to report, which the right to report and actually go overseas and observe what you want to observe, to move in the spaces you want to move in, to sort of more easily identify Potemkin village type scenarios, is an important right. I think Mandel, there's some discussion actually, even in the 70s, where one of the arguments that's raised in that case is, why do you need to bring this Marxist into the country? Can't you just read his writing or like bring him in on a telephone? I mean, this is actually Paul Robeson in the 50s has to perform via telephone to sort of international solidarity groups because he's not allowed to leave the country. And the court, I think, says that even the court, in turning down the First Amendment right to bring Mandela into the country, says we do acknowledge that there is a benefit to being in person in dialogue that doesn't exist just through communication. So, I mean, I think there's a host of things that would be lost. I do think that there has been a change from the early Cold War, that, the US in the 50s and 60s, speaking as a historian, is a remarkably, surprisingly insular and closed culture. It's much more open now, so that the particular valence of, more selective filters and more selective acts of censorship is maybe less important. But I think there's a value added.
Thank you. Nick, you have a lot of experience working on an issue that's closely related to this, the Foreign Agents Registration Act, or FARA, which has been mentioned earlier today as well. You've written extensively about it. You also deal with it in your work for ICNL. Can you give us a brief tour? What is FARA and what First Amendment rights are implicated by it?
Yeah, sure. So for those of you who don't know, I work at ICNL, and we work in the US and around the world to create a protective legal environment for activists, for nonprofits, for social movements, and I manage the US program. And in recent years, we've seen an increasingly significant impact on nonprofits with the Foreign Agent Registration Act and an increasing chilling effect. So I started working on comprehensive FARA reform maybe about 7 years ago. And at that time, I'd say most nonprofits just really didn't know what FARA was. And then when it started impacting the nonprofit community, it was generally more like large international environmental groups. But in the last year or two, I'm talking regularly to grassroots activists, to funders, to nonprofits from a really kind of diverse range of groups who are being impacted by this act, the Foreign Agent Registration Act. And I think to understand why, a little bit of background is helpful. So, this is also a World War II era statute that was designed to target Nazi propaganda. It was billed as a transparency statute. So essentially, if you engage in certain covered activities, including very broadly defined political activities on behalf of a foreign principal, you need to register with the US government. But we shouldn't kid ourselves, right? This is a criminal statute, has notoriously broad and vague provisions about who needs to register, and it was used in a discretionary manner in the war to shut down Nazi propaganda. And it did that through stigmatization, red tape, there's a really kind of burdensome reporting requirements, investigation and prosecution. And at the time, you know, the act was justified, I think, on this kind of Walter Lippmann notion of the dangers of propaganda. And I would say, you know, this is kind of the strongest justification you hear for acts like FARA in the US and in other countries, which is this kind of self-governance one that we've been hearing today, that there's these outside actors that are trying to undermine our democracy. We need the government to step in and protect the US public and have interventions so that the public can navigate this. But I'd argue that, you know, when you look at FARA in its totality, you know, it's really kind of undermined the self-governance we need and the civil society we need to have self-governance. And we see this really early, actually, in the Act's history. So during the McCarthy era, FARA was used to prosecute W.E.B. Du Bois for circulating an anti-nuclear war petition at the request of a French nonprofit. He was ultimately acquitted. Question whether he should have been actually under the text of the act and how broad it is. But his reputation never recovered in his lifetime. After that, the act went into a period of kind of hibernation where it was mostly used to go after kind of lobbying by foreign governments. And even then, most people think that it wasn't enforced very strongly. And then 2016 happens, right? And we have a whole new era of FARA. And you know, there's these concerns about Russian and Chinese interference in the election. And the Justice Department's looking around for tools to go after foreign interference, and FARA becomes one of the primary tools. So it's used to go after RTTV, Russian and Chinese media outlets, to prosecute key members of Trump's inner circle on lobbying for foreign governments. It's been used to go after Russian disinformation campaigns and a lot more. But it also emerges in a much more kind of politicized environment, right? And so we see a lot of confusion across civil society, right, about how this act might be used against them. So right now, there are multiple congressional investigations against nonprofits for violation of FARA. Particularly targeted are environmental groups and pro-Palestinian groups, but there's others as well. You get these confusing enforcement actions out of the Justice Department, so they issue these advisory opinions. I'll just kind of name two to give you a sense of how they're viewing the act. So for example, they told a church in Pennsylvania that they needed to register in the act under FARA because foreign congregants were coming in from France. They had requested that they print out signs for a March for a Life rally, and they said that's registrable activity under the act, right? They've also said that if you're receiving foreign funding as a nonprofit, they have a very confusing three-part test that I don't think anybody understands about whether you need to register under the act or not. And so as a result, the nonprofit community is scrambling to really understand how to navigate this act. You know, and so I'll leave it at that, just on that part of the question. But it's having this kind of chilling effect that we're seeing play out, and I can add many more examples that are happening right now.
Yeah, no, that would be great. I'd like to hear more about. You know, you've mentioned in some of your writing the impact that this has on the right to association, and I think it's interesting to dig in on that because often when we're talking about the First Amendment, there's a tendency to shove everything into the free speech bucket, but associational rights are also very important and distinct. So can you talk a little bit about how those are implicated here?
Yeah, sure. And I think this is important also when you're kind of like thinking about reform, and I can go into kind of what we might want to think about in this space going forward and how other countries have adopted as well. And when we've talked about reform and think about how do you think about FARA or similar acts in other countries, we think about a rights-based approach. And very much this is, you know, being able to hear information from the rest of the world. So a right to information from abroad, that's really important. But it's also the right to partner with people abroad, right? It's the right to act in coordination with people abroad. It's the right to exchange resources, including financial resources, with people abroad, right? And I think sometimes the way that speech rights get played out, it's a very kind of thin sense of our political culture, where I think associational rights and these cross-border associational rights, I think, are really important to understand. And even in that, though, I would kind of flag this, and this case came up earlier, that even when the rights are properly identified, right, they still need to be weighed appropriately by the courts. And we've seen this, for example, with Miss Viking, right, which was a case about FARA that was mentioned earlier today, where the court, in a divided 5-3 decision, said at the time there was a requirement, there's a, to put on all covered materials, that it's quote unquote propaganda, right? So a very kind of stigmatizing label. And that has to go out on all such covered material. And the court, I think, quite implausibly said, that's not chilling, right? That's not a burden on speech. And you see, so not being able to kind of take into account what actually is a burden. And I think other courts in other parts of the world have had problems with this, but the European courts have done it much better. And I'm happy to talk about that as well.
Great, thank you. Chinmay, your paper brings these debates into a more current context. It's called Losing TikTok. Do you want to present that for us, please?
Yeah, I just, thank you. So parts of what I'm going to say almost pull threads from what speakers have said through the day, and I've been delighted to hear it and to be educated by it. So there are two elements to my paper. The first is basically about the Chinese apps and the alarms raised about them. I called it accessing Ernie Bot's avatar initially, and then I realized that not everyone knows about Baidu's little chatbot, and I felt like losing TikTok is more contemporary. I'm going to keep the part about the Chinese app alarm short because I think that many people have discussed it today. And the second thing that I'm trying to do with the paper is basically draw on the idea of listeners' rights. I love Right to Know the World. I will cite you. Mine is the digital version of it, where I'm saying that the way these apps are constructed, it's very rare for anyone to be a passive listener. If you're on TikTok or if you're on a social media app, you're liking things, you're choosing to read or watch one thing for longer than another. And often you're choosing to share and remake things, which means that the passive listener of the 60s is now potentially an end user, or some version of someone trying to know the world digitally, which doesn't substitute for what Sam was trying to say. And so that's kind of the positive agenda of my paper. And so very quickly, I just wanted to go over, if anyone's interested in the TikTok ban, Anupam Chandar has written 2 marvelous papers, one solo authored and one with Paul Schwartz, that traces how it happened from former President Trump's initial choosing to ban it right up to the foreign adversaries. I'm also very sleep deprived currently, so I hope you'll forgive my poor choice of words now and then. And so the legislation that the Foreign Adversary Controlled Applications Act, which is what TikTok is arguing against right now. The 2 concerns which I think have come up today have been data collection and manipulation. And I agree 100% with Evelyn. I am also a foreigner, but also someone that studies social media platforms. It is not clear to me why regulating these 2 things by targeting Chinese apps in particular is a better way to do it than to regulate all apps that engage in this. I, in fact, before moving on to this, want to say that it is potentially detrimental because creating the possibility for the executive to remove the Chinese apps from the American information ecosystem leaves the ecosystem in the hands of 2 or 3 companies, and that creates a very different kind of problem of public discourse. And so that's worth considering and weighing against the problem of manipulation and considering whether people are actually going to start believing things that they see on TikTok about Hong Kong, or whether they'll see them but it won't resonate with them because they are in this context watching American news, getting information from other sources. So that's me briefly about the TikTok ban. Moving on to the question of the listener, I'm very grateful to be a part of this symposium and a part of this panel in particular as I think through what Lamont means online. And I'm borrowing here partly from Jack Balkin's theory of what cultural democracy means, which is that there is the right to access information, and several scholars like Robert Post have suggested that there is a political element to this information that is important for Americans as citizens. But as Catherine so powerfully illustrated in her lunchtime talk today with her cute cat example, it's actually very difficult to separate cultural content from political content, and the way in which people mix the two and grow from them and get values from them are intermingled to a degree to which it's not possible to say that political speech is political speech and cultural speech is cultural speech. And so I'm currently playing with this idea for my paper for the symposium, where I'm also thinking through what that means online. And so the example that I started thinking through, and I'll welcome anything that you have to add to it, is the Korean band BTS, which this generation that uses TikTok is also very into BTS. If you have any friends under 30, nephews or nieces, you know this band. It was interesting to me because I was looking up BTS and just to check what their TikTok presence was, and I discovered that when Black Lives Matter was raging, BTS felt that it resonated with their values. And it's interesting because BTS Army, which is what their fans are called, they love BTS not just for the music, but also for their values, which are anti-bullying and anti-discrimination. And so BTS gave $1 million to Black Lives Matters, encouraging the BTS Army in the US to raise $1 million for Black Lives Matters. And that is political, but it came from a group that was formed for cultural reasons. And it is a foreign group that stands for certain values, and these are values that American citizens may choose as their own, and values that may matter over here. I felt like it was a really powerful example of the way in which the younger generation forms associations and develops as individuals and also as collectives. Sam, I love that part of your paper where you flagged that listeners' rights have unfortunately been developed entirely as individual rights, and there is actually a collective element to them that is really powerful. And I think that that collective element is really big if you think about how online discourse works and how people under 30 engage with each other, often primarily on online platforms, but often forming social groups and alliances in ways that weren't possible earlier, but are possible for all the young people of the world. And it seems a great shame to me to take that away from young Americans. That's it from me.
Thank you. I'm wondering if you can elaborate a bit about a distinction you draw in the paper that you mentioned briefly here, but between understanding people as listeners versus understanding them as end users. If you could talk a little bit more about what that distinction is and what implications you think it has for the way we look at First Amendment rights of online people.
Thank you. So understanding them as end users recognizes that they are not passive consumers of content, and even if you, so in TikTok particular, which I'll confess I'm not on, and so I think the best I know of TikTok is things that I've been shown, but also Meta has a competitor called Instagram Reels, which is similar, and I've used that. Even if all you were doing, if you committed to not liking or sharing or reposting a single video, and most people don't engage that way, you would still be training the algorithm. You would be doing something merely by the watching of something because the algorithm learns you. And I think that I'm not even the demographic of young, I'm not yet quite young enough to be a classic TikTok user, but even I trained the algorithm a little bit to show me things I wanted to show me. And that is minimal. The way the younger generation uses this is to signal, to find friends, to pick up a little song from one place, to combine it with a little video from a different place, to add commentary. And several of my former students are online. They do it to constantly signal things that they believe in, groups that they're a part of. And I think that that is the modern listener. They're not receiving the Peking Review and reading it and then hoping that they'll write a thing about it and it'll get published in a journal maybe next year. They're taking 3 seconds and they're making it their own. And in the process, they're changing maybe a little bit who they are. They're maybe becoming a part of a new circle, and maybe they're transmitting a value system or asking a question that's useful for someone else to consider.
I appreciated that framing as well because it evokes the idea of a constant ongoing conversation or dialogue, which is closer to the way we think about public discourse than just a listener, one-way listener relationship. So going back to something you said about distinctions or the inability really to distinguish between cultural content and political content, I'm just wondering, Sam or George or really anyone, are there any examples we can look to of the way courts or governments have considered this in the past? Like, there is this concept of core political speech that the courts are purportedly very concerned with. But in terms of cultural exchange and its value, do we know very much about the way the law has looked at this?
Well, I think there has been a long recognition in law that, despite the fact that we often refer to it as quote-unquote core political speech, that, the arc of the law has gone more in the direction that Chinmay has suggested, that what is political, what does political mean in a democracy, right? If a democracy is a government of people, then political is all the things that make us as people, and that means talking about the election, but it also means talking about pop culture and what's in magazines and what's on social media and all of that. And I think there's a broad recognition, maybe not in the language of court doctrine, but I think in the principles that are represented by the First Amendment, that political really does encompass this cultural, and that all the things that make us make meaning for us as citizens are more than just kind of how we vote and the things that contribute to our voting.
Anyone else?
I mean, it's maybe slightly tangential. I mean, I sort of two slightly tangential points, I guess. The first would be, it does feel like starting in about the 1930s, there's a real focus on cultural politics and the sort of the meaning-making of culture as a central front of sort of democratic politics, and struggles over things like the music and the movies and the political symbolism that's tied in some central way to, I think, a project of national consolidation, that there is an American culture, and it, that then breaks down in the 70s with a more sort of globalized culture. One of the key things that the New Left was active around was trying to kind of globalize the American imaginary and reconnect with sort of global decolonization movements and think more expansively about world citizenship, not just in politics, but in sort of the whole range of life. The other question that I hear you asking is like, would there be any benefit in trying to distinguish between sort of more core First Amendment activity and these sort of more peripheral ones? And that came up in my paper in a place that I thought was interesting to think through, which was one of the reasons that courts are dismissive of claims of, say, a right to travel is because the court doesn't want to create a hierarchy of sort of First Amendment actors and say some people get the right to travel, but other people don't. And that would mean that if you want to say you have a right to travel, then it's impossible to regulate in the field at all, because anyone who wants to go on a holiday to Cuba will then just go on a holiday to Cuba, and you can no longer say it might not be good for Americans to go to. Whether or not you believe there's a risk to going to Cuba or whatnot, if a government decides they want to regulate, if you're going to say all travel is equal and it all has First Amendment implications, well, then you're not going to be able to regulate at all. And actually, the case upholding the area restrictions on Cuba is a 1965 case, and Earl Warren in the majority says, we need to be able to do these kind of regulations, and they do interfere with the free flow of information. But if that was enough to strike down a government regulation as unconstitutional, well, then every type of government regulation could decrease data flow in some sense, and you'd have no governance left. And given what's happened over the last 40 years, that's not a bad reading of the kind of weaponization of the First Amendment before it's even happened. My argument, though, is that in all of these travel cases, there are in practice carve-outs where the government will say, we're not going to let you travel to communist China, but we will let journalists going for kind of journalistic activity travel. And they've had a pretty political definition of what journalist activity is, and that it would be helpful to know more about how those classifications have worked, but they have existed. And so while there's a lot of anxiety in First Amendment law about saying we're going to protect journalism and political activity and not other types of speech activity, in practice, in these kind of border cases, it's been happening. And I don't know whether it's been a good thing or a bad thing, but we shouldn't pretend like it hasn't been happening already.
Yeah, and I'll follow up with this in the context of FARA, because it's interesting FARA directly addresses this, where the Act makes an exemption for bona fide religious, scholastic, academic, and fine arts activities. And it's interesting, what is bona fide? The Justice Department has interpreted this to mean non-political, right? So question, what is non-political art? What is non-political academic activity, right? And actually, I think groups, including probably those here at Columbia, are now paying more attention to this because there's been accusations of FARA violations of student groups on campuses. And the Act is impossibly broad. I should really make this clear, right? So a foreign principle under the Act makes no distinction between the government of Saudi Arabia and your grandmother in Canada. Treats both the same, right? Agency relationship, when are you acting as an agent? It's not just direction and control. It's if you're acting at the request, right? That's what the Du Bois example was. That was the printing of the sign at the request of a foreigner, right? Justice Department has expanded that recently and said it's if you're acting in coordination, right? You don't even need request anymore, right? So we're broadening out even further. And the covered activities are not just political activities, which it defines as attempting to influence US public opinion on any domestic or foreign policy issue. Exactly what we're doing here today, by the way, right? So this would clearly be kind of covered as political activities under the Act. But it has a whole range of other, soliciting or distributing anything of value, right? And so as a result, the exemptions become really important. There's an exemption for commercial activity. Otherwise, all transnational trade would probably be covered under the Act, right? And so it's really interesting when it's looking at, okay, what do we want to basically be able to cast in this net so that we can use discretionary enforcement to go after activity we don't like, which is exactly what they were trying to do in World War II, which is exactly what they were trying to do in the McCarthy era, and arguably what they're trying to do today. When I talk to legislators on the Hill, well, they're like, we don't need to reform FARA because it's used in a discretionary manner, right, against people we know we want it to be used against, right? That's the way the Act is used today, right, 2024. And so, but it's not the fine arts, it's not Amnesty International, right? It's not the symphony orchestra, right? That's not what we're really trying to capture here. But if there's controversial speech, okay. And we're seeing in our political environment now how that plays out.
Great, thank you. So I want to turn to TikTok and to the TikTok ban. We've talked about this earlier today, so I'm going to try to approach it a little differently. I'll start out by saying that at least on the reading of Lamont and associated cases that we've heard here, there are some very strong arguments that the First Amendment would not allow a complete ban on a platform like TikTok. There are also arguments often made in the national security side of the equation that, yes, the First Amendment presents a high bar to government regulation, but in this case it is met. This is a severe national security threat. This is a foreign-owned platform that we know to run influence operations. And so, at times it seems that the two sides in this debate each think the other is just completely mad for their position. Like, how can you possibly want to ban an entire communications platform? How can you possibly not ban this platform in particular? So I'm thinking, how should First Amendment advocates respond to these arguments? And in particular, I'm remembering something that came up in a conversation I once had with a staffer on Capitol Hill who was like, you First Amendment people love to tell us what we can't do, but it would be really great if you could tell us what we can do. So I'm going to ask you to just offer your thoughts, that either more broadly for why we should continue to allow access to TikTok, but also like, what regulations do you like? What do you think would be compatible with the First Amendment and be effective at achieving mitigation of the harms that we're worried about?
Okay, firstly, if I can start with getting very abstract about this, because I did a deep dive into how people think about risk in my previous paper. It's interesting to me because I was looking for good reasons in whatever unredacted material has been shared to argue that you should ban TikTok. You have to see what the counterpoint is. And honestly, I found nothing beyond it is possible that someday the Chinese government may weaponize this app to manipulate the American people, and it's best not to let it get there. which to me is basically risk thinking, that there is a set of people who are hyper-focused on the idea that this might happen, and because those particular people wield enough power to sort of flag that as a risk that we should all render salient, they've decided that that is the risk, and it is a bigger risk. It basically eclipses the threat to foreign discourse, the threat to public discourse, which they're not focusing on at all, right? And so this is Dan Kahan's cultural cognition theory, is that when people are making decisions about the law, it is influenced by what they see as salient. So I think that that's partly what's going on. But if I were to respond to them, I would say that there has to be, it's important to establish a threshold of proof. At what stage do you say that this is categorically harmful? How do you identify when something is risky enough to compromise public discourse? I just feel that they haven't engaged with it. I don't know if that's the answer you were looking for.
So I guess where I'll start is to say, is to acknowledge that there are real concerns about TikTok's data collection and data privacy practices, as there are with many or most of the online platforms that we use on a day-to-day basis. And the way to address concerns like that are not to ban an entire platform, but to pass comprehensive privacy legislation. I also want to acknowledge that there are potentially real concerns with foreign actors manipulating US citizens, as again there are with domestic platforms and others who are seeking to manipulate US citizens. Well, I think the question is who gets to decide what is too dangerous for American citizens to consume, and should it be the government? And as an illustration with Lamont, the Peking review issue I took a look at it, and it includes things like a letter from the Communist Party of the USSR to the Communist Party of China expressing its values. It includes tips on farming and irrigation. It includes critiques of US imperialism and capitalism, which, if that counts as communist political propaganda, I think much of our symposium today probably also counts as communist political propaganda. And the question is, does the government get to decide what Americans hear of that? And with TikTok in particular, I guess why I think a listener's rights perspective is particularly useful here is that it focuses us in on the key interests at stake, right? So the key interest at stake with a TikTok ban is not the interest of ByteDance or the Chinese government to speak. It's not even necessarily of TikTok US, the platform to speak, but the key interests at stake are those of TikTok's users, and I think this listener's rights perspective really helps us hone in on what the real sort of free speech and First Amendment stakes are in this.
Nick?
Yeah, sure. I'll come at this again from a fair angle, since that's why I'm here. But last year, House Oversight Committee said they would start exercising oversight over enforcement of FARA, and two of the examples that they used about why they needed to exercise enforcement was because TikTok had not registered yet as a foreign agent, and the Justice Department had not required them, and Al Jazeera had not, right? Those were the two examples that were being used. And I think what we see often with this concern about foreign influence, and this isn't just in the US, like we work around the world on these foreign influence registration laws that have popped up, often modeled on FARA in the United States, is there's genuine legitimate concerns about foreign influence. And legislators say, we have to do something, this is something, right? It's the old legislative adage, I think it came from like, yes, Prime Minister, right? We have to do something, this is something, right? Here's a bill, it will ban TikTok, here's FARA, let's enforce it against this, let's create a FARA-like law in our country to combat. And I'd say, I think, as you're suggesting, we need a much more kind of problem-oriented approach, right? We've heard about transnational repression. What are the tools we can use to combat transnational repression? In Australia, for example, one of the concerns was about foreign influence in universities. They enacted a foreign influence transparency scheme there, and it really didn't have an effect, right, on pushing back on like concerning kinds of foreign influence they were concerned about, particularly with China. But universities came together and created a risk-based approach, right, on the risks they were seeing, implemented that through guidelines that were enforced. across universities, and that had much better of effect, right? And I think it's about having these kinds of targeted solutions that are responsive and proportionate to the actual problem. And unfortunately, I think as soon as you bring up porn, right, it triggers something in this deep part of the mind of like, oh, we got to do something. Like, this is scary. Something scary is happening. We have to do something. This is something. And I hate to like boil it so simply, but I think in legislators' minds, often that's what's going on.
Can I add a tiny thing to that? I don't know if you noticed that this legislation, it uses the term foreign adversary for a set of states that were previously described as non-allied nations, I think in part to trigger the thing you were talking about.
Okay, we have a question at the mic, I think, and then I'm going to bring in a few from the online QR code.
I have a question about something that I haven't heard discussed at all, and this is the asymmetry that is inherent in discourse with people like from China or Iran, or it was mentioned before in the previous panel from Lebanon, which I presume meant that they've invited members of Hezbollah. And the asymmetry is this, that here in America, if you change your mind, if a Chinese participant convinces you that communism is this great thing, and I now go around and say, oh, communism is wonderful. Now, I'm not going to do it because I'm an ex-Soviet and I am completely immune to that. You know, it was inoculated there. But for the sake of the argument, nothing's going to happen to me. But the Chinese professor or whoever, he cannot get convinced that communism is a pile of garbage, because if he gets convinced and goes in China and says, oh, you know what, whatever President Xi says is garbage, you know, we've got to do it completely different, he's going to wind up in prison at best. And, you know, there are countries where apostasy is a capital offense. I think Pakistan is one of them. And so we have a situation where the opponents are pushing their way of thinking on us, but there is no way for us to push back and to convince them. So it's not an honest conversation. And conversation, again, is about changing the opposite person's mind, and this becomes impossible. And I'm just curious whether that dynamic is being discussed and is being the part of government's rationale or anybody's rationale, because what I'm hearing is, you know, we are supposed to hear and absorb, but we're not supposed to push back and say, you know, what you're saying is really a pile of garbage and you should really change your ways and your mind.
So I think you have illustrated really well this point that when a government declares ideas as sort of unpatriotic and dangerous, these are tactics that we ordinarily associate with authoritarian regimes and not with democracies. And so when the US engages in similar kinds of behavior, it not only looks hypocritical, as I think Anna mentioned on a panel earlier, it really erodes the US's ability to make these points on a more global stage. And a way to illustrate this is, you know, in the Lamont context with communist mail restrictions, that earlier administrative program that was ended by President Kennedy in '61, it was ended in part because he received this report from a committee of the National Security Council, and it said, well, our efforts to intercept and detain communist mail, there's actually no indication that there's any national security benefit that we're gaining from this. And in fact, there are potentially national security risks because of all the work that we're trying to do, talking about the free flow of ideas globally, and that it seems awfully bad to have a program at home that is entirely intended to restrict foreign ideas from coming in when we're trying to make the exact opposite point abroad. And so I think, you know, when the US tries to mirror those tactics, that's when we should really be most critical of our government. And I think, you know, that's what you have with something like the TikTok ban as well.
Go ahead. Okay.
I'll just add another historical example of this, that there is an instrumental argument for the US to live up to its own ideology around exchange of free ideas, and that's not just sort of rhetoric, that if you really believe in it, then the consequence should be that we trust that our ideas will win out in this exchange, even if there is any kind of pushback at the other end. And so you want to maximize the channels for exposure. And one of the places you can see the US defensiveness around something like an ideological agent coming into the US really having consequences was in 1948, there was a Freedom of Information Conference at the United Nations. One of the things that it produced was the text of Article 19 of the Declaration of Human Rights, from which we got the title, Regardless of Frontiers. It's the only conference of the early United Nations on a particular substantive issue. The signature US policy at that conference was going to be a binding multilateral treaty to allow for the free movement of journalists across national borders in the 1940s. And this is what they sort of take to the United Nations, and they want to get it signed onto. And there's some support for it. It was going to be an uphill battle. But then the Soviet bloc says, you say that though it will exempt any national laws about excluding journalists for national security grounds. What they were saying was, the US is not going to let communist journalists in. Why should we all sign up to this to let American journalists freely report from our country? And so you only actually get that kind of exchange agreement with the Helsinki Accords of '77, right, which then leads to kind of more exchange, which plays a role in helping the fall of the Soviet bloc. And in '94, when Congress passes the Free Trade in Ideas Act to try to close down a lot of these regulations, the argument is made that where we've done exchanges, we now no longer face communist adversaries. Where we have left them in place, particularly Cuba and Iran, those regimes have not toppled. So if what we really want to do is kind of spread the American way of life and liberal democracy, there's an instrumental reason for actually allowing exchange, not just a kind of idealistic one.
Yeah, so following up on this point, many thoughts, so appreciate it. I'll first pick up on this, which is, one of our publications that gets most read at our organization is this publication called Pharaoh's Double Life Abroad. And it's because all these authoritarian governments have picked up on FARA. I think this has been the most devastating impact of FARA for the cause of democracy globally. This has included Russia, Hungary, Kyrgyzstan, Nicaragua, Georgia, right? Other places, and said, well, you have the Foreign Agent Registration Act. We're going to enact this. And they do, and you can't say anything, right? Because you have this law. And then we're gonna go after, and we're gonna shut down civil society. All the voices we don't like, anybody, right? We're gonna shut them down using this. And as I said, it's a really expansive act, right? You can imagine how this could happen. So there's those countries. And then there's the kind of more established democracies that have all enacted these in recent years, or many of them have. And there's a big debate in the EU about this right now, but France, the UK, Canada, and Australia have all in the last 3 or 4 years enacted a much narrower version of FARA. And the big debate amongst the democracies, including in the US now, is this question you're bringing up, right? Should this just, we're not really worried about interactions between the UK and the US, or Canada and the US. So should we set this up and just have it be targeting China and just be targeting Russia? So the UK had theirs apply to everyone, but they create this enhanced category that the government can choose certain countries of concern to put in that enhanced category, and there'll then be more registration requirements. Canada was just debating that. They rejected it. Partly out of concerns about the model for the world, partly because of concerns about like stigmatization that will have for like the Chinese Canadian community. There'll be like good Chinese Canadians and bad Chinese Canadians, right? And what are the implications for that? Also, all the politics of choosing, like we'd put China in it, but would they put India? Like India just killed somebody in Canada. Seems like they should put India in that category, but there's like a lot of geopolitical reasons about whether you put that country in the category or not. So they ultimately rejected it, but on the Hill in Congress, a lot of the FARA proposals right now for amendments of changing it are creating countries of concern that explicitly list out Russia, China, and Iran, right, to have different registration requirements that are there. And I think this is a real issue that the civil liberties community is going to have to grapple with, right? Because it's very popular globally. Australia is re-looking at their act with this in mind, right? And so I think we're going to have to think about it because it's coming, and what's the response to that, right?
I could not agree more. It's interesting to me because to go back to what George said in the beginning, the nature of a democracy is to prioritize what its citizens want and their ability to participate fully. And for that, they need access to all information. And it's sort of, it's partly that, but it's also partly that when citizens are told that they will be deprived of access to information, they feel disrespected. And that's part of like the sociological legitimacy of a democracy. I can say that because I'm from a different eroding democracy. India is contemplating banning Wikipedia because they want the High Court wants Wikipedia to remove a page. And it illustrates the point here that if the US were to make laws like this, it would make it easier for other countries to say that we're banning Wikipedia. That's a part of it. But the second is that you can't claim to be a democracy and then use reasons like foreign policy. So we're more concerned about competing with the Chinese than we are with respecting our own citizens in a democracy. I think that that's a difficult argument to make.
Great answers, thank you. One thing that struck me, particularly in the historical papers, is this sort of recurring back and forth between some really good, really strong, I think, inspiring rhetoric that Americans can take it. They can face these ideas that do not comport with our way of life, and they can make their own decisions and see why ours is better. Coupled with this really deep-seated fear, like, what if that's not true? And I think, if anything, that's only gotten worse over the years in terms of the way our appeals to the marketplace of ideas, coupled with our clear doubt that the marketplace of ideas is actually going to function for us here. Okay, so I'm going to try to take a couple of the questions that came in online. One question is, if the TikTok ban takes effect, how long would it take for it to be struck down on First Amendment grounds? Would that be immediate? So first of all, I love your optimism. I'm wondering if anyone, so I should back up and just say, for those of you who aren't familiar with this, this is a law that was passed by Congress and signed by Joe Biden requiring TikTok to divest from its parent company, which is ByteDance, based in China, within, I think they gave them a year or 9 months, or be banned in the United States. So would anyone like to talk to the way courts have looked at restrictions on TikTok so far, or how we think they would should this ban come into effect?
Sure, I guess I can speak to this a little bit. I mean, so I'm also very interested in hearing the answer to this question. Both interested to hear when it's going to get struck down on First Amendment grounds, and also when it's going to happen. So there is currently litigation going on in the DC Circuit on the federal ban, which oral argument was last month, I think, early last month. They granted expedited review, so I think we should really be expecting a decision any time now, and I didn't bring my phone with me, so I imagine if there was a decision, people in this room would have gotten up and left, so I think we're safe there. But we should be expecting that anytime soon, and I think in all likelihood, whatever the DC Circuit decides, I'm terrible at reading the tea leaves when it comes to courts, but I think it's very likely that the Supreme Court will review it. There's also litigation in the Ninth Circuit regarding Montana's ban. But I think it is I guess one important note here is that there has only been one federal court to have addressed these broad TikTok bans, and that is the district court on the Montana ban, and the district court there concluded that there were serious First Amendment problems, and I think we should take that seriously, right? Again, who knows what's going to happen at the DC Circuit or any other place, but I think we should take seriously that the first court to really consider these issues saw these problems.
Anyone else? Maybe? Okay.
No, I mean, I do want to say that the WeChat case had an outcome that makes me optimistic, which is that ban was struck down, but this is different, and I want to leave it to people who are actual lawyers in the US.
Okay, so I think this will probably be our last question. I'm going to combine something that someone submitted online and a question of my own, which is, does it matter, should it matter, that a listener knows who is speaking to them? There is, on the one hand, a long tradition of protection for anonymous speech in the United States under the First Amendment. On the other hand, a lot of the concerns that are being raised about platforms like TikTok and about online disinformation campaigns more broadly is that you don't know who is behind them, that the average listener, recipient, or end user is not aware of who is actually the speaker or who designed that content. How should we think about that? Is there a way to address those concerns without infringing on First Amendment rights?
I can outline, so again, with the caveat that I don't use TikTok. So back when misinformation was sort of the key problem that everyone was thinking of, Martha Minow wrote a piece saying that if there are foreign actors spreading any kind of electoral information, then people have a right to know. I wouldn't say that so I'm on the fence about it. I think that if we accept that we exist as listeners in a marketplace of ideas, and the model that we're working on is that we evaluate ideas and accept the one that we consider best, then that wouldn't work. But I do want to acknowledge that actually the way it does work is that we trust some groups of people more than we trust other groups of people. And so I would be concerned if a group was masquerading as a different group that you might trust. I think that that is cause for concern, and I think that that is why platforms like Facebook make an attempt to try and filter out coordinated efforts to manipulate communication. But I think that's very different from one-off efforts. That's very different from an anonymous account saying Black Lives Matter, if that makes sense. Not fully formed, I'm still thinking it through.
This is tangential, but can go in. But I think another way of thinking about this is also about what kind of speech, obviously. And I think one useful rubric is kind of thinking about what is this kind of core political speech and core like democratic decision making around electioneering, around lobbying, right? Where we will accept a higher level of transparency, which is a different kind of surveillance, right? Like if you think about it in certain kinds of interactions. Because we want to be able to like see where this is coming from, who's talking to our legislators, who's testifying before Congress, right? You have to disclose all sorts of things if you testify before Congress, versus the public square, right? And I think we just need to keep coming back to those distinctions because unfortunately what we've seen in things like FARA, right, is using the same regulatory tool for both, which I think is madness. Right? I think a lot of people think of FARA as a transparency tool for like lobbyists of foreign governments. It actually might be an okay tool for that, right? It's not a good tool for the public square, right? It's a terrible tool for that. And so I think we have to keep on going back. What's the problem we're trying to orient? What's the rights at stake? How are we weighing that? So that's my 2 cents there.
So I think the only thing I'll add quickly to this is, I think these ideas have kind of, I think each of us on this panel have expressed some version of this, but I think one way to think about listeners' rights is as a structural right? That it's not, about listening to any particular piece of speech or information, but that it's protecting our ability to access, the structure of communication that informs our ideas about how to participate in our democracy and with one another. And I think thinking about listeners' rights in this structural way, breathes a little bit more meaning into what it means to be a listener and also what the First Amendment means. And I think that's especially true in the digital age where, there's information all over the place and it comes from all sorts of different sources. And I think there's real, reason to think that as we are in the digital age, we should be thinking about these listeners' rights in this more structural way and also maybe a more cosmopolitan way.
Great. Well, we have reached the close of this panel as well as the close of this event. So I want to thank all of our panelists, both up here and all of the speakers throughout the day. The conversations were really fantastic. And thank you to the audience for being here and for watching online. I hope we gave you something new to think about. I hope you'll sign up for our newsletter. We'd love to see you at a future event. Have a good afternoon, everyone.